Good morning, everybody. Welcome back. Did you guys have a good long weekend? Of all the things that we have to not like about Judge Cannoni, I got to tell you, the holiday schedule, not one of them. Not one of them. Bev, you're the real MVP girl. We just really appreciate that long holiday weekend, first weekend of summer, right? Isn't that what they say? Although it's kind of weird. It's kind of weird this year because Memorial Day is the beginning of summer, but we still have this whole week of May left, which is just different. It's not what I'm used to. I feel so uncomfortable about about being all ready for summer this early into May. Well, I hope everybody took some downtime, some time to just decompress, think about other things. I will admit it did cross my mind. Are we going to come back on Tuesday and have a whole stack of things that got filed over the weekend? Honestly, I really hope the attorneys took a long weekend off too for themselves. Rest is really important, guys. Rest is recovery. It's where most of your progress is made. But mostly who I think about during the time off, I definitely think about the jury. I think about the jury. And for all this time, they've had to focus on this case, give it so much of their attention. They've tried so diligently to keep track. They're taking the notes, but it's a lot, guys. It's a lot to follow. So one of the things I did while we were gone, enjoying some time off, took Grandma to the cemetery to go visit the family graves. Played some pickleball, did some boxing, some stuff outside. I mean, just a great long weekend, guys. Sure does feel early right now, too. But one of the things I did is I went back and went through all my notes. Just been kind of trying to organize things, sort things out. Been kind of putting together a little bit of a recap that I'll probably put up on Substack when I get ready. But boy, this is what reminds me, like, it's halfway through the trial, still waiting for the Commonwealth to close. And it's like so much has happened and yet so little all at the same time. I was looking back and it's just hard to remember some of this stuff. Like Carrie Roberts, guys, Carrie Roberts, she was a day one. It was a day one. Way back when we heard from Carrie Roberts. So much has happened. So much has happened since the early days of this trial. We started that first week with pretty much all first responders. We had Daniel Whitley. We had Timothy Nuttall. We had a little bit of Guarino, that Guarino shuffle coming in, going out. Jason Becker. We heard from Jason Becker. Guy, who remembers? Do you guys remember Jason Becker and what he had to say? Do you think the jury is sitting there going, gosh, remember back on day 4 when we heard from Jason Becker? No, they're not. They're not, because the only thing that Jason Becker was put on the stand to testify about was sectioning Karen. And she made a comment about how she was sad and upset because the last words with John had been a fight. Way back on day 4. Does that seem sitting here right now like that matters? Really stuck with the jury. They're like double underlined in their notes, Jason Becker. No, I don't think they are. I really don't. And that's one of the maybe downsides about the kind of bait and switch strategy that Hank took with his opening, where he promised us in opening a case that was going to be about fact, science, and data. And then we didn't hear anything at all about fact, science, or data for quite some time. quite a number of witnesses. We heard a lot of I hit him, I hit him, I hit him. And that was always supposed to be the backup, according to him. But, he went through a whole first week, pretty much all just about I hit him, I hit him, I hit him. Day 5, it was all the way back on day 5 when we had Ian Whiffen come in and testify. And we started to get the Haas long, and then we learned more stuff about John's phone. Things that we didn't know about last trial, the pocket state. The pocket state was new. We didn't know that at the last trial, but the phone will actually sense if it's in a pocket or if it's there's a face nearby. How crazy is that? I had no idea that Apple phones do all these amazing things. That voir dire of the Ark witnesses, guys, that feels like a million years ago. Jury didn't get to participate in that, but that was all the way back on day 5. Hank was up there being rude, accusing him of basically being underhanded, Heidi liars, and then coming back like within hours to complain about cross-examining Jessica Hyde about being ruled unreliable in another court would be dehumanizing. It would be dehumanizing after you sat there and sneered at Dr. Wolf. The freezer. Remember Ian Whiffen talking about putting the phone in the freezer? There's like so many gems. I take a little trip down memory lane with this trial. There have been so many little gems that I forgot about. Forgot all about that phone. It could be in the freezer, and it would also drop temperature. I don't recall that he really proved anything more substantial than that. But guys, if you put the phone in the freezer, it probably will show a drop in the battery temperature. Think about that. I wonder if that's set with the jury all this time. Then we got into Jen McCabe. Oh, that epic, like 2.5 days of Jen McCabe, the cross that was stumbling and then came back and absolutely dominated that cross. The little do you deny it Jen just didn't quite know how to deal with. That new information from her about the lying to the FBI. Didn't know about that last time. Didn't know about that last time. Ryan Nagel, Heather Maxson, and Sarah Levinson, they were all kind of tucked away in there on day 9. Day 9. Let's tuck them in there because they didn't see anybody in the car. They didn't see John anywhere. Tuck them away. Gallagher. Remember Paul Gallagher? The leaf blower. He's the one that didn't check the Ring camera because he's already familiar with it. It's not Ring, by the way. It's Arlo. Arlo camera. Belonging to the, Deputy Chief Kelleher across the street. He had an Arlo camera. But Lieutenant Gallagher did not go canvass it, ask for surveillance footage or anything like that because he already knew it wouldn't pick up the road because he's picked up packages there, guys. He's on very close and intimate terms with Chief Kelleher's Arlo camera. Robert Gilman. Now he stood out. Okay, we got to go back to day 10, and he's the first one for me that he really stands out. The weatherman, guys, the weatherman, he stood out for me. I mean, if you're going to want fact, science, and data, the guy who's there to talk about enough snow to track a cat, And then only just a few inches accumulated even by the following morning, when it's supposed to be this raging blizzard. That's why nobody saw John. That's why nobody who was leaving the house at 1:30, the storm conditions were just terrible. Well, not according to the weatherman. According to the weatherman, it was only about a half an inch of snow as of about 1 a.m. Would have been about a third of an inch that would have covered if John was lying out there on the lawn, the way that the Commonwealth is presenting it. Would have had a third of an inch of snow on him at that point in time. Very windy. Been a lot of wind chill. Would have been very cold. Surely frostbite kinds of conditions. Then we got into taillight. Then we started getting into taillight. Charles Ray, who took the dash cam video at One Meadows Ave, the back of Karen's SUV, got that image of the taillights covered in snow, and something looks maybe a little bit off with the right one, but you just can't really tell. Then we got Kevin O'Hara testify about the CERT search. And they found 6 to 7 pieces of plastic and the shoe after. Now, this is after, because we just heard from the weatherman. Guys, we heard from him like literally early that day. Heard from him earlier that day about how there was maybe 3-4 inches on the ground at about 8 in the morning when Gallagher was out there doing the search with the leaf blower. And they found no plastic at all, none, despite clearing a large area right there where John was found. But then CERT went back in the evening after all of the snow had fallen, the worst winter storm in January in Massachusetts state history. But only after about, 5, 6 a.m. That's when they started finding the plastic. And it was all in that little 1 foot by 1 foot area right on the edge of the street. They didn't search the yard at all. Just a little 1 foot by 1 foot area. Then as they continued to move down the street 7-8 feet further and didn't find anything else, that's when they called off the search. So just a little bit of a peculiar visual, a little cluster of plastic pieces and a shoe. And then tons and tons of plastic still out there to be found only once the snow starts to melt. We got Connor Keefe. Connor Keefe was, trying to play the team sport, right? Trying to back up his team, but not really a pro yet. Perhaps a bit of a rookie. Definitely didn't get the memo about Proctor not being the lead investigator. Didn't know that was to be denied. Wasn't sure about all the plastic in the bag. There's that piece of plastic that was unaccounted for. He didn't recognize, didn't belong in there. So what did we do? We just pulled it out of the bag and then put the bag in evidence. Don't pay any attention to that extra plastic. Any of that sit with the jury over the long 5-day weekend? I don't know. Jessica Hyde. Man, Jessica Hyde, she seemed like a real smarty, like she understands her stuff, but boy, just a soup of technical words and explanations at 100 miles an hour, and something about pizza, fried chicken, and pancakes. Not sure that that analogy really stuck. And then Buchanan. People are like, why do you say his name wrong? It's because in my mind, he just makes me, I don't like the guy. I don't like him at all. And so his name reminds me of Buchanan. But it's Buchanan. I understand. Yuri Buchanan did not know he was coming in for a marathon session. Good, good 3 days, 3 solid days he spent on the stand. You would think, just from the standpoint of what was prioritized for the jury to pay attention to, when you spend 3 days on somebody, probably they're going to remember that, at least some of it, right? They're going to think this is important. We're spending an awful lot of time with this guy. And if he's going to be the proctor surrogate, then it definitely makes sense. He's the investigator. But not sure he really left the best impression. Was there anything substantive that jumped out other than, of course, the reading those text messages? Everybody remembers Yuri spending a good hour and a half or so having to read all those text messages. But I think it's more of a mood. It's more of a mood from Yuri that sits more than any particular content, anything particularly substantive that he had to say. You just had a feeling of, wow, this guy is really uncooperative. He really doesn't remember anything. He doesn't recognize anything. He's got, excuses for everything. We did get the new information about the dog who is now Cora. Chloe is now Cora. They say lives with a vet now. Is that something the jury is really hanging on at this point? I don't think so. The Commonwealth has, I think, been so cautious about avoiding the weak parts of their case, just trying to pretend that they don't exist. If we just stick our head in the sand and ignore them, then maybe they won't come up and maybe they won't cause a problem. So the fact that these things all over his arm really look a lot like dog bites, if we just don't pay attention to that, if we pretend Yuri Buchanan, I had to go to the hospital that morning so that I could get eyes on John and allow his injuries to determine where my investigation was going to lead next based on the information that I had. And so I went and I got that look at John and especially his arm. And I thought, motor vehicle accident. That's what we're dealing with. I'll put that out there. But they have really, tried to avoid the issue of the arm, the problem with the arm, the injuries, the significance of them. So I'm not even sure that by the time Yuri was on, they had a real perspective on why we're talking about a dog at all. Just not sure we had really gotten into that at this point. So then things got a little quiet. We had a couple Massachusetts state troopers who just documented things, took photos of Trooper Paul's driving tests, took some photos of the search, the planned excavation on February the 3rd. This was almost nobody remembers Evan Brent. Who remembers Evan Brent? Nobody remembers Evan Brent. He was on day 15 and he was just there to testify. I took some photos of the pieces of plastic, the items that were discovered during this February the 3rd search. I documented it. I bagged it. And then the crime scene photos, the photos that were taken from his part of the search, they're put into evidence, but there's a problem. There's a problem because they discovered 20 things or something, but they only took 5. They only took photos of 5. If I'm paying attention, if I care at all about Evan Brent and what he did and why it's important, I'm not sure I know. I'm not sure that really substantiated a lot of confidence in the search and the integrity of this plastic and so forth, because it just keeps turning into explanations that don't add up. You're there to document the search. You documented every item in place and bagged it. Presenting this is very systematic and orderly by the rules. But there's only photos of 5 things, dude. And there were many, many more collected. End of day 15 into day 16 is when we got Maureen Hartnett and all the collection of the body fluid samples and so forth. Then Dr. Scorty Bello. Dr. Scorty Bello surely is a standout. She's surely one. The jury is sitting back over the 5-day weekend and thinking, medical examiner, Medical examiner. What stood out? Undetermined. Undetermined is what really stands out from Dr. Scorty Bello. We did finally get some detailed information about the injuries, the abrasions, the skull fractures, etc. Some extra pieces about the John's BAC, 0.21 from the heart blood, 0.28 from the vitreous humor. By the way, guys, where's the retrograde extrapolation on John? Remember we did the retrograde extrapolation on Karen? That was all the way back on. Boy, I want to take us way back. That was all the way back on day 8 to 9 with Hannah Knowles. Hannah Knowles underlined a couple times in those notes. You think? Hannah Knowles did the retrograde extrapolation on Karen, getting that range of 0.48 to 0.14 to 0.28 at 12:45 a.m. based on Karen's blood alcohol level the following morning. Where's the retrograde extrapolation with John, guys? If they're pulling his blood 0.21 at 8 in the morning. That's a lot of alcohol. That is a lot of alcohol. Then we had some interesting back and forth about the hypothermia in particular. And why hypothermia? Well, because there are ulcers to the stomach and pancreas. There are physical changes that she can observe, but not clear that those conditions are completely consistent with hypothermia, because number one, there's no frostbite. There's cold body temp, but there's no frostbite for a guy that was out in the cold wind, frosty blizzard conditions for 6 hours or so. In most cases of hypothermia, about 50% or more of the stomach is ulcerated, but John, it's less. And then what? Then on redirect, we find out John was taking Pepsid. John was taking Pepsid, and that is in fact a common treatment for stomach ulcers, and stomach ulcers are commonly treated by alcohol consumption. That might have stood out. I don't know. One thing that stood out to me, I don't know if it's going to stand out to the jury, but one thing that stood out to me, just a lot of equivocation with Scorty Bello and what she will testify as far as injury causation, what she's willing to testify to, what is objected to, what is not objected to. Perfectly happy to talk about injuries to the, these ulcers to the pancreas and the stomach being caused by hypothermia, but those bites on the arm, those arm injuries, not going to be allowed to testify whether they're consistent with a dog bite. Asked explicitly, Bev says, nope, objection to it. Nope, not allowed. Of course, the jury will be instructed. You don't get to draw any inference from the jurors, from the questions themselves, from the fact of an objection, whether it's sustained or not. Just don't worry about that at all. are they not going to notice that Hank doesn't want his medical examiner to answer whether John's injuries on his arm look like dog bites? How can they not notice that Hank doesn't want her to answer that? Surely they notice that. So Scorty Bello, I would expect, she's an important witness. She has sat with the jury during their time away. Now, hopefully they've thought about this case very little. Just like all of us, right? Just put it out of mind. Let it go. Focus on other things. Come back to it all fresh. Go down memory lane. Start thumbing back through our notes. Oh, yeah. Of course I had Hannah Knowles double underlined. She was really important. DNA testimony. The DNA testimony, it's significant, but it was also kind of dumped on them. So I don't know how much of that is going to stick or not either. The big takeaway, lots of mixtures all over John. Lots of mixtures all over John. John's own DNA on John, hardly surprising. John and a mixture of two others on the exterior portions of the taillight. None of this seems to be the compelling case that hoping for.
But now open, you may be seated.
All right, so I was told, counsel, Mr. Alessi, you wanted to see me?
Oh, of course.
Okay.
We knew there was going to be a
Did you want
sidebar.
to come to sidebar?
Start at sidebar and then
Sure.
we'll go from there.
Okay.
Starting at sidebar. So then Ashley Vallier, that taillight reconstruction, I imagine that has also, it's just visually very compelling, seeing all those pieces put back together. I would think that sits with the jury. And that has the potential to be pretty devastating to Karen's case. If that's all that they're really taking away, this visual of plastic that came out of the evidence bags and it was put back together and it matched Karen's taillight, if that's all you were paying attention to, that could be pretty compellingly bad. But there's a lot of plastic there that did not belong to Karen's taillight, apparently. And then, of course, there was that one chunk, that one piece of the taillight that was never recovered at all. Bradford and Miyasako on day 18, the mitochondrial DNA. What do we get? The hair might be John's, but it might also be any of John's maternal relatives. And then Shannon Burgess with tech stream data, but degree inflation, claiming that that bachelor's degree for 17 years that he's never had, version after version after version of his CV with different years on it. So he updates it enough to change the year when he's supposed to get his degree. But he's never actually fixed the name of the degree, which was a problem, right? Because that degree is not actually offered by the University of Alabama at Birmingham. I don't know if they got much else out of this either. They got that the clocks are different and that there's arguments about what time is what. I think that's probably the likely takeaway from him. There's a clock dispute, and this guy lied about having a bachelor's degree, or at the very least was exceedingly misleading about what his actual qualifications were. Christina Hanley and Isaac Wolf then closed off the last of what we got before the jury got their break. Isaac Wolf, yeah, he could have slipped and fallen and hit the back of his head like we saw a gazillion times in Minneapolis when I was in the trauma center. People got drunk, did that all the time, slipped, cracked their skulls open. So you're saying That's a possible mechanism. Gotta think that set with the jury. Oh, he could have just slipped backwards and cracked his skull, and maybe it had nothing to do with Karen at all. And then finally, wrapped up with Christina Hanley and the glass comparison and the big takeaway from there. The bumper sprinkles, they didn't match. Didn't match the glass. What's it doing on her bumper? I don't know. Your explanation is probably as good as anybody's, but the only person who's really going to know is Proctor, because he's the only one that found the glass that has any comparability to those bumper sprinkles. And the piece of glass he says he found doesn't match anything else either. So doesn't match the tumbler. So how'd it get there? It's been a lot, guys, over 20 days. It's been a lot to just go through and kind of recap that. And at the same time, doesn't it seem like it's just been very little? Where even are we? What is the jury supposed to be hanging their hat on right now? Of all of these things, what stood out? What stood out? Dr. Scorty Bello, I feel like Scorty Bello stood out. Jen McCabe, kind of feel like she stood out. Yuri Buchanan stood out. But what stands out substantively? I'm not sure. I'm not sure much is standing out substantively from the Commonwealth's case here. That just screams. You know, Karen Reed is guilty. Karen Reed hit him. The closest thing that I can think of that just would be very easy, good visual for the jury to be going back to, simplifies how you can think about the case, that reconstructed taillight. I really think that's the strongest thing the Commonwealth has as we sit here right now, is that reconstructed taillight. Because if you haven't been paying attention to much else, if you haven't been focused on the details, and guys, a lot of people don't care about the details. Some of the jurors, yeah, they might be in there in the box taking their diligent notes, and they're, you know, like us, taking 1,000 notes of like the taillight pieces and trying to put all that together and stuff like that. But that's probably the minority. It's probably not most of them. Most of them are likely just going with more of an impression. What's the big picture? What's the big picture? What's the takeaway for this person, that person? What's the bottom line? I'm not sure there's a lot of bottom line with a lot of these people. So problems with things like the medical examiner isn't going to back up your account. She's going to say, yeah, here's the injuries I expect to see with a motor vehicle collision. He doesn't have any of those. That's not a takeaway. That's not a good place for the jury to be sitting. If this is a witness who stands out to them, as I would think the medical examiner tends to be. The person who did the autopsy tends to be pretty significant in the trial, pretty influential. People pay attention. But she doesn't have anything to say that really helps your case. So if we're just taking in what the Commonwealth is presenting, we're not examining it too closely. We're just waiting for the pieces to be put together for us, really, because that is what the attorney's jobs are. Not just to throw all this out there at the jury and make them make sense of it. No, it's your job as the lawyer to make sense of it for them. So maybe we're not paying real super close attention because we're counting on the attorneys to put all the pieces together for us at the end. And we're just at this point getting kind of an impression, the strong things that stand out, that stick. What's the strongest thing then for the Commonwealth that's standing out right now? I got to think it's that taillight being put back together. There's the I hit him, but that has just been challenged consistently from the very beginning. And so it's been pretty effectively countered. I have to think every single witness who's testified to I hit him, had major problems, either with their own personal credibility, like with Jen, or with the account that they described. The way that they described this all happening, Nettle version doesn't work. Katie McLaughlin version doesn't work. So I don't think I hit him is the real standout piece of evidence that the Commonwealth maybe wants it to be. I gotta think it's that tail light. It's very visual. It does make a compelling case that yeah, this tail light came from Karen's tail light. It's not just random tail light. And so if we're not paying attention to the details, we're not counting, oh hey, they had 87 or 47 pieces of plastic, but only 23 of them ended up going back into this tail light. So where's the rest of the tail light? They're not paying attention to that. That may not have registered at all. If there's any problem with any of that. So having that visual, there's a tail light that's put back together with pieces of plastic they got from 34 Fairview. I think that's really the strongest thing they have right now. So if, as has been widely reported, the Commonwealth has one more witness and then they are going to rest, then I'm pretty sure this time we can assume it's Dr. Welcher. Thought last week we were going to be getting Dr. Welcher. Didn't happen. Turned out it was Dr. Wolf, whose schedule was very busy, needed accommodating, and understandable for a man who does 4 surgeries a day. Very important stuff. So it's got to be Welcher, and that does explain why we need to have a lengthy Alessi sidebar before we can get started. Because I mean, we already know that there's stuff in dispute. The timing of everything, who gets to respond to who, to what. At the end of the day, Hank wanted the extra rebuttal of the ARCA witnesses based on the time frame. You know, ARCA didn't turn their report over until May the 7th. Of course, that was the deadline that the judge had imposed, but turned it over late, and so Hank wanted some more time for his witnesses to be able to rebut that report. Judge says, sure, we're going to allow it, and the scope of that will be determined after ARCA testifies. So you don't even actually know if you need it until ARCA testifies, but you're going to go ahead and say, yeah, we're doing it. I'm going to go ahead and grant that an undefined scope because you don't actually know if you need it or not. I like that little olive green get up Karen's got today. I do like a nice olive green. It'd be a good suiting color. So I would expect that as far as the accident reconstructionists go, surely there's been like last minute responses and supplements and new ideas and changes and so on and so forth. I mean, how could there not? We already know Jud Welcher's original slide. He's going to get cross-examined on it. I don't know if that's still going to be part of his presentation. Has he come back and changed it now that he realized, oh, the timestamp issue, it doesn't really work? The timeline that I created doesn't fit. Got a little bit of a problem with that lock button being hit after we're claiming a collision took place. So is he going to try to change that? Surely he is. Surely he is. He's going to try to get out ahead of it and not get cross-examined on that. Well, but that's what was disclosed in his report. So I'm going to come back and change it now. That's going to be a little bit of an issue. Of course, we have no idea what ARCA's done in the meantime, that they may be evaluating and wanting to respond to as well. Bev has treated it like there's this very clean distinction between what is Welcher's independent work and analysis versus what is rebuttal to ARCA. Okay, Welcher produces it, ARCA responds to it, and then Welcher responds to ARCA's response. She seems to think there's this very clear and distinguishable division between those categories of things, and in reality, it is often not that clear. It's really, really often not that clear. And that's part of the problem with the way that she's set up this process that she's going to allow, where Jud Welcher or somebody, maybe Burgess, I don't know who, is going to be able to come back. They're going to be able to rebut ARCA, but about what, we don't know, because we don't actually know where the distinction is or if it is that clean. So that's kind of what I'm getting at. Why I think they're likely having a long sidebar here is because if the distinction between what's rebuttal and what is just my own direct examination that I'm going to present as my analysis that I considered, along with the feedback and critique and so forth that I got, then you might be up there testifying to something that's very different than was in your initial report. You're making an argument, well, it's not rebuttal, it's his own opinion that's changed. It's his own opinion. It's not him saying why ARC is wrong. But that's not really how the order of things is supposed to go. So I don't know, guys. Not sure, exactly what any of these issues are going to be, but we know if we're getting down to the wire, we know there have been so many issues with these witnesses, and these ones in particular, the reconstructionist and the timing and so forth, that it is hardly shocking that there would be last minute issues that need to be addressed. I see that Sandra is asking about this very thing. Is Hank Brennan's rebuttal limited to only new information from ARCA, or can he call any witness he wants? Well, Sandra, this is a very good question. And of course, the practical answer to this is it's whatever Judge Cannoni lets him do. It's whatever she allows. Typically, rebuttal is supposed to be just a response. It's not new information, new stuff. It's in a normal world. Dr. Welcher testifies on direct, his opinions, his analysis, the conclusions that he reached based on that. And then ARCA testifies to what's wrong with what he said and what he did. And then rebuttal would be he comes back and says why ARCA is wrong about what ARCA says he did wrong. So that's kind of the normal process of how that stuff is supposed to work. But in reality, I suspect that the water is going to get quite muddied. It's just going to get very muddied. In part because they are trying to, Hank is trying to carry off this bait and switch with the timeline, where they proposed a timeline. He clearly proposed a timeline. I mean, we saw the slide during the cross-examination of Shannon Burgess. He proposes a timeline, recognizes there's a final lock event that happens after the end of that time frame. But now they're trying to say they never actually claimed things were at that time. So it's not, see, this is how the water is getting muddied. It's not, they're trying to say it's not that we got the response from ARCA or DISORGA or whoever and then responded to that. They're trying to say this is what we were saying all along, that the clock skew would actually bring the timeline to this other point. And so even though Dr. Welcher had specific times in his slides, those specific times were not actually the times that we're asserting that these events took place. See how it gets muddied? If you just pretend that that was your opinion all along, that's what you were doing the whole time, then it's not a response. Then you get to bring it up on direct. It's just your opinion that you've clarified. And the judge has already bought into this. Already bought into this explanation, said their new supplemental report that Aperture did. No, that's not Burgess's, May 8th report. That's not a change. It's not a surprise, even though they have never before shifted the timeline in this other direction. Hank takes a position. It's just a clarification. It's not anything new. And so she's allowed that. She's bought that. And so if she continues to buy that, then my suspicion is that Welcher is going to be able to do pretty much whatever he wants. He's going to be able to testify to his own analysis, but he's also going to be able to pre-butt ARCA, anticipate already what the objections to his position are and change his position. And then argue that's not rebuttal. That's not me responding to ARCA. That's just what I thought all along the whole time. So in an ideal case, it will be a lot more clear. But I suspect that's part of what the issue. It's just part of what the issue is. They've really muddied these waters with what's the original opinion, the original disclosure, and what if anything has actually changed since then as the reciprocal discovery has gone back and forth. Odin's Martyr. Hi, Andrea. Does it seem odd to you that Welcher and Wolf are similar to Rentschler and Wolf? Is there any chance that would be intentional? Probably not. Probably not. I guess I've heard of worse ways to go shop an expert. You like the name of his firm. No, I think it's just a coincidence. And if anything is a coincidence, it's that having the alliterative name is just it's good. It's a good naming convention when you have a firm, something like that with names in them, to have the alliteration. It sticks. It's very effective. Sticks in your mind. Welcher and Wolf. So I don't know. Maybe there's a study out there on like business names, organization names, or things like that. How often do people choose the alliterative name? I would think it would be a lot. It just sticks. It resonates. Barbara Ellison, Annie Elise jury observations on day of Dr. Wolf. All but one took notes. Riveted by Jackson, bored by Brennan. Youngish jury used to social media. The age of the jury, it still remains this wild card for me. It's very unusual. It's very unusual to get a young jury. Most of the time, because of hardships and scheduling conflicts and things like that, you are ending up with retirees. It's just what you get. Most states, it's who's most likely to be summoned in the first place. Massachusetts is a little bit different with how they summon their jurors, so it's not so much skewed because of that. But anytime you're going to have a multi-week trial, people are going to have hardships. People are going to not be able to get out of work, not be able to get out of school, not be able to get out of pre-planned trips and things like that, not be able to arrange childcare. And so people who are in that prime, busy parts of their lives just tend to not be able to serve on a jury like this. So you end up with retirees because They got the time. So this young jury is really it's a wild card. I've never tried a case in front of a predominantly young jury. I've thought about this and like, what would that even be like? What would that even be like? It kind of intimidates me. I wouldn't have any cultural references, you know? I'm just not entirely sure how we'd relate. It's a piece of the puzzle that is easy to not think about while we're sitting here watching the trial because of course we don't see the jurors. So you can just kind of imagine them however you want. And I find myself if I just, imagine the jury in my mind's eye, I do not default to a bunch of young people. I just don't. Even if I know that's what the jury's composition is in my mind's eye, no, there's a lot of gray hairs on the jury. So that being not the case, it's a different dynamic. So we know that the jury has been reactive. We know the jury's been reactive. They've been admonished at least once, guys. Don't make faces, don't make comments about the evidence. Just try not to react because everybody needs to pay attention without distractions. So don't talk. Then we had that questioning period last week where everybody's kicked out of the courtroom. The jurors are brought in one by one. They're questioned at the sidebar. We don't know what about. But typically, if something like that is going to happen, it's because we're trying to ascertain if there's some kind of taint that has entered the jury room, some kind of information that they're not supposed to have, some kind of misconduct that's taken place in the presence of the other jurors. And I have to wonder, we also saw the Chambers conference a couple weeks ago now with the John O'Keefe's family back in Chambers, and then they come out, and then ever since Paul O'Keefe has been sitting in that back row. And we never learned exactly what that was about either. But it does seem like perhaps people's reactions are playing an outsized role in this trial. They're garnering a lot of attention. If the family has to change their seating because they can't control their facial expressions or whatever, and then the jury is getting admonished for not controlling their facial expressions and so forth. It almost seems like it makes me wonder if there's like a back and forth going on. Is that part of the issue here? I don't know. I can't wait to find out once we are able to get the behind the scenes information about the sidebars and all that we're not allowed to have right now. But it makes me wonder if there's some kind of back and forth. Okay. I'm picturing a scenario where the jurors see Paul doing his thing, his staring down Karen, reacting, making faces and so forth. They don't like it. Call it out to the judge. Judge eventually, has this Chambers conference. They move Paul into the back. Is complaining about the jurors making faces, is that payback? I could see that, right? Anybody else see that scenario? You're going to make fun of, you're going to call out our making faces, so we're going to call out yours. And it's been this little tit for tat. I mean, that is one explanation. Other possibility, though, is it's somebody on the jury. Somebody on the jury doesn't like how other jurors are reacting, doesn't like how other jurors are behaving. That could explain why we had the whole big questioning of everybody. If there's a complaint that came from a juror, possible. So yeah, the jury is just there. The jury is always a wild card in every trial. It's particularly, I think, the case in this trial because it is unusual, very unusual to have a young jury. Not sure what that means. I don't want to stereotype, young people too much. But you do have to wonder. You grew up in the internet era. You just have a different perspective on information, a different way of processing it, a different kind of expectation about how information is going to be delivered to you. And this is such an old school style of getting to the truth of something, a court case, a court trial, all these formal procedures and evidence and so forth. Very, very different. Very different from that norm that a young jury may be more accustomed to. I do hope we get to hear from them once everything is done. That would be nice. So it looks like, let's see, we're waiting for the new filing. Appears to have landed, according to Ted Daniel. A new filing hit the docket this morning. Defendants' supplemental list of prospective witnesses. We don't have the actual document yet, though. How intriguing. Supplemental witnesses. Yeah, still waiting for the document itself. That's intriguing, isn't it? That's intriguing. I have some thoughts about what that is. It's typically when you're going to be presenting something like that, it's because something has come up that is newly discovered and that's either been kind of raised unexpectedly by the opposing side's witness, or it's just something came out that you didn't have the opportunity to be able to respond to before. So if I were going to spitball what some possibilities for this might be, I'm definitely leaning into Shannon Burgess and the whole issue with his credentials, his resume, and so forth. Hank really went on a limb there. There's transcripts available, and you've never testified in federal court to having a degree that you don't have, for example. What if they find a transcript where he has? That's the kind of thing. You didn't anticipate he was going to raise this. This was his answer to your cross-examination. So this would be rebuttal. This would be rebuttal testimony. Something like that. Something like that could be possible. Don't know what else we might be looking at. I'll just keep an eye open and see if that document comes up, and we'll take a look at it as soon as someone's able to grab it. MAGA Barbie with a question, a super random question. How does the defense get word to Proctor about when they need him in court? Do they just call his phone? Lol, thanks for your coverage. As a practical matter, yeah. If they've got him under subpoena, then he knows that he is going to be required to come in, and it's just sort of a question of when is that. And so with police, now granted, he's not with the troopers anymore. Any other situation, you just call Massachusetts State Troopers. They probably have somebody, you'd talk to the shift sergeant or somebody like that to let them know, I'm going to need Proctor on Tuesday or just whatever day. He's not with them anymore. So yeah, you're probably having that communication directly with him. And, if he's smart, he's making himself available, not making it too difficult to get a hold of him and find him, not leaving town unexpectedly or anything like that. But yeah, you typically are just going to call him on the phone. Tell him, hey, today is the day. Sandra M., good morning. Can the defense ask ARCA, you weren't hired by an insurance company, correct? The way they ask if they were hired by the defense or the Commonwealth to avoid what happened last time. I don't see anything wrong with this question other than it's leading. So they can't ask the question quite like that on direct. But to just be able to elicit the information that it was a third party. No, it was not the insurance company. Perhaps it was, I don't know if they're going to be able to say another law enforcement agency. The way that they kind of pulled it off with Jen McCabe, you can't come out and say Department of Justice, FBI. You can't say the name. But can you get close enough? Maybe. Other investigators? And were those investigators with an insurance company? Just for example. I don't see anything wrong with that question. It does clarify, it narrows the range of options that the jury could think that this is about. So I know we've missed that fan, but I'll go ahead and take it off until we're ready to get started again. A cool breeze. How many F's do I give about the GNA figures 0 to the nonillion? The jurors were not sitting there painstakingly writing down nonillion is with 30 zeros. Like, no. I can just about guarantee that the jurors don't understand what those statistics mean anyway. The statistics are meaningless. They're just big numbers. A lot of times I feel like maybe that's why they use them in part. Like there's a lot of ways you could report this information. But we like these ones with the likelihood ratios because it makes it, we get to use these really big numbers. And so that makes it sound, oh, that's extremely rare. It's extremely rare. Yeah, it might be, but that doesn't mean that it doesn't exist multiple times in the population. Rare things can exist. You know, all it takes is one identical twin and a very rare condition can now be completely replicated. So no, I seriously doubt the DNA figures particularly stuck. The jury doesn't know what to make of any of that. They don't know what the significance of it is. The bottom line is the main thing, and just there's mixtures. There's John's DNA, and then there's mixtures. And that's what they have. They don't necessarily even know what to make of the mixtures. It's going to be on the defense to make an argument for why that matters, I think. You know, if they want the jury to think that matters, you need to tell them why it matters. But otherwise, yeah, it's just a big number that gets thrown out because it makes it sound real significant and real compelling. All right, it looks like we have the witness list now. Let's see what we got here. All right. Let's take a little look. Here's the supplemental list of prospective witnesses. Matthew Coleman from Quincy, Michael P. Arico of Canton, David Nicholas White of Milton, and Jonathan Diamandis of Milton. Interesting. Well, that's definitely not Burgess people. This is not some Burgess rebuttal. Those would be like Alabama witnesses, I would think. Custodians of records, stuff like that. These are locals. I don't know who any of these people are. I don't know any of those names. Chat, you guys know any of these people? No idea. No idea. Oh, I see. It's Proctor's friends. Are these guys ones on the group chat? I didn't remember who the friends were. I know they were identified in the first trial, but I feel like they were identified by like their nicknames. Didn't they have nicknames or, they're saved in people's phones? This could be it. That would make sense. That would make sense. It could be either just looking for a kind of backup way to get those texts in without having to call Proctor. I don't know. Very interesting. Very interesting development. I do tend to think that's going to be better if you can do that. You got to have those group. Okay, you got to have those group chats in. You absolutely have to have those group chats in evidence. You made too much of them at the beginning, and they really do color the whole case. Right? Telling his friends on day one, first, just, the awful stuff about Karen is one thing, the attitude that he had towards her, the disrespect. I mean, it's beyond that, but, the attitude that he had towards her, certainly, but just the coming right out to say, no shit's going to come on the homeowner. He's a Boston cop too. To just come out and say it like that. You really do need that in evidence. Too much of the case, that is what so much of the defense case is. Particularly if we're leaning on the Bowden, the investigative failures. Here's all the things that they didn't do. Should they have done it? Sure looks reasonable. Like a thing to do, canvass the neighborhood for security footage, secure the scene. Don't interview the witnesses in front of the other witnesses, et cetera, et cetera. Why? Because no shit was going to come on the homeowner too. He's a Boston cop too. It's such an important organizing theme of the defense's case. They really have to have that in. But, it's always going to be dangerous to call Proctor. He is not your witness. You don't know what you're going to get. He is a cop. He's been a professional witness for a number of years. He knows the game. Look at how Buchanan, I did it again. Buchanan. Yuri Buchanan. Look at how he played the game. And he knows how to testify. He knows how to make it difficult and so forth. So you're going to get some of that from Proctor. He's potentially dangerous. Anytime you put a non-friendly witness on the stand, it's potentially dangerous. You're potentially opening the door for Proctor to get into stuff that you don't necessarily want him to be able to get into, If we're not making a big part of the case about the Sallyport video and the handling of the Sallyport video, how Sallyport video got lost in Michael Proctor's file for like 2 years, in his paper file until it mysteriously reappeared after the, diligent examination that we're quite sure that Mr. Lally did because he certified that he did. And we don't have any grave concerns about that Sallyport footage not being produced, even though it was sitting in Michael Proctor's file. If we're not making a whole part of the defense case focused on that, then yeah, what do we need from Proctor besides the texts? Because in many ways, he's just going to go and hammer some of the same points that Buchanan already made and perhaps do them better. When you already talked about The interviewing Karen at the home and stuff like that, really brushed over, didn't give a lot of detail, easy to miss. What did Karen say? Why does it matter? So they're getting a second chance to be able to go in and emphasize that. You're giving him an opportunity to try to bolster and explain away the bumper sprinkles, the glass that he found, the different collections of things, the chain of custody. Where was all this stuff before it got booked into evidence? You're giving him a chance to get up on the stand and give an explanation. So if you don't call him, all of those things remain open questions. So this does make a lot of sense to me as a strategy. If that's who this is, if these are the group chat buddies. Yeah. Yeah. It's a way to get the text messages in and then just avoid all of the other risks that are going to be inherent in calling somebody like Trooper Proctor as an unfriendly witness. Unfriendly witnesses are very dangerous anyway, guys. There have been more than one occasion where I would rather maybe sometimes have no witness than have the unfriendly. They are looking to cut your throat at any opportunity. They are going to fight you. Everything that you are trying to get, they're going to resist. You just don't necessarily have the control over what they're going to say that you would like. Obviously, they're not your witness. But they're not there to help you. It's really the bottom line. They're not there to help you. And so they're going to hurt you whenever possible. So if you have the choice, to get something in without calling the hostile witness, you're probably going to be doing yourself a favor to think long and hard about whether that's going to be a better option. Carolyn Smith, Young Jerks Twitter, saying Proctor hasn't gotten a subpoena. Would you give this any credence at all? And would it be silly not to call him? I don't know one way or the other. It's not unheard of. I mean, people do have to be served. Avoiding service is a thing, you know. People do it with some frequency, don't they, Elon? Massachusetts does not seem to be like many other jurisdictions where you file a return of your subpoena once you have it served. You have a proof of service and you file that, and so then you know this person's been successfully served. These other people have not. This is a very jurisdiction by jurisdiction thing. Some places you might have them but not file them. So just if you need it. If I need to go and ask for a material witness warrant for somebody, then I will go file my certificate of service to show they did have notice that they were supposed to be here. They haven't shown up, or they've indicated they're not going to show up. That type of thing. Then you would come in and you would ask for a material witness warrant based on the fact that this person has been properly served. How do we know this? Because here's my certificate of service. Whoever handed it to them at the front door or whatever. Has signed off date and time and circumstances and so forth of when service was accomplished. So, I mean, I can't say this is impossible. This kind of thing can happen. Yeah, people can avoid service. And I'm not sure that we'd have a way in Massachusetts, given how they handle these types of issues. They don't seem to file stuff to document it one way or the other. I don't know that we would have a way to know. It's possible. If they had served him and there's some issue with him not showing up, then yeah, again, I would expect there to be like a material witness warrant. If he's evading service and they can show he's evading service, then that can be a potential justification too, to allow somebody else to testify for what they need him for in their place. You might have to make a pretty good showing of like, yeah, he's been, not at his house at normal times, not answering the door, et cetera, et cetera. You might have to have something, but most places have alternative service. If you can't get someone served the traditional way, which is literally walk up to their front door, ring the doorbell, they open the door, you confirm that it's them, you hand them the subpoena, and that's that. So people figure that out. They don't open the door. They don't acknowledge who they are, pretend that they're somebody else, that type of thing. So if that happens and you're not able to serve somebody the traditional way, usually there are alternative ways to do that. So I'm just looking to see in Massachusetts, we do have a process, but I'm not sure where the rules derive from. But so it looks like they do have some type of alternative service that's available. And so what you have to do is you have to file an affidavit that explains what you have tried to do to have this person served the way that the rules call for. And usually, like I said, that's personal service to them. So you have to show, like, we've been to the house this many times at these hours. We know his schedule, and he's supposed to be home then, and he's not. He's avoiding it, and so we haven't been able to get the person served. So it looks like if this process that I'm looking at would work for a subpoena for alternative service, then first you have to go to the court and you have to get permission to serve by alternative service. And if you get that permission, then what you do is you publish it in the newspaper and you send them a copy certified mail. Normally you don't get to mail legal process. That's not considered valid service. But in this alternative service process, you publish it and you mail it certified, and then it's good. So I raise all this to say that if there was like some issue with Proctor avoiding service, generally I'm going to expect that they have tried one of these alternatives, tried some other way to get it done. If you're denied, you're denied, and then you just look at what your backup position is. But there would be filings is what I'm getting at. There would be a motion. There would be some indication that this is happening. So yeah, I don't know what to make of this information if he hasn't gotten served. I mean, it is possible. Definitely possible. And what we are seeing now with the new witnesses, that could just be the way that the defense is trying to deal with that, rather than, going through this alternative service route, which at this point in time, if they've waited this long, it's probably too late to do that. I don't think you can serve by publication, and put it in the newspaper and then, expect them to show up next week. That's just probably not reasonable notice. So I don't know. I know that rumor is out there. Whether it has any validity or not, I have no idea. Zarcasm. Good name. Good morning. I just found your channel at the start of Trial 2.0. I intentionally started it late because of the chats on other channels. This is my first live with you. Thank you so much for your insight. Well, thanks for joining us. Really appreciate that. Yeah, having a little bit of a delay this morning. Not the most exciting day of evidence here in the courtroom, but there's still a ton to talk about with this case. We got so much to get caught up on, get our minds back into the Karen Read trial after that very long, enjoyable time away. Got to get back to the grind. Thanks so much for joining us. Whatever Clever. Hartnett recently watched a video of her collecting Lexus evidence. Defense acted surprised that this video exists. Should it be turned over to the defense? This did come up during her testimony where she was asked about she had to have help getting the taillight out of the vehicle. I guess she didn't know how to disconnect it. I don't know if she didn't know how to disconnect the wire harness, if there's a screw somewhere, a mount that she missed and didn't see, whatever. She needed help from another officer, a police officer, to get the tail light out. She's asked, was that officer wearing gloves? And she's told there's a video, or she says there's a video of it that she had just seen within the last couple of days. And based on that, she knows that the officer was wearing gloves when he helped her do it. And it did. It sounded like a surprise to the defense. Like, oh, there's video, you say. And I would expect that if the defense hasn't seen it, it's because this is just part of the great Sally Port disappearing. The Sally Port video that is only selectively produced, but seems to have been, wholesale collected and preserved. Just no decision made to hand any of it over to the defense, except in these little drips and drabs. So the defense should have it if they've requested, which I believe they have at this point in time, all of the Sally Port video that's available. If this was Sally Port video, and it makes sense that it was, there were, surveillance cameras there. We've seen them. Then, they should have received that. Now it's possible it could have been some other type of video. Somebody could have pulled out his cell phone and just recorded what was happening on his cell phone. Exactly the kind of thing that cops can and routinely do. Every single police officer responding to a scene now has a recording device right there in their pocket. If not wearing it on their lapel and so forth. So any one of them could do that. Now, it's been very noticeable, I think, very noticeable that not a single one of the first responders did any of that. We haven't, this trial, gotten quite the impression of how many people were there at 34 Fairview the morning of the 29th, because unlike Mr. Lally, who just called everybody, no matter how repetitive, if they breathed on the case, he's putting them on the stand, and we're going to hear their version of events. So with Lally, because you heard from every single person who was there, you got a sense of the scope of that. How many people set foot on that scene, and not a single one of them, not a single one, with one exception, and that was Good, who pulled out his phone to video record Lieutenant Gallagher doing his leaf blowing. That was the one bit of documentation, but more than a dozen people out there, not a single one thinks to themselves, I'm going to pull out my camera and record some of this. Not a single one does it. So the absence of that kind of video is noticeable here. Doesn't mean that can't be what somebody did in the Sally Port. It finally crossed somebody's mind in the Sally Port days later. Oh, I could pull out my phone and I could just record all this while it's happening. That might even raise more questions for me if that's what happened. Oh, so you can do that. You do know how to do that. That isn't discouraged. In fact, anybody who was at the scene on the morning of the 29th at 34 Fairview, they could have done that too. So it's possible it's something like that. But it does seem likely that there's some Sally Port video, doesn't it? We've seen Sally Port video of the car in there. And yes, if that is the case, that should have been turned over. JL, I don't remember who said it, lawyer, DUI, EDB, etc. But it was mentioned that if a juror knows nothing about the case, then it sounds like Procta isn't alive anymore based on how they talk about him. Huh, that's interesting. I hadn't thought about that. I think it's possible if the jury just knows he's not here and we don't necessarily know why. The jury has heard that he got fired. Didn't they? They heard that from Yuri. Let me see. Let me see if I can pinpoint exactly. He never saw Proctor's IA file. Okay, he did. I guess, yeah, he did distance himself from a lot of that stuff. Let's see. Michael Proctor did act with integrity, but then we had to back away from it. Did he come out and say that Proctor had been fired? I feel like they did, but I didn't necessarily write it down. The thumbs up gave him a great performance review in October. But then he denies ever seeing his IA file. Yeah, if they haven't come out and specifically had it established that Proctor was fired, then it's not a bad point to just make sure that it's made and emphasized, just to take this type of interpretation off the table so that there's no question about why is he not here. It's not that he's dead. It's not that he's dead. It's that he's not wanted. Nobody wants him here anymore. The Commonwealth doesn't want to claim him anymore. The defense thinks he's trash, so they don't want to call him. If that message has not been clearly communicated, then they would be well advised to make sure that, yes, the jury knows that he's been fired. I could swear it's come out, but I would have to dig through my notes a little bit more of a granular kind of level. Yeah, I know he said it in opening. Like, I know it's been out there in opening. Maybe that will be enough, but there hasn't been a witness that's testified to it, unless it was Yuri, off the top of my head. Because they didn't call Tully, right? And Tully was in charge of Buchanan as well. So unless they got it from Yuri, I don't think it's in. Could be an important thing to just make sure. Seems small. But yeah, you don't want the jury to be looking for possible alternative explanations to save the Commonwealth's case. You want them to look for possible alternative explanations that undermine the Commonwealth's case. AEB 5043. That's all I'm going to try to do to pronounce that. I was on a jury for a murder trial that was very young. It was a quick not guilty. We're less likely to take the word, law enforcement word, as the truth. They didn't meet their burden, and the defendant being a bad guy didn't matter. Very good insight. Good insight. That was definitely a question. Culturally, is a young jury going to be less inclined to just take law enforcement's word for it because they said so? Maybe there's studies about that kind of thing. does make some intuitive sense. Makes some intuitive sense when you're young. Don't you tend to be a little bit more radical, a little bit more of a firebrand, a little bit more don't trust anyone over 30, anti-authoritarian? Or is that being too stereotypical? I guess maybe the trend, the tendency can be in that direction compared to older people. Older people can trend the other direction, but of course you're always going to have exceptions one way or the other. This is it's good. It's reassuring to hear stuff like that. It's how it should work. Whether the defendant is a bad guy or not doesn't matter. You're not on trial for being a bad guy. You're on trial for committing a specific crime that's alleged. So if you're a bad guy, it should not matter. Yet, somehow it seems that over and over trials often just focus on character types of issues. If we can dirty them up, make them look bad, then maybe the jury just won't care if we don't have a case. It's unfortunately a common strategy. So I like to hear this. This does give me assurance that folks take the responsibility seriously. They understand the role. The role is not to, hang a sign on this guy. He's a bad guy. It's not what the trial process is about. Did he commit this particular crime that he's accused of? Z, TB and Barstool Sports adding interest from teens to 30s. Could be interesting. Yeah, the Barstool thing, that's been kind of interesting to watch. Wasn't it John Boy? It was some trying to remember now. The first guys who did the podcast about Sandra Birchmore. Wasn't that a John Boy production? It was. I remember it caught me by surprise because it was. I didn't expect criminal investigative journalism from this outlet, but then they did a long podcast series about the Sandra Birchmore case. It was Barstool. Thank you, Michael Muddragon. It was Barstool. Yeah, I remembered it was something like that, and it did. It just surprised me, but also, like folks are pointing out, it potentially does bring in a whole different audience to this trial. If they're interested in this kind of misconduct in Massachusetts.
I was told counsel wanted to see me at sidebar again.
Oh, More sidebar. Yeah, see, this is interesting. And for me, it was the opposite. I found the Karen Reed case before I heard about the Sandra Birchmore case. And so I do wonder about how much crossover like this that there is. I mean, just the fact that that Matt Farwell got charged was so significant. I don't know how big of a story it was. Like I said, other than this podcast, the Barstool podcast, I really had not heard anything about Sandra Birchmore until he got charged. Then it blew up. So that's a possibility, yeah, that's bringing in a new, younger audience. Good observation there. TCP, if Proctor fails to show either missing subpoena or last-minute vacation, do they just replay prior testimony, or is there a way Commonwealth can keep his testimony from coming in? It would depend on why he fails to show. If he's unavailable, then the prior sworn testimony can sometimes be admitted as an alternative to live testimony. It's an exception to the hearsay rule in circumstances where the witness is unavailable. But what does witness unavailability mean? If you just didn't bother to go subpoena him, it's not going to fly. If you had tools that you could have used to get him subpoenaed or served, alternative service, and you failed to explore those or exhaust them, then the witness may not be unavailable. It's just that you didn't do what you needed to do to get his appearance secured for trial. Now, last minute vacation, if he just takes off, if he's otherwise been subpoenaed and he's supposed to appear, but he just nopes on out of town, then you're probably good, because he's in contempt. Like, he's ignoring the order of the court that compels him to be present, or not the order of the court, at least the power of the court to compel him to appear. If somebody doesn't show for a subpoena, they've been properly subpoenaed. Like I mentioned, one option, you go get a material witness warrant. That's a mixed bag. To follow up about that, we just talked about calling hostile witnesses. Okay, how if you call an unfriendly, you typically need to be very, very careful with them anyway, because they're not looking to help you. Now turn that up to 11, because you got this person arrested and thrown in jail before you put them on the stand. You need to be real careful about what you're doing. Keep it real targeted, because this person is going to be looking to retaliate against you. This person is going to want their revenge. So you might pursue that, but if you have this alternative option of, hey, let's just say he's unavailable, and use his prior sworn testimony from the last trial, yeah, we might be able to do that instead. But it all just depends on why. If he hasn't been properly subpoenaed, then you're just out of luck. That was on you to get that taken care of, and you didn't do it. If he is properly subpoenaed and he doesn't show up, much, much, much better odds that you're going to be able to go down this road. Wags, another rando question. When something is struck from the record, does it disappear or show as a strike-through text for appeals? It does not. There is no striking things from the transcript. The transcript will always say whatever has happened. So they will not go back and erase words or strike through or anything like that. They just note in the transcript, judge says it's to be stricken. And so when the judge is saying it's stricken, really what they mean is from the jury's consideration. You're supposed to strike that from, the jury's kind of memory of the testimony and what is transpiring in the courtroom, but it will always be there in the court record. It has to. It's a ruling, so it's a potential ground for error. You have to know what it was about, because you have to be able to evaluate, if this was an error, what sort of impact might this have had on the trial? So if you just went through and whited out parts of the transcript or something like that, you wouldn't actually be able to analyze, were these correct legal rulings? Were they harmful? Do they require a new trial? That type of thing. So really strike, just hear that in your mind as a shorthand for the jury should disregard it, but it will still always be in the transcript. Abacus Flinch, mulling this over the weekend, it feels like Hank isn't investing a lot of time into this case, despite knowing what an uphill battle it is. It almost feels like he knows there's ringers on the jury. Yeah, I don't know. I don't know about the jury. He does seem a little unprepared on some of the details. How he didn't know the mechanism of the skull fractures when he was questioning Dr. Wolf. It's just a little bit of a...
Oh, great.
Maybe not significant issue, but it's just an obvious own goal when he asked the doctor, so the brain, he thinks that the brain contracoup movement is also what causes the radiating skull fracture. And the doctor says, no, that's not. And so he repeats the question again, the brain, any way the brain could cause these injuries? And the doctor's like, absolutely not. He emphasizes how wrong you are. And that's just because Hank didn't seem to understand. We're talking about radiating force. We're not talking about the brain slams into a different part of your skull and fractures your skull. That's why Dr. Wolf is talking about being able to put his finger through your brain in that kind of disturbing way that sounds like he's thought about that. So there are little pieces like that that seem to give away that he may not be as
Yes, sir.
familiar with the case
You're
as
welcome.
we would like.
Good morning, Your
Good
Honor.
morning, sir. All right, so we're going to have a short voir dire.
Of Voir
so,
Dire.
Mr. Alessi,
Thank you, Your Honor.
Voir Dire.
Morning, Dr. Welcher.
Good morning.
If you look at any documents in answering my question, I appreciate you letting me know that, okay?
Okay,
Do you have any documents open in front of you at this moment?
I do. I have a binder.
Your Honor, I would ask until the question
can
comes
you
up.
do without it, sir, for a few minutes?
Depending on the question, sure.
Okay, so just let us know if you need
Depending on
to
the
look at
question.
it. Don't look at it without
I mean,
permission, please. All right, go ahead, Mr.
Thank you, Your
Alessi.
Honor. Dr. Welcher, you have changed your PowerPoint presentation
Oh.
in the last few days in this case,
Again.
correct?
I deleted a slide and removed a couple words.
Right, but you changed your PowerPoint presentation, correct?
Correct. I deleted a slide and deleted a couple words.
A couple
Who have
words,
you
times
spoken
maybe?
to, at the Commonwealth in the last 2 weeks? Anybody associated with the Commonwealth, who have you spoken to?
In the last 2 weeks, Mr. Brennan, Mr. Lowley, Lieutenant Tully,
Totally
Anyone
again.
else?
I think Mary Ellen Gray,
Anyone else?
the tech person Cindy this morning.
And with regard to those conversations, what prompted those conversations? Who initiated them?
Sequestration
I was
order.
originally told I was going to have to be out here last Monday. So there was a whole flurry of conversations around that. I was initially told I may have to give all my rebuttal testimony on a whole huge data set I'd received.
I'm sorry to interrupt you, sir. My question was simply because we have a limited amount of time. Who initiated the conversations?
Oh, there were multiple conversations.
How many?
I have no
More
idea.
than 10?
I'm sorry?
More than 10?
Probably not.
All right, what did you discuss with, you understand it's no longer Detective Lieutenant Tully, it's, as I understand, it's Lieutenant Tully. Did you have you said you had conversations with him, correct?
Correct.
When was the first conversation, how many, and what are the nature of those conversations?
Are you limiting it to the last 10 days or in total in my life?
Within the last 2 weeks.
Last 2 weeks. I believe it was when I got here on Saturday night, I informed them I'd landed. And then Sunday morning, he gave me a ride over to the district attorney's office.
And what did you discuss from when you, did you have any discussions with Lieutenant Tully before Saturday? Within the last 2 weeks?
Not to my knowledge.
What did you discuss with Lieutenant Tully? Topics.
Give me a time frame.
I keep saying the last 2 weeks. That's the time
So
frame I'm looking at.
all the conversations I had with him,
Yes,
can you have
He's
somebody
mad.
pick me up at the hotel?
I'm talking substantive, sir, about your outline, your PowerPoint presentation. Topics of, what discussions about the topics in your PowerPoint presentation?
I had no discussions with him about the topics of my PowerPoint presentation.
Who did you have discussions with from the Commonwealth about the topics in your PowerPoint presentation?
Mr. Brennan and Mr. Lowley.
Describe those conversations and how many you had, including the first one that you had.
Well, I originally submitted my presentation with my original report way back, I believe in January.
Right. I'm asking for conversations within the last 2 weeks.
Okay, question wasn't clear. Then on Sunday, we just went through top to bottom through my presentation. Mr. Brennan wanted to make sure he understood everything in it. And then I met with Mr. Brennan again on Sunday. We ran through it briefly again. And
That's
then
twice now you've said
that was
Sunday.
largely it.
Who suggested the changes to your presentation?
Mr. Brennan.
Mr. Brennan
Oh.
suggested the changes that you make.
He indicated some of the things, for example, the slide I deleted referenced testimony that I was not allowed to include on a slide.
Were there any discussions with anybody from the prosecution team about the changes with regard to the what I will call the Dighton route, the Dighton distance, and the total mileage? Do you know which slide I'm referring to, sir?
I do, yeah.
Who initiated the discussion on the changes to that slide?
So that slide was changed, I don't know, probably 8 or 10 days ago.
Oh, it was changed 8 or 10 days ago.
Correct.
Were there any changes made from 8 or 10 days ago to what's now in your presentation?
Not beyond what we talked about.
Oh, okay. So 10 days ago, those changes were made.
8 to 10 days ago. I could actually probably figure out exactly when if you like.
Now my next questions go to Mr. Burgess. Mr. Burgess is a colleague of yours at Aperture, correct?
Correct.
Are you aware of issues relating to the accuracy or inaccuracy of his CV?
Unfortunately, I've been bombarded with emails that have referenced that. I've seen it, I have not read them.
You've been bombarded with them, but you have, and you say unfortunately, but you have not read any of them? None?
Maybe 1 or 2 lines. For example, they come in, they're looking like legitimate business emails. And then I pull it up as a business email. I'm like, okay, I'm not supposed to do this. Court said I can't look at this.
Now, I want to go back to your slide presentation. I understand that you intend, subject to our objections at the court's ruling, you intend to present testimony with regard to your PowerPoint where you are going to elaborate on your 1231-38 to 1231-43 trigger 1162-2, and you're going to add to what has been in your presentation a verbal discussion with regard to Mr. Burgess's change that he made in his May 8th report with regard to the variance time window. Do I have that correct?
No, you don't. It's not based upon a verbal discussion. It's based upon his report.
Okay, so you're going to make, you propose, what you're intending to do is you want to add the change from Mr. Burgess's May 8th report to what you're going to testify to on your PowerPoint. Do I have that correct?
That is correct.
And the only reason you're going to testify with regard to altering the 1231-38 to 1231-43 window is because of what Mr. Burgess has done on May 8th. Is that correct?
It's better data. So I'm altering it and correcting it with better data that I've received from Mr. Burgess.
Right, but my point is, if it weren't for Mr. Burgess's change, you wouldn't be making any changes in your testimony, correct? It's only because of what Mr. Burgess did on May 8th. Is that correct?
Only from his report, correct.
Correct. So, and you understand, sir, that that change has significant effects on the very issues in this case with regard to the timeline and the collision you allege occurred, and comparing it to human volitional conduct of Mr. O'Keefe with regard to his manipulation of the phone. You understand the consequences of that change, do you, sir?
I do. I would disagree with your assertion that this is consequential. Again, my original data, which is in my PowerPoint and has not changed, that data is still there. The timing was extremely close within the error of the measurements, which Mr. Burgess ultimately showed in his subsequent report that was within the variance associated with those timing devices.
I understand, but my point, sir, and I want to understand if I have it correct, is that is going to move the time that you assert the 1162-2 trigger occurred, correct?
Correct.
And you would agree that's a substantial change given the issues in this case when seconds matter, or do you think it's an insignificant change?
I wouldn't say it's insignificant. Again, I haven't modified my PowerPoint at all. I was happy with the data I had and satisfied with the data I had. Again, once presented as engineer would with better data, we use better data. I'm sorry.
Please, Voir Dire, let him finish.
Yeah.
It brings it closer in time to Ian Whiffin's last contact point data. But even if we don't have that, given what I knew about the variance in the cell phones, my time was still within that window anyway.
Sir, you've just answered my question, which is you agree that it affects the timeline in the activity of Mr. Whiffin's report. You said brings it closer. Did I have your words correctly?
Correct. What I was concerned about was your word about significant change. It brings it closer. It doesn't necessarily bring it significantly closer. My original timeline
No,
was
before
very
versus
close,
after.
within the range of the accuracy of that, those types of cell phones, infotainment system data. So even if I didn't have Mr. Burgess's subsequent report, the data is still within that time window.
Sir, isn't it a fact that with the variance of
why do you
Mr.
change
Burgess
it?
that you're now you want to testify to, that there is a change because your 1162.2 trigger 1231.38 to 1231.43, you know that there's a device lock event on the phone of Mr. O'Keefe after that time period. You understand that, correct?
So again, there's a window of plus minus on that. Technically, those timestamps on that are, as you indicated, again, that's literally, I wrote that on my slide. It includes my slide where I have that exact comment.
But my question, sir, is the change means now that with the Mr. Burgess variance moving, you now have part of the moving range that occurs after the device lock, whereas before your change, the device lock occurred after every bit of your range of 1162.2. I have that correct, don't I, sir?
You do.
Okay.
Okay, so
Your Honor,
that's it.
that's all I needed. Thank you.
All right, so we're going to bring the jury in.
He's not going to tell us the ruling,
Go
but
inside the door.
probably
You
giving
may
him
as well
some
stay right there. Okay.
guidance at sidebar. But this sounds like an issue, yes, with changing the
I'll see
testimony.
you at
He did
No,
seem
they-
to agree that yes, he changed thing. It does move the time of the trigger point. It does change so that the device lock is now within the time period where the backing maneuver is taking place, as opposed to afterwards. Conversations with Tully, with Brennan. Interesting, huh? Interesting that it was Brennan who suggested changes to his presentation. And then he also changed another slide 8 to 10 days ago. When was that? When was that produced? I have to wonder, when was that produced? Do you think they promptly handed that over to the defense 8 to 10 days ago when they changed it? Getting into sequestration order issues here, and not looking like the cleanest situation. Probably not more than 10 conversations with everybody in the last 2 weeks. That seems like a lot of conversations within the last 2 weeks. And then getting bombarded with emails about his colleague, Mr. Burgess. He knows he's not supposed to, so he's only read a couple lines. So he says,
So we took up a lot of your time this morning. I think the coffee and donuts and muffins was probably a hint that we were taking longer than what we ordinarily would do. I do appreciate your patience. So I have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we met last week? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here last week? No. Thank you. With that, Mr. Brennan?
Thank you, Your Honor.
Sir, can I just stand and raise your right hand?
Yes, sir.
Do you solemnly swear the understood to the court and jury the case now is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
You're welcome.
May I refer to my resume? May I refer to my resume?
All right.
Refer to your
Brennan,
resume. Better make
whenever
sure you
you're
get
ready.
that right.
Good morning, sir.
Morning, Mr. Brennan.
Could you please introduce yourself to the jury and spell your first and last name for the court reporter who's next to you?
Absolutely. My name is Judson Welcher. My first name is Judson. Last name is Welcher, Welcher.
Sir, what do you do for a profession?
I'm an accident reconstructionist and biomechanical engineer.
I'd like you to explain to us a little bit about what an accident reconstructionist does.
Sure. You can think of accident reconstruction and things such as this as the physics and engineering that happens in car crashes. So accident reconstruction tends to deal with everything that happens to the car and outside the car, skid marks, vehicle damage, the electronic recording systems in the vehicle, things that have to do with the motion forces and how the physics of everything occurred and how that affected the motion of the vehicles.
You said that you were an accident reconstructionist, but also a biomechanical engineer. How is your work as a biomechanical engineer different than an accident reconstructionist?
So simply, you can think of biomechanics as similar, but to everything inside the car. So biomechanics is looking at how the effects of physical forces are applied to the human anatomy. When I'm trying to explain to somebody what I do, I say, hey, it's like a civil engineer who's designing a bridge. So many trucks and cars on the bridge. Are that going to cause the beams in the bridge to fail? Is that going to cause the cables to fail? So a human body is governed by the same laws of physics, just like the bridge. Obviously, it's made of a lot of different materials, but in a human body, my beams are bones. My cables are the muscles and ligaments. Different material properties, but everything's governed by the laws of physics and principles of engineering. So I'm looking at how physical forces, the outside of the car, for when people are inside the car, seat belts, airbags. The first seat belt was patented by an engineer. It's engineers who quantify the force of the crash and what kind of injury damage there is to the body. So it is force that causes damage like a fracture. And so we're looking at how the physical forces are applied to the body and what that means in terms of what happens to the body.
Dr. Welcher, I want to ask you a little bit about how you became a biomechanical engineer and an accident reconstructionist. Can you tell us?
Sure. So when I was getting ready to go to college, my father, who was a physician, said,
God.
whatever you do, do not go to medical school.
Don't tell
And I
us
was
the
getting
whole
ready to go to
story. We
medical
don't need your
school.
whole life
So
story.
this was 39 years ago, I believe. 35 years ago, 39 years ago. He said, it's just not worth it. So I said, okay. So then I entered into the mechanical engineering. I grew up riding motorcycles, taking things apart, frequently pissing my parents off when I couldn't put it back together. But I like taking things apart and figuring out how things worked. So I went to university and got my undergraduate degree in mechanical engineering. From there, I happened to be at a Thursday meeting of the American Society of Mechanical Engineers. A group came in from a company that did this type of work, and they showed some examples of how you apply engineering concepts that you learn in mechanical engineering to the human body. And so I was like, man, that's a great job. That's the perfect mix of engineering that I have and my desire, to learn the medical side of things as well without becoming a doctor. So I talked to them. I actually applied to the company and was ultimately hired as a biomechanical engineer.
How long did you continue as a biomechanical engineer until you went back to school?
So I actually, very quickly after I started the job, I took a human anatomy class at a community college. I quickly realized that wasn't enough. And so in around 1993, I went to the USC Medical School and enrolled through what's called concurrent enrollment, which means you can take the class, but you're not actually in medical school. It's a medical school class.
Dude.
But I took gross
Move
human
it
anatomy.
along.
So it was me and 160 or so other doctors. I took the same human anatomy that first year medical students at USC took. So it began in 1993.
Did you continue to work as you pursued your higher education?
I ultimately started my own company, continued to work, continued to do research, had a wonderful opportunity to have 2 beautiful children.
Oh, good Lord. This guy is a dead
And
ringer for
continue
Eric
to this day.
Clapton, but
Tell
without
us a
the
little bit about the
whiz.
company you started and when.
Sure. So in about October of 1994, I started my own company. Me and the guy who was my immediate supervisor said, hey, we can do this better. We can do more research, more testing. And so we started our own company.
What kind of company was it?
It was an accident reconstruction and biomechanical engineering company. We also early on did a bunch of testing and design work for amusement park rides. The same concepts for car crashes applies to roller coasters, basically anything. So we worked and had some contracts on improving ride safety. And I was also on the ASTM committee that looked at amusement park ride designs.
Did that company grow from 2 people?
Correct. We took it from 2 to about 25 people, and then we ultimately sold it in right around January 1st of 2022.
Before 2022, did you obtain a master's degree?
I did.
And what was that in and where was that from?
So again, I was working full-time. Actually, while I was doing my master's degree, I was also teaching
Good one.
classes at Texas A&M through their law enforcement training division. So it was extension classes. But I ultimately completed my master's thesis in December of 2001. That was from USC, University of Southern California. And I received my master's degree in biomedical engineering. I wrote my thesis. It was basically on automotive seat design, but it was titled Whiplash-Associated Disorders, Related Anatomy, Biomechanics of Injury, and the Relationship Between Injury Potential and Automotive Seat Design.
Oh, how relevant.
Pardon the interruption. If Dr. Welcher reads from this report, which I think he just did, can we know when he's?
Sure. Dr. Welcher asked me if he could refer to his resume, and I said yes. So if you read, just let us know.
Thank you, John.
And it's my resume, not my report.
Your resume, did I say?
No, you did. He said report.
Yeah, no, it's his resume.
You share with us that your company continued to grow until you ultimately sold it in 2022. During that time, did you continue to pursue higher education after you obtained your master's degree?
I did. So again, ever since 1993, I've been slowly pursuing higher education, both obtaining my master's degree as well as my PhD.
Slowly?
During that time frame, I also published 20 peer-reviewed scientific publications. I taught for 5 years at Texas A&M and served as a peer reviewer for both the Society of Automotive Engineers and for a short period on the Archives of Physical Medicine. So I was working and running a company with my co-creator, as well as teaching, conducting research, publishing, also while going to school part-time.
Take us to 2011. Were you still pursuing education at the University of Southern California?
I was.
And what occurred? What did you achieve in 2011?
So in August of 2011, I finally obtained my PhD in biomedical engineering. I wrote my dissertation, reading from my resume, titled Development, Validation, and Testing of a New Sensor Array for Intra-Articular Pressure Measurement, In Vitro Human Lumbar Spine, Intra-Articular Facet Testing, which is a lot of big words to say. I was testing cadaver spines, looking at the loads inside the spines associated with various motions of the spine.
Did you achieve your PhD in biomechanical engineering?
It's actually in biomedical engineering. Biomechanics is within the field of biomedical engineering.
So you have a PhD in biomedical engineering.
Correct.
You mentioned that you have published many articles. Have there been articles that you have published that are relevant to some of the subjects that you're going to talk about during your testimony?
I mean, I have a number of, again, peer-reviewed scientific publications. Peer review just means you submit it to a journal and they have other people review it, give you comments, your peers in the field. I do believe there are a number of them that could certainly be relevant to both the physics and, for example, pedestrian injuries.
If I could mention a few. You wrote an article on sideswipe collision dynamics. What's sideswipe collision dynamics?
So I was actually an invited speaker at the World Congress, or sorry, not the World Congress, the World Reconstruction Expedition. They asked me to give a presentation on the theory, science, and mathematics behind sideswipe or side impact collisions. That would include side collisions, glancing collisions, shallow angle impacts such as like a corner of a bumper goes into the side of a car, any kind of glancing or clipping type impact.
Similarly, in many of the articles that you wrote, is one of them about methods for quantifying the impact severity of low speed side impacts at varying angles?
It is.
Tell us a little bit what that.
So that was a Society of Automotive Engineers paper. Again, another peer-reviewed paper that we worked on. It was kind of an extension or continuation of all that research, where we just looked at the physics and the mathematics, basically the reconstruction of glancing or sideswipe type impacts.
Similarly, methods for quantifying the impact severity of low speed side impacts at varying angles. Is that similar to the other papers, or was that different?
Yeah, I thought that was the same one.
You know your papers,
If I
sir?
can continue. Another article or publication that you wrote, occupant kinematics and loading in low speed lateral impacts. What does that mean?
So in the course of my career, I've done probably 12 to maybe 1,300 actual crash tests. I've crashed everything from skateboards, mopeds, up to trains, motorhomes, and ambulances. I've conducted, relative to this case, probably or been involved with 50 to maybe 70 pedestrian impact tests. So the low speed side impact one is we actually put human volunteers in side impact collisions. And what we did is we had accelerometers, which are things that measure acceleration. If you had physics, remembering Newton told us force equals mass times acceleration. So knowing the acceleration of something, you can get an idea of how much force is applied to it. So we have various sensors on the body. We have various sensors on the car for the reconstruction aspects of it. So that study was the biomechanics portion. And the first paper you read about the reconstruction was the reconstruction portion. So the first paper you discussed was everything outside the car. Then we looked at how the forces applied to those impacts to people inside the car.
Have you had a lot of publications and studies about the force applied to people outside of a car?
I don't know if I'd say a lot, but I was an invited lecturer to the Accident Reconstruction and Collision Safety Institute conference, where I specifically gave a paper and a series, or basically a lecture on what's called pedestrian impact biomechanics, which was exactly as the name implies, what happens to pedestrians when they're impacted predominantly by cars and vehicles.
How much of your work involves pedestrian impacts?
Probably
Oh,
maybe
what? It doesn't sound
10%, 5 to 10%. Most of it's car to cars.
Biomechanics of low speed impacts. Is that another paper that you wrote?
That is a paper I wrote.
I don't want to read all of your papers and all of your publications, but on a different topic, did you
Guy.
write a paper on the study of the measurement of Generation
No,
2
stop. Go ahead.
Toyota event data recorders and low speed side impacts?
Yes.
Could you tell us a little bit about what measurement of event data means in this?
So newer Toyotas particularly, have two types of electronic equipment on board that can record crashes. There is what's referred to as an event data recorder, or EDR. It's somewhat commonly referred to as a black box. That's not exactly right, but it's close. And then there's a secondary system, which is really more closely tied to maintenance. That's called TechStream, but it will pick up data that you can frequently relate back to various events. So that particular paper was looking at the event data recorder data in Toyotas.
We'll get more into that subject later, but is event data recorders a subject that you're well schooled at?
Yes.
In addition to the papers that you've written, have you continued through the years and after becoming a PhD or research in this area, in these areas?
Correct. For example, every year we're part of a conference called SATI, which is our company, largely led by the engineer Christopher Furbish that we work with, has spearheaded us going out and conducting crash tests for that conference for 10 years. We did a lot of the instrumentation and crash testing at the Aperture Reconstruction and Collision Safety Institute conference. And then for a number of years, the company actually went down and did crash testing for what's referred to as the Spine Research Institute down in San Diego. So we've been hired by various professional organizations. We came out here once, the Massachusetts Association of Action Reconstructionists, I think I'm messing the name up, had a conference. We came out here, conducted crash tests for training other experts out here. We did all the instrumentation, the biomechanics of that crash testing.
In your research and testing, you have pages with dates of the different researches and testing you've done. There's over a dozen of the research and testing
there a question
items
there,
and
Hank?
articles that deal with pedestrians. Is that a common topic in your research and testing?
Yes. So again, frequently at the conference, we're doing pedestrian tests. The last Action Reconstruction Collision Safety Institute conference, there was a series of pedestrian crash tests run there. SATI 2 years ago, maybe 3 years ago, some pedestrian crash tests that were done there as well. So there are a number of instances on my resume where I have both attended class, and then I mentioned the one time where I gave an hour and a half long lecture on pedestrian injuries.
After you became a PhD or a doctor, do you continue your education and research?
Correct. I've always continued my education and
We
research.
spent half an hour
up
on this
until,
guy's resume.
I just got back from the event
What
data
does this
or
degree of bolstering
Action
tell
Reconstruction
you
Collision Safety Institute
about his
EDR
opinions?
conference, or the Event Data Recorder Summit. My company, through my relationship with the founder of that summit, was a sponsor. So Aperture was actually a sponsor of that conference. We actually sponsored it the previous year as well. And also as part of that, I assisted one of the researchers in conducting, it's called front camera module testing for pedestrian impacts on Chrysler vehicles. Excuse me, General Motors vehicles.
As a biomedical engineer, are there any groups, organizations, or certifications that are important?
I think ACTAR is important. So ACTAR is an acronym. It's ACTAR, and that's short for the Accreditation Commission for Traffic Accident Reconstructionists. And so it's a bunch of professional groups, originally from some concerns, I believe, from the Department of Transportation, got together and set standards for reconstructionists. Again, these are kind of minimum standards. You have to show, you send in your resume, you talk to them about your research, and then if you're deemed qualified, you sit for an examination that tests your skills, day-long test, theory, a practical portion, and then every 5 years you have to have 60 continuing education units to become reaccredited. I've been an accredited accident reconstructionist since February of 1995.
Asking the
And my
important
accreditation
questions.
is current and active up through today.
So you've been accredited for 30 years?
Yeah, correct.
I don't want to trick you on the math.
No, I never thought about it, but yeah, I guess it has been 30 years.
Have you testified in court before?
I have.
Have you testified in state courts?
I have.
Have you testified in federal court?
I have. Matter of fact, in Boston.
Have you ever testified in civil cases?
Yes, I have.
Have you testified being called by the plaintiff?
I have.
Have you ever testified being called by a defendant in a civil case?
Yes,
Have you testified in criminal cases?
I have.
Have you ever been called by the state or the government?
Yes,
Have you ever been called by a defendant?
correct, public defender's office.
In any of the cases, whether it's civil, criminal, plaintiff, defendant,
All of the
government
data.
defendant, does that in any way change your analysis about
Oh,
the data,
no.
regardless of who or where you testify?
No, I take my job is to be a critical analysis of the data. So I wanted to look at the data as objectively as possible and form conclusions based upon the data, trying to remove wherever possible speculation, try to remove wherever possible reference to testimony. Now, sometimes testimony is the only thing we have, and so we need to rely on it for bits and pieces. But generally, my job is to try and look at data and see what the data shows. I have no dog in this fight. I don't, quite frankly, care. What I'm doing is trying to do a good engineering job, which is looking at the data and drawing sound principles and
Sure,
sound
you don't
conclusions from the data.
care.
Presently, you said you had a company and you sold it. Where do you work?
It's a company called Aperture. I guess we were acquired or merged into it technically.
How many offices do you know if Aperture has?
Oh God, I should know that. I mean, we have them in Massachusetts. We have them in, I think there's 3 or 4 in Texas. There's, I think, 4 or 5 in California. So I want to say there's at least, I don't know, 13 to 15.
Do you work at a particular location?
I do.
Where do you work?
Long Beach, California.
Do you work with other people? Do you have a team?
I do.
How many people are on your team?
5.
And what's the team comprised of?
Good old Long Beach.
Is everybody a PhD and engineer?
One individual is a PhD in engineering, Dr. Umali. And then I have 3 other engineers and 1 case reader. I guess it's 6 people. I have a case manager as well.
Is there any, do you work interchangeably at the different branches around the country, or do you have your own team in California that you work with?
99% of the time, it's my own team. Occasionally, we'll get a case from another office. I've worked on a couple cases out of the Texas office and maybe a couple out of the Nevada office.
Were you asked to look at any data or information relative to this case?
Yes.
In looking at data and information, do you try to look at a narrow or a broad range of information?
So I definitely cast a very broad range. We try and get as much information as possible. And then, weed it down to what is important, weed it down to what is consistent with the data. So start off very big and then get down to sort of the meat and potatoes of it.
Weed out the data that isn't consistent with the data.
Do you necessarily rely on
is what you
everything
do.
you look at?
No, I certainly consider everything I look at, but I frequently don't rely on everything because sometimes it's not reliable or it's irrelevant.
In this case, can you share with us materials generally that you looked at in your review?
Sure. Your Honor, may I read from my report?
Yes.
Thank you.
Got that, guys?
Since
If you
reporter,
didn't
I
rely
apologize
on
for
it,
lengthy
it's
list.
because it's unreliable or irrelevant.
Slow.
Can't wait to hear what this guy thinks
So
is
I have,
irrelevant.
Police reports, including the Canton PD incident report, and I have 8 other reports, also the 34 Fairview Road Rams final report or cars report. I have the ring video from Mr. O'Keefe's residence. I believe that's 1 Meadows. I have the cruiser cameras, which are the police vehicles, onboard cameras, both front and rear cameras from 1, 2, 3, 4, 5, 6, 7, 8. I believe 10 different videos. I have photos and videos of the scene from the sergeant. I have photos of the vehicles, 140 photographs of the vehicles lined up together. I have 25 additional photographs of the scene, 18 separate photographs of the scene, 2 photographs of the scene, one group of 92 of the scene, one group of 50 of the scene, another video showing the cars lined up bumper to bumper, 4 videos of the scene. I have a video showing Miss Reed's vehicle being pulled into the Sally Port at the Canton Police Department. I have a 360 diagram, surveillance video files from McCarthy's, surveillance video files from Waterfall Bar, Canton Police Department, Sally Port videos from Dighton. I have the Lexus Connect Verizon records. I have the alarm.com videos. I have a video of the tow truck arriving at the Canton Police Department. One titled Native Location, John O'Keefe's phone. Past witness statements. The report of examination from the coroner. Jennifer McCabe Cellbrite data. Something called Lexus Infotainment. Different past summary testimony of numerous witnesses. Have earlier summary testimony of numerous witnesses.
Summary testimony.
The Boston interview, Boston Magazine interview with Miss Reed, a Dateline interview with Miss Reed, a 2020 interview with Miss Reed, lab reports from BODE, the Crime Scene Response Unit Boston, Crime Scene Service Section Maynard, Crime Scene Service Section Southeast, the Criminalist File Folder, Trace File Folder, UC Davis Veterinary Report. I have Verizon records, GPS location records, John O'Keefe GPS points, Axiom cache location, weather reports, medical records, including the Canton Fire Department run report for both Mr. O'Keefe and Miss Reed, medical records for both Mr. O'Keefe and Miss Reed from Good Samaritan. I have 2 retrograde extrapolation reports, one, and a serum plasma conversion report relative to Miss Reed. I have the neuropathology report. I have the Orange County Medical Examiner's report, the diagrams, the postmortem toxicology report, and a second same autopsy report, more pages.
In addition to the information that you reviewed, did you on your own go out and obtain information that you thought might be helpful for your review?
I did. So first what happened is I asked for all the information on the case. So I received some information, and then what we do is we start doing our homework. So we start doing the groundwork. So once I received some of the information, what I did was, modern cars have what's called a VIN number or vehicle identification number. It's a unique 17-digit number. So what we'll do is we'll decode that VIN number, and that gives us information about the vehicles. So I did that for Miss Reed's 2021 Lexus, as well as Mr. O'Keefe's 2019 Chevy Traverse. So ran the VIN numbers, use the VIN numbers. It tells us year, make, model, safety equipment, things like that. I then got dimensional data from a program called Expert Autostats. And then I have complete parts diagrams for the vehicles. So I have literally bumper to bumper parts diagrams from something called the Mitchell Collision Estimating Guide. And what that is, it shows parts, involved in the vehicle. So for example, in Miss Reed's vehicle, I have bumper to bumper. I certainly have all the parts around the rear bumper and tail light of her vehicle. And then of course I started additional work on top of that.
After you began your study, sir, did you have an opportunity to personally look at items that were involved in this case?
Yes, I did.
And what did that include?
That included looking at Miss Reed's vehicle, looking at Mr. O'Keefe's vehicle, going to the scene of the incident. I ultimately purchased a 2021 LX 570, the exact year, make, and model of Miss Reed's vehicle, and conducted testing with that vehicle, as well as doing a whole bunch of research and compiling data for my report and slides.
You mentioned slides. When you went through your investigation analysis and ultimately led to whatever conclusions you have, did you provide and create a PowerPoint presentation that could assist you?
I did. I provided a PowerPoint presentation on January 30th.
May I approach, Your Honor?
Yes.
It's got that emphatic sniff thing that he does. Provided it on the January the 30th.
Yeah.
Yes.
Sir, I'm handing you a binder. Would you kindly take a look at it?
Okay.
Sir, does that appear to be a copy of the PowerPoint presentation that you prepared for us today?
It appeared, right? 141 pages. Didn't look at every page, but it looks right.
Thank you. All right, I asked to mark this for identification.
Okay.
This will be a chalk.
MMM for identification.
With the court's permission, I'd like to have Dr. Welcher use his PowerPoint presentation to walk us through some of the information he'd like to share today.
Okay. No objection, Mr. Alessi, right?
No objection, Your Honor. Thank you.
Your Honor, I'm looking at a paper version in front of me.
Okay. Is the paper version the same as what we're going to see up here?
It is.
Okay, then that's fine.
Thank you. And Dr. Welcher is going to manage the PowerPoint presentation. Sir, you mentioned that you wanted to look at the area and look at the scene. Your office is in California.
It is.
Why was it important to come all the way out to this area to see the scene firsthand?
Hold on a second.
I'll let you set up before I start asking you more questions.
We went through this, had it working perfectly. There we go.
Okay.
So that's me. No, that's my first slide. So,
I
again,
have a couple questions for you, Dr. Welcher.
Come on, camera
The
dude.
first is your office is in California.
oh, yes, sir.
Why was it important to come all the way out here and view the scene firsthand?
Again, you want to have as much information as possible. So I wanted to, physically look at all the things so I can actually see with my own hands, my own eyes, lay hands upon it, look at it as best I can. You try and inspect and look at as many things as you possibly can. Sometimes they don't exist anymore. Sometimes they're gone. And you have to make a best approximation if you can't do that. In this case, I was able to look at the scene and both vehicles.
Was that an important part of your study, Doctor?
I think so.
I think so. I mean, I needed to bill
talk
for it.
about what happened to the cars or what happened to the people.
What if I
to
hadn't
look
actually
at what happened to the
slapped the
cars?
fender
You
of
need
that
to
car.
actually look at the cars, not just look at photographs when possible.
Giddy up
So
car?
I
What if I
have
hadn't done that?
Physically looked at the cars. For example, on the Lexus, I climbed in it, over it, underneath it. I downloaded data from it. I did a whole bunch of things looking at Ms. Reed's Lexus to assist in my analysis to try and add some further objective data to what we're doing here. So same
Is
thing with
touching it
Mr.
with your hand and
O'Keefe's
seeing it with
vehicle.
your eyes is
Looked at the
objective
rear
data?
bumper, took some pieces off the rear bumper to see what was behind the cover, to see what kind of damage we did or didn't have. So went to the scene, looked at the measurements of the curb, looked at where some of the lines are on the road because you can see them in some of the photographs. Again, it's always good when possible to inspect everything you can inspect.
If you could now begin and tell us how you started your investigation.
Sure. So on September 23rd, I had an opportunity to come out. Mr. Brennan was the first time I ever met you on that day, I believe. And I had received material before that. And what you see here is, this is my inspection of Miss reads vehicle. In the upper left photograph, you'll see, oh, this doesn't work very well. Upper left photograph, that's Miss Reed's vehicle, that's Mr. O'Keefe's vehicle, the Chevy Traverse. And then what you see here is a laser scanner. You can see it on the ground here. Laser scanner is creating a 3D model of the vehicles. So I use that to create a 3D model of the vehicles. You can see me in the upper right photograph. That watch is this watch right here, my Garmin watch. And what I'm doing is looking at
This Garmin watch.
the construction
You had to make sure you
composition
knew it was a Garmin.
of that right rear corner of the bumper. I'm looking at things such as the dimensions.
We know you're not
where
running ultra
various
marathons,
lights
dude.
and
It's
components
cool.
are, and how does the geometry of that bumper relate to things that would be hit when backed into.
Dr. Welcher notes this is 9/23/94. Is that an accurate date of when you came and first started looking at the vehicles in the area?
You said 24, correct?
I did.
You said 9/23/24, correct. And then on the slide, what I've tried to do is underline what I'm doing. So this is inspection of the Reed Lexus. And as noted, I'm only showing you a couple. I actually took 445 photographs.
Do you remember when you began this case, the month of the date?
No, it was obviously before this, I had material before I came out to look at the vehicles.
Do you think it was months before this?
I don't think it was months. No, it was maybe a month, if not less.
So you began your work in the fall of 2024?
Correct.
And I just want to ask you about the picture in the middle. You see the right taillight housing is missing. Did you
Correct.
understand that had been removed prior to you looking at the car?
It was, yes.
Thank you.
You're welcome. However, some of the evidence stickers, these white stickers here, were still on the vehicle.
You did not place those. Did you place those stickers on yourself?
I did not.
Were they there when you first saw the car?
Correct. They match what I'd seen in other photos.
Okay, thank you.
So just continuing on. So what you see is, again, I mentioned looking underneath the bumper. So we wanted to see what, if anything, was damaged on the corner. So I'm putting my hand to show where the frame rail ends. This is me looking up underneath to the backside of this taillight. If you can see, this red taillight actually sticks out. And so I'm checking the front here from damage. I'm checking the back for damage.
1 second, please.
We don't know what you photographed here, dude. It's terrible
Doctor, when you were
perspective.
looking for damage on the previous slide, did you find any damage to that lower right red taillight?
No, there was no damage to the taillight.
The middle picture is from the inside, looking at the inside of that taillight. Was there any damage to the inside of that taillight?
There was not.
Thank you.
You're welcome. So again, looked at the height of it. I mentioned this lower taillight. Notice how the structure of the bumper protrudes out. You can see one of the marks, which is consistent with the contact to Mr. O'Keefe's vehicle. Here, this scratch mark, or scuff mark. Notice how close it is to this light. Again, some of the evidence, stickers.
Did Hartnett
Just a better
document
view of
that?
those, then going down the side of the vehicle. So with all that information, I mentioned a laser scan. So you move this laser scanner, and each minute and 51 second scan is collecting about 50 million data points. And so you scan all the way around, and then what you do is you merge all that data together. So even though this looks like a poor photograph, what you're seeing is hundreds of millions of photographs, hundreds of millions of points. And so you literally can figure out, if you wanted to know the distance from this lug nut to where the lighter is on the ashtray, you could probably do that to an accuracy of about 2 to 3 millimeters. So really, taking tons and tons of data. So it knows the exact position of every one of these millions
Why
of
does it
data
look like
points,
it still has
and
snow
knows the
on it?
color associated with those data points.
Why is that data imaging so important in accident reconstruction?
You want to have an accurate model of the car. So, I mean, you probably don't need literally that many points to get an accurate model, but that's just the nature of the way the science is going. Computers are getting better and faster. Scanners are getting faster. So you get an enormous amount of data when you use these scanners nowadays. So then, as indicated on the underline here, I did a CDR. That's a little different than what you heard me say before. CDR is crash data retrieval. So that's the hardware and software that you use to download or actually copy or take an image of, which means you're just taking an image off what's on the vehicle, the EDR, which is the event data recorder. So you use the crash data retrieval hardware
With the black box.
to download the event data recorder, otherwise commonly known as the black box. So I downloaded the black box from this vehicle, and although you can hardly read it here, again, I mentioned there are two systems on this vehicle. This is the CDR system or EDR system. There's also the text stream. The EDR system, this system is primarily to manage the safety components, protect the occupants of the Lexus. So things like fire the airbag, fire what's called a pretensioner, keep track of the severity of the crash to decide whether we need to fire the airbag. So it's not really designed for pedestrian impacts. So when we downloaded this vehicle, we got what's called a none file. A none file simply means that there's no data there. The system's working properly. We had no fault codes, but for a car hitting a pedestrian to cause a file here, this is really more designed for car-to-car impacts, something that's going to have a significant impact on the occupant of the Lexus. And again, the Lexus is a 6,000-pound vehicle. Mr. O'Keefe's only 216 pounds. So it's not going to register from hitting a pedestrian.
Were you surprised that
really?
there was no information about a collision in the EDR?
No, it's exactly what I expected.
Exactly
mentioned
what
the
he
second system.
expected.
So as underlined up here, this is the text stream. So this is from Toyota text stream data. You can see the screens here. There's generally two types of files, what's called a vehicle control history and a PCS file. The PCS file is God, I forgot the name of it, the protection system. So I also looked at Mr. O'Keefe's vehicle. PCS is pre-collision system. Looked at Mr. O'Keefe's vehicle, same thing, took a series of photographs, laser scanned it, looked in it, underneath it, behind it. I mentioned taking some of the bumper parts off. So I took this rear cover off here to look at the damage behind the bumper cover. Most cars have what's referred to as a face bar. That's that piece of metal that you see here. And there's a piece of energy absorber here. That's your face bar. So I'm looking to see if there's any damage to that. There was no damage to that.
Before you go forward, I want you to take a couple steps back because I want to ask you some questions to explain
Please.
text stream data. Could you go back a couple slides, please?
Sure.
Okay. You mentioned that in the EDR, which is similar to a black box, there was no information found. And then you mentioned a different system, the text stream. Can you make it clear for us how these systems are different and where they're stored on a motor vehicle?
Sure. I mean, a lot of data is stored in a similar location. The text stream system was originally designed, according to Toyota, for maintenance issues. It seemed to come about around the same time Toyota was having problems with sudden accelerations or allegations of sudden accelerations. So the text stream data or vehicle control history will give you information when there's, for example, excessive acceleration or rapid shifting of the vehicles or rapid steering of the steering wheel. So the statements are that that's designed to help the maintenance people, if you come in with a problem with your vehicle, to diagnose what that problem is. It has a lot of utility in accident reconstruction because if you jam on the brakes before a crash, frequently the tech stream data will record the crash.
You mentioned Toyota a number of times. Could you share with us the relationship between Toyota and Lexus?
Sorry, in my mind, they're the same thing. Toyota and Lexus, obviously a little different, but Lexus is basically made by Toyota. So Toyota and Lexus has the Lexus safety system. Toyota has the Toyota safety systems, which you both read with the tech stream data.
The tech stream data, in this case, does it play an important role in your analysis?
I think so, yes.
The tech stream data, did you independently download that data yourself?
So I independently downloaded it, and then I also ran a test with Miss Reed's vehicle, and I created a new tech stream file so that I had a stamp in the ignition cycles of what the current ignition cycle was. So I did a sudden acceleration test of the vehicle.
On the Lexus or on the exemplar vehicle?
On her Lexus.
When you did the downloading, why did you do it yourself?
Again,
Yeah.
whenever
already
possible, want to
have
be the
it?
one that does it, make sure it's done correctly, and be able to say, hey, how do I know that's from that vehicle? Well, I know because I was the one who did it. And so if I get it from someone else, then they frequently have to bring that person into court to say the other ones that did it, so then I can use it. So if I do it myself, it eliminates that problem, and then I have no concerns over where it's coming from. So then I know hey, I did it. This is the right car. This is the right program.
You left us
So
at
you
slide
didn't
10 when you were
actually
inspecting
purchase
Mr.
it all,
O'Keefe's car.
is what I'm hearing?
Correct. So again, simply a blue arrow indicating that I looked down behind all this stuff, took measurements of it, and then similarly, I have a 3D point cloud of Mr. O'Keefe's vehicle. So part of the reason we're making these 3D point clouds, and we'll touch on this further, in addition to the scene, you can then basically put all these things back together in the computer. So instead of having to drive the cars to the scene, for example, or to Mr. O'Keefe's residence, you can take these computer models and additional data and put it back in the computer and reconstruct everything on the computer.
Yeah, if only you had good scene
So-
data to do that.
Before, we had the exact angle of impact. Again, this is for looking at when Ms. Reed contacted Mr. O'Keefe's vehicle, backing out of Mr. O'Keefe's garage at One Meadows. I lined them up just to generally show the approximate location. A couple things, notice how, again, this lower portion of the Lexus bumper sticks out. Notice how the side of the Chevrolet slopes in as you get higher up. So this portion sticks out more than this portion. And this is where you would expect any contact damage to occur, assuming there was an impact. So again, looking at the measurements up the height of the vehicle, of course, as you indicated, Mr. Brennan, the taillight's gone. And then went to the scene. So same thing, went to the scene, took, again, 297 photographs of the scene, had our people scan it to create a computer model of the scene. So, literally, if you wanted to know the distance from this window to, say, some manhole cover on the road,
What is
we have the
this
data to figure that out, down to a couple millimeters.
bizarro
In addition
thing we're looking
to
at
going to
there?
the scene and doing the digital mapping, you mentioned other review of materials.
You're gonna
Did you
call that
have
a
an
digital
opportunity
map?
to review dash cam footage from Canton Police Department police vehicles to see the general location of where Mr. O'Keefe was when first responders were assisting him?
Objection, Your Honor.
So that's just a yes or no?
Yes.
Thank you.
So the tech stream download. So this is a screenshot from the text stream download. Keep in mind, this is kind of maintenance software. So we're looking at a number of things in the maintenance software. What we see is, and this is noted in the report too, that when the vehicle gets into the Canton Police Department after this event, you can see the mileage is 12,665 miles. So that shows up in Trooper Paul's report. It shows up in the photographs, and it shows up as matching the mileage in the text stream data, both at triggers 1164 and triggers 1167.
I'd ask you if you can enlarge the data on the right and break down what it actually means, the different columns and the. Is it possible for you to enlarge that?
My fingers are too fat.
Thank you.
Okay. So what you're looking at is what I called event 1162. If you see anything in blue on these charts, that's information that I added. I typically put my initial, JBW, Judson Blair Welcher, that's me. And so this is referred to as the key cycle trip. So key cycle is simply you turn it on, not necessarily turn the ignition on, turn it on, turn it off. That's one key cycle. So I labeled this one 1162-2 because there's also one that's on the same key cycle that I'm calling 1162-1. The system also records the mileage. So again, this is a maintenance system generally. So what you see is the T here is the trigger, and there's a point. So this time in the text stream data, you could think of it as like a stopwatch. It's when it starts when the car turns on and stops when the car turns off. And then if it sees a triggering event, a T, it records that information. So this is when the trigger happened. So that's 1,142.2 seconds. And so I've converted that to minutes and seconds because most people don't think in seconds. And so what it also does is once it sees a trigger, it's constantly circulating data through the computer. So when it says, okay, we have a trigger, it saves 5 seconds before the trigger and then 5 seconds after the trigger. So the trigger's in the middle and you have 5 seconds of data before and 5 seconds of data after.
And this matters
A
because
couple of questions for you,
Please.
Dr. Welcher. First, starting with the clock, the time in seconds on the left. You mentioned that begins when the car is turned on. What type of clock is that called?
It's just a continuous clock, meaning it's not a clock like a time clock. It's more like a stopwatch kind of clock.
Has it ever been referred to as a running clock?
It's the same thing. You start the stopwatch, it's running.
Based on the text stream data alone found in that one spot, can you tell from the data in the text stream alone what time the power was turned on?
No, not alone. It simply tells you how long it's been on. It doesn't necessarily immediately tie it back to a clock time. You need additional information.
And so this in and of itself, the text stream data doesn't give you a certain time on a clock, like 1 o'clock or
like with the
2:30,
date.
anything like that.
No, it simply tells you in this case, when the trigger occurred, it's been on for 19 minutes and 2 seconds.
You also mentioned that there is a 10-second window of information this captures, 5 seconds before the T and 5 seconds after the T, the triggering event.
Correct.
Objection, Your Honor.
Sustained, yes,
That window of 10 seconds, what happens if that doesn't capture the entire event? What if there's something before or after? What does the text stream data do?
So it depends on what the something is. So if there's another trigger, then it will record more data. So you can have you can have two triggers that are recording things on the same time window as well, or very close to the same time window. So you need another trigger to keep it going. But in essence, what it does is when it sees a trigger, it saves that 10-second window and then just keeps monitoring things until it sees another trigger.
If the data captures a trigger, it has a 10-second window, and an event continues past that 10 seconds, so past the 5 seconds on either side, and there's no further trigger, do you get any other information from the text stream data?
No. For example, in the trigger event, and say 5 seconds later the vehicle's still moving, well, the data just ends, and it says it's going, I don't know, 17 miles an hour, for example. It doesn't continue on. We just know that when the trigger ended, it was going 17 miles an hour.
Thank you very much.
Okay. Okay, so we have mileage recorded in this system. So what we're trying to do is use the available data to see if we can determine, you know, like what event this is, or is this the event, or is this something that could have occurred outside 34 Fairview on the evening of this event. And so one of the things we're utilizing is the mileage. Okay, so 12629 is at the end of event number 2 on the 1162 ignition cycle. When the vehicle ultimately comes into the impound yard, and this is actually before that, comes into the impound yard, it has 12,665 miles. That's a difference, did the math for you here, of 36 miles. Okay, let's consider where that could have come from. So we looked at the various paths and descriptions of where Miss Reed's Lexus was driven after leaving 34 Fairview on the night of this event, up until the point in time the vehicle ended up at the Canton Police Department. So we used Google Maps. We adjusted for the correct date and time of the year. And then what you'll also see is we adjusted for the correct time of day. So, although you can't really see that, let me see if I can blow it up. So you can see that's looking at the mileage and time. Again, really didn't use the time, just used the mileage on Saturday, January 29th at around 12 a.m.
Time of day.
That, of course, is not
Still
taking
the
into
same
account the weather.
distance at rush hour.
And what are the addresses? It's hard to see on the top from where to where?
So this is from 34 Fairview to 1 Meadows Avenue, which is Mr. O'Keefe's residence.
And there are other mileage that you have there?
Correct. So we basically ran through the entire path as we understood it. Again, we didn't have complete information. We didn't know the exact roads. We didn't know if turned around,
No,
stuff
you
like that.
definitely
So
didn't.
you're seeing the suggested available paths, and we end up with a range of data. So we go through all the paths, and you can see that this is what we end up at the bottom here, which is very hard to see.
So if you go the fast route, you're over.
So the minimum suggested route is 36 miles, 36.1 technically. You have a range of 37.9 to 39.7, but again, that's right in the range of the 36 miles. So that's a data point that's starting to build our confidence in what is in the text stream data being related to our event.
This is all an effort to match whether or not the 1162 data is relevant to a particular event?
Objection, Your Honor.
Sustained.
Let me ask it this way. matching all the distances by miles. Is this the only way you're trying to determine whether 1162 is the event in front of 34 Fairview Road?
No. So again, these things are all tools. You can't take necessarily one data point in a vacuum. You need to consider the totality of the data.
Totality. Heard that with Burgess. Just the totality of the investigation. No, it was mechanic.
Which is what I did. So we mentioned the continuous clock that was in there, or the running clock that was in the vehicle. So what you see over here.
Could you enlarge that for us, Doctor?
I am doing that right now. You can see we have the time. And again, I've converted it in blue to minutes and seconds. This is the first trigger on that key cycle. So on key cycle 1162, there was two separate events. The vehicle keeps a continuously running clock. So we're able to see the time each event occurred relative to when the vehicle was started and the difference between the two events. Okay. So at trigger event 1162-1, we know that the ignition has been on for between 10 minutes and 57.4 seconds. Or that's when the trigger is, sorry, 10 minutes, 57.4 seconds. Again, the trigger has plus or minus. So that's from 10 minutes, 52.8 plus 10 seconds, which gets you to 11 minutes, 2.8 seconds. Or as I wrote here, 10 seconds total. So again, the text stream data indicates at the time this event was written, the trigger occurred, again, at 10 minutes. You see we have the T.
No, we don't see.
10 minutes, 57.4 seconds.
I don't know what the hell you're talking about.
Dr. Welcher, if I could ask you a couple of background questions. This block of time that you're reviewing that mentions two triggers, can you tell whether those triggers are immediately related or two separate events?
So you can tell they're separate events because there's a separate amount of time between them. There's about 8 minutes between the events. And so they're on the same ignition cycle, meaning the vehicle hasn't been turned off in between. And we have this continuously running clock that records when these things occurred. So it tells us when event 1 occurred, when event 2 occurred. We know it's on the same ignition cycle. So if we have some idea of when the car was turned on, we can then tie that back to clock time or real world time.
How do you find such bad communicators as experts?
Okay.
This didn't even make sense. And now he's just going to riff?
Lots going on here, right? A lot to digest. This is trigger event 1162.1. I was provided with data and a report from Mr. Burgess that indicated the infotainment system was turned on at 12:36. Zoom in for you folks. That corresponded to a GPS location that looked like it was outside the Waterfall Grill on Washington Street. So additional cell phone data that we had is that we knew there was a 3-point turn made when the Lexus passed Fairview on Cedar Crest, pulled into a driveway and made a 3-point turn. So what you see over here is GPS data from Mr. O'Keefe's phone. And with that information and knowing when the system turned on, we're able to now tie the text stream data to a real clock, meaning what time of day did that text stream trigger occur. So we're going from the running clock to a real world clock. So if you take when it was turned on from Mr. Burgess's report, you can see that the Lexus was turned on at 12:36. You add in the text stream information, you get it at 12:23:38. And now we have a cell phone data point at 1:54. So at the time my report was written and these slides back in January, that was all the information we had in terms of data point 154. That was the one that was closest in time to it. So we had since received additional information.
Dr. Welcher, let me ask you a couple questions, and if you can zoom in a little, we might be able to see it a little better from here.
Where would you like it?
If we can start at the top when you explain in text. You told us that the text stream data does not have an actual clock, it has a running clock, like a stopwatch.
Correct.
And then you mentioned that after you received information from Mr. Burgess, you could put an actual time onto it. How do you do that?
Objection, Your Honor.
Sustained.
You shared with us that the text stream data runs on a running clock.
Correct.
And then you received further information so that you could actually identify a time. Where did you receive that information from?
Objection, Your Honor.
I'm going to allow that.
That was from Mr. Burgess's report.
And do you know where that information came from?
That came off the SD card, I believe, in the infotainment system.
Do you know when Mr. Burgess found the SD card on the infotainment system?
No, I'd have to go back to his report, but it was in it. This information was in his original report.
Based on the SD card information about when the car was turned on and off, how do you match that with the text stream data to get a time?
So when the car is turned on, that's approximately when the running clock starts in it. There may be as much as a 3-second delay in it, but that's approximately when the clock turns on. So this shows us when the stopwatch was started for the text stream data. So knowing that infotainment system has date and timestamps on it, so that ties it to a real world clock from GPS information. And so now we can, when that infotainment system turned on, it's very close in time to when the text stream data started recording data. That allows us to tie the two together.
The times that you're showing on this slide, does that relate to the first or second event on the text stream data, the first or second triggering event?
The first event.
Do you characterize the first event in any way?
I call it the 3-point turn.
In addition to the data you analyzed, was there any other information you saw that evidenced or supported that a 3-point turn occurred at the area depicted in your slide?
Right. We have a whole series of GPS data with heading angles, as well as a description that Ms. Reed gave in an interview.
The time that you have after you consider the SD card ignition on and the running time, what clock is that based on?
It's my understanding that's a clock in the infotainment system. And then we're ultimately trying to also tie it back to the clock on his cell phone.
Mr.
O'Keefe's cell phone, correct.
Do you have any understanding whether all devices have the exact same clock?
So it's my understanding they do not. In my discussions with Mr. Burgess, reading reports, that they can have, there can be as much as 30 seconds to a minute of variation.
Objection, Your Honor.
Sustained.
Have you ever heard the
Strike, Your Honor, that answer.
Sure. Jurors disregard that answer.
Have you ever heard the term variance before?
I have.
What do you understand that to be?
That means differences from the answer,
Yeah, these are
Sorry,
hearsay
differences from what?
from
problems.
typically the correct answer. Like meaning that a given data point has variance in terms of how it's measured, when it's measured. So different measurement device can have a different variance around the actual true number.
He doesn't get to
You
repeat
mentioned on the
Burgess's
slide
testimony.
a time of 12:23:38.
Correct.
In O'Keefe's cell phone data, at point 154, approximately 12:23:58.
Correct.
Is there a difference between the clock on the Lexus text stream data and that of Mr. O'Keefe's iPhone?
There is.
When you developed the slide, did you have the benefit of more detailed information about data point 154?
I did not receive that until May 8th.
Did you later learn more information, more specific information?
Yes.
Okay.
Being a little cautious around that answer, huh? Suddenly you don't have a whole lot
I'd
to
like
say in the
show an exhibit
volunteer.
to Mr. Welcher that's already been admitted.
Okay.
It's 192A.
I'm still extremely unclear about how they've tied all this together and what has an
Gilman, can we
actual
start with
clock and what
192B?
doesn't.
Dr. Welcher?
Your Honor, can we approach on?
Yes, we'll come over.
Thank you.
This looks like this is just him parroting Burgess again. These are hearsay problems. He doesn't get to testify to what Mr. Burgess did or what Mr. Burgess concluded from it. That's why we had Mr. Burgess on the stand. So that's why he doesn't get to talk about his report, his location data, and so forth. Guys, I understand this case pretty well, and I remember so much of this from the last trial. And I'm sitting here listening to this guy, not sure what he is actually communicating here. I'm really not sure what he's actually communicating here. It should not be this difficult to try to explain how all these clocks align. We know that there's a running clock somewhere. But where is there an actual clock? Is there an actual clock somewhere? If so, where? That's not clear. The actual clock that is being tied in with John's cell phone, is that coming from text stream? Is that coming from the EDR? Like what? It should not be that difficult to understand. It should be really, really crystal clear. And just the selection part of this. Okay, well, you know that there was a 3-point turn, so you focused on that. You don't know every time she's made a 3-point turn. Did she make a 3-point turn coming out of Meadows at 5:07 in the morning? Yeah, probably. Did that record? Did she make a 5-point turn at any point leaving? Or a 3-point turn? We saw the car do a 3-point turn up in Dighton when they loaded it on the tow truck. And so how this 3-point turn is like some identifiable point in time that we could just pick out a match from, this seems like a really poor assumption, because it seems like there are, even just in this fairly limited window of time, a few 3-point turns that we'd be dealing with. Then the mileage. They run out all of these different route options. Guys, I remember from the first trial, this is a big part of what Tully did. You guys remember that? You guys who watched the first trial? Tully talked about trying to reconstruct Karen's location when she was driving around the morning of the 29th, between the time she left John's house and when she ended up at Jen McCabe's house, because there's like a 45-minute, 40-minute maybe window in there. It's a fairly extended length of time. And it seemed like in the first trial, they were trying to suggest she went all the way back to 34 Fairview, but they were never able to substantiate that. But they picked her up on camera in different locations, and tried to track her location data. That is a huge chunk of time that is unknown and unaccounted for. I don't know how you fit that into this mileage reconstruction. You have to make these minimum assumptions about where she went, right? She went from John's to the waterfall and then to Jen's. That's what he's got on his map or on his chart. And only if you look at like the minimum possible distance between all those things do you get the 36 miles as even being possible. But what was she doing for the other 40 minutes? Was she just sitting outside the waterfall idled? That seems unlikely. That seems unlikely. And they picked her up on camera in the previous trial in other locations. So surely they would be able to narrow down a little bit more specifically exactly what her route was that morning. Could we at least narrow down if she was on this camera at this location, then she would have taken this route? It seems like that information is or should be available, but it also doesn't sound like he did anything to try to reconcile it. So once again, remember last week I talked about if we could keep track of all of the like extraordinary events that have to all coincide. Do you think that Karen Reed hit John O'Keefe with the car, right? The extreme events, not impossible, but just, it could happen. But it sure is a lot of them, a lot of not impossible, but could happen types of situations that are all converging over this particular incident. We've got not being seen out in the yard, right? Seems unlikely. We've got him with the 80-degree body temperature out there for 6 hours, but has no frostbite. Seems unlikely, but possible. You remember all these likely but possible possible but unlikely things? The mileage. It's possible with what she was doing that she only went 36 miles, but it seems unlikely. You got to give every benefit of the doubt to the Commonwealth, to the routes that they chose, to the Google Maps, right? The Google Maps calculation of the mileage. Or how are we reconciling that with the vehicle odometer, for heaven's sake? Those things aren't going to necessarily add up either, are they? Do they? Hey, guys, car people, I don't even know this. Do odometers still run by the wheel from the drive shaft? Or does it all just get picked up with GPS now? I mean, I assume it's still, your car, your speedometer, your odometer, they typically run off of the circulation of your wheels. It'll register every time your wheel turns, and it knows how big your wheel are, which is why, guys, if you get big wheels on your car or something like that, you have to go in and adjust your speedometer because it won't register the same. It'll show you as going slower than in fact you are, because it's assuming you put a great big wheel on your car, and now it's a big old lifted monster. It's just reading the time that the wheel turns, not the size of the wheel that's turning. So anyway, this is like conventional speedometer, odometer, and I would expect, just like the analog clock is not going to sync up with the digital clock, there's always going to be some amount of skew, even if it's slightly, but it will accumulate over time and give you the clock drift. Surely it would be the same between an analog odometer, like you would have running your vehicle, counting every time the wheel makes a full 360-degree rotation, and then doing the math, turning that into miles, turning that into speed, and so forth. That surely is going to have some skew from what a GPS, a satellite measurement shows. Nothing about that being reconciled. So we have to give every benefit of the doubt to the Commonwealth's version here to get to barely fitting with the 36.1 miles. And we have to ignore there's a 35 to 40 minute period that morning that is largely unknown, where she was going and what she was doing. So I don't, how is this even landing? How is this landing? Is the jury sitting there getting this? I feel like I know this case pretty well. I'm having a hard time following his explanation here. What he's saying, all of this shows. Very good point here.
Dr.
You
Welcher, if
reversed?
you could take us back to
come
slide
off.
30. And so we understand you mentioned there were two triggering events. Is this the first one or the second one?
It's the first one,
Is that the one you've labeled the 3-point turn?
correct?
And where did that happen? What street?
Cedar Crest?
At this 3-point turn triggering event, there is a time in red, 12:23:38.
Correct.
Where is that time taken from?
That's coming from the cell phone of Mr. O'Keefe at 0.154.
Okay. And is there another time on there?
I do the math between those two.
Okay. Could you make that a little larger? Could you zoom in so we
Sure.
can see it better?
So there's an infotainment time of 12:12:36, I guess another time, that answer your question. Then we have,
The 12:12:36, what does that indicate? What's that relevant to?
that's when the text stream data is basically turned on, plus or minus a little bit.
When you say the text stream, is that relative to when the car turned on?
Correct. Sorry.
Okay.
So when the car turned on, then we add the time for the trigger. So what we have is we have data in the text stream that shows the speed, the position, the steering of the vehicle on that trigger. And so we're trying to match the timing and
we
the
know you're trying to
description of what
match.
the vehicle was doing with the text stream, the infotainment, and the cell phone data.
Is the data that you analyze regarding the speed, the direction, and the timing to determine whether this was consistent with a 3-point turn?
Yes.
Okay. Continue, please.
Continue, please, with what? That's not a question.
And if you can enlarge that because it's hard to see back here.
Sure is. Okay, so again, we are looking at event 1162-1. The information in blue is speed. It comes out of the text stream in kilometers an hour, converted to miles per hour, feet per second, looked at the total distance traveled, shift position. So in the text stream data, a shift position of 1 indicates you're in drive. A shift position of 2 indicates you're in reverse.
There's no zeros. What would a zero indicate?
0 is usually neutral. And I believe 3 is park. So there's also data on the acceleration of the vehicle. So basically, what is the effect of whatever you're doing in terms of stepping on the gas or not stepping on the gas? And there's also information on the steering of the vehicle. So again, there's trigger 5 seconds before, 5 seconds after. So over here, a positive number equals a leftward steer. So you can see we have in the forward velocity or forward motion in drive, goes forward with leftward steer, stops, shifts into reverse, and then continues with the rightward steer back.
Could you take us over to the left
What?
of that data? When you look at the number 1162-1 as an event, can a key cycle or when a car is turned on, power ignition on until the point is turned off, whatever amount of time, can it have more than one triggering event?
Yes, it can have lots of triggering events. In this case, it has 2. On a key cycle 1164, there's 11. On 1167, there's 10.
If you could move a little bit to the right on this, is there something you can see on here that caused the triggering event, some of the data?
Yes. So if you look at the triggering the indication of what this trigger was, what you see is accelerator opening ratio, which is basically, you can think of it as how much you're stepping on the gas pedal. And so if it exceeds, in this case, 30% quicken time after shipping into reverse, that tells the system, hey, we might need to start recording this data. So what you can see, it went into reverse, and then within a very short amount of time, the accelerator pedal went above that 30%. That's what caused the T or the trigger in the tech stream data.
Like when your wheels slip on the snow?
Row next to the 31.5, engine RPM data. Can you explain to us what that is?
Sure, that's how many revolutions per minute the engine's turning.
The more gas, is it generally the higher the RPM?
Correct. There's going to be a little lag. Your car doesn't move instantaneously. You have to step on the gas, then the RPMs go up, and then it starts going faster.
Running at 600,
If you could
800, that's
explain to us
low.
the total distance and distance travel columns.
That's
How do
low
you
for a
read
gas
that?
car, isn't it?
Sure. So we know the speed at various
Check that on my
times.
diesel.
We know from this data that there is, you can see half a second between each one of these timestamps. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 data points at half a second. That's the 5 seconds of pre-crash data. So if you know you're going so many miles per hour, again, I converted it to feet per second. Feet per second, you're going so many feet per second for half a second, for example, you just multiply those two together and it tells you how far you went. So what I'm doing is looking at speed traveling during the interval, that's during this short time period, and then I add it all together here for total distance traveled.
You mentioned that when the data is captured, it's limited to 10 seconds. When we look at the top row of JBW vehicle speed MPH, it's 9.94. Is that 9.94 miles per hour?
It is.
Can we tell whether it was going faster or slower before this data?
We generally cannot. I mean, you might have some, it looks like it's slowing down. And then you see right here, this brake switch application. So you have two things relative to braking. You have a brake switch, which is simply whether the brake is on or off, just enough pressure to make the brake light come on. And then you have brake oil pressure, which gives you some idea of how much pressure is in the system, which is a rough indication for the braking. But then what you see here is the longitudinal acceleration or deceleration. This gives you some idea of how much the vehicle is speeding up or slowing down. So generally a minus sign is a slowing or accelerating in reverse.
And for the bottom of those columns, I'd ask you whether or not at the beginning of the
Slowing.
window, if you had any other information, is it the same situation for the end of that window that's captured?
Correct. So at the end of this window, you can see it's still going about 8.7 miles an hour when the trigger stopped. So after that trigger plus 5 seconds, the system said we no longer need to monitor it. Things have returned to an okay state. And so then it stops monitoring the system.
Based on your analysis and review and looking at this data, did you come to a conclusion to a reasonable degree of engineering certainty whether or when this event occurred as it is portrayed in the data?
Yes, I did.
And could you share with the jury, to a reasonable degree of engineering certainty, when did this occur?
So this, you want time-wise or location or both?
Start with location, then time.
So it happened on Cedar Crest. It happened between cell phone data points 154 and 155. And it's a 3-point turn on Cedar Crest. And it occurred, according to the tech stream data, about 12 minutes, 23 seconds after the vehicle was turned on. So,
And do you have an understanding of the variance between the Lexus clock and Mr. O'Keefe's cell phone?
Yes,
And what is that variance time?
21 to 29 seconds.
And so the Lexus clock at 21:23:38, what time would that put Mr. O'Keefe's cell phone?
Objection, Your Honor.
That's not what he said.
Sidebar for Justin.
That's the running clock. That's not what he said. Brennan's not even listening to his own witness. Oh, guys, this has been excruciating. I mean, I'm trying to understand. I'm really trying to understand, and I'm having a hard time. One of the things I saw on that chart that got my attention, but he didn't say anything about it. Something about a yaw rate sensor. This intrigues me because I expect this to be going off like a lot if you're driving in the snow, if it's like slippery conditions and stuff like that. So yaw is when the car like rotates on its center axis, like the back wheels start to like a fishtail. A fishtail is a yaw when the car is starting to rotate in that type of spin direction that you never want your car to go in. You never want the wheels in the back to be moving slowly towards the front of your route, but it does happen. It's a fairly common thing. So it makes sense to me that the car would have a sensor for the yaw rate, like how under control is the back end of this car. It's an important safety feature. Like I said, driving on snow and ice, how often do you fishtail? You fishtail a lot. So I saw that and I thought, oh, that's interesting to me because I'd expect that there would be tons of sensors from that going off if we're doing a lot of long drives through the worst winter storm in January in Massachusetts history. 30 some miles. But I don't know. He didn't tell us anything about that. I feel like some of what he's doing is just communicating what he doesn't really want to communicate. Like we were trying to fit these things together. Yeah, we know that. That's the quiet part that you're not supposed to say out loud. We know you were trying to fit this thing to that thing. We know that's what you were doing. Not that that's where the evidence led you and you just reached that objective conclusion. We know you were looking to try to match these things together and then provided us this justification for why you did it. But you're not supposed to say that. And yet when you say that, now suddenly that's all I really heard. Because this explanation itself about the data and how the data got us there, no, nobody followed that. Nobody followed that. Nobody, felt like they had been taken by the hand and walked through this data and had it presented to them so that they themselves can reach the conclusion, oh, hey, here's when this thing happened and here's what it meant. No, you tried to fit this to this and you gave us a really confusing, non-intuitively clear explanation for how you got to that point. So I just, don't know about any of this. I really don't. If we're supposed to be getting at, we still have the key cycle problem, don't we? If 1164, he said 1164 had the different events on it, and that was Trooper Paul's test. That's only 2 key cycles after Fairview. That's not enough. We still have the problem with you turn the car on and off the next morning to go to Jen McCabe's house and then to John's. You turn the car on and off to go from John's to Dighton. The car gets turned on and off to get put on the tow truck, and then the car gets turned on and off to get taken off the tow truck. You're supposed to you're supposed to have 4 key cycle events in between those things, but apparently you only have 2. And so I still don't know how or if that is going to be reconciled. It would help a lot, honestly, to just make it clear where these timestamps are coming from. Can you put something, a visual on your slide, a picture of a freaking timestamp? I mean, Where did it come from? I know we have a running clock, and I know we have clocks on John's device, John's phone, but where we are getting a timestamp from TextStream is really unclear. It shouldn't be. Just tell me what is recording the timestamp. Where is it? Why is the timestamp associated with some events but not others? I mean, it makes some sense, I guess, that that's how it would work. You're not going to necessarily need to timestamp every single little thing that the car is recording, but you're gonna record some. So what recorded the timestamp? Did I just miss that? I mean, guys, I'm here diligently trying to pay attention, and if I missed it, I don't know that has been made particularly clear. I like the part where he went through and he independently downloaded all of the data so that he doesn't have to rely on other people. This tells me a number of things. It tells me, number one, the chip off data.
I'm going to give you a 10-minute break because we're right through our. So 10-minute break and then we'll go again.
Jurors, right this way. Please rise for the jury.
I'm holding this off to see if they're going to argue more about the Voir Dire and what else they were arguing about this morning, or if they are just taking their break. I suspect it's the break, but we'll see.
Dr. Welcher, we'll be back in 10 minutes.
Oh no, we'll be back in 10. So she's telling him to. So the chip off, none of it mattered, and so Burgess, a big part of his role, I guess, doesn't really matter. I mean, you can just walk up and independently download it. And how did you do that? Did you, by chance, use Burla? Do we have another source now? Because if he downloaded it from the vehicle, in the vehicle, all we've heard about being able to do that so far is you use the Burla tool, and it didn't originally support this Lexus data. But then since then, it's been updated. Mr. Burgess tried to put Karen's board, the motherboard, back together after the chip off, tested it in the exemplar vehicle that they bought, and it worked, but then stuck it back in Karen's car and got unexpected results. So could not get it to work the way it should work in Karen's car. Where does this fit into all of that? Where does this fit into all of that? This would seem to be before that, right? Because Shannon Burgess didn't even get involved until October of 2024. But this guy's out there on September 23rd, 2024, taking his 400 and some photos and doing his own independent download. This data better be identical. I thought Mr. Burgess told us that Burla wasn't very helpful anyway because Burla is just getting diagnostics. It's not getting you the actual raw data. This is all diagnostic stuff. Isn't that what he's explaining? But the whole reason it records these trigger events and stuff is not because it's trying to record events, accidents, collisions, but it's trying to get a bunch of different information about the vehicle performance so that if you have a problem, you can go into the shop and you can say, when I backed out of my driveway this morning, it made this weird grinding noise. And somebody can get in and plug into the system and get the diagnostic data and look at that time and see, is there something that happened then? There's some kind of event that registered that would help us narrow down what is causing your grinding sound as you backed out of the driveway, at whatever time in the morning. So that all makes sense, but how these data sets relate to each other, completely unclear at this point. I don't even know if he and Burgess are relying on the same data. They're not relying on the same data set, it doesn't sound like, because Welcher's using his own independent download. Burgess is using what he got off of the chips. And these things better be the same, but the way that Burgess described it made it sound like it wasn't. He was busy trying to pre-butt what it sounded like Maggie Gaffney did or thought about doing or something, which was to go and, re-extract it using Burla after Burla got the update to be able to support Karen's car. And he's like, poo-pooing that. It's Burla only gives you the diagnostic information anyway. Well, then how did this guy download it? I have quite a few questions about that and what that implies with respect to what are these two different experts for the Commonwealth? Are they even relying on the same thing? Because it doesn't sound like they have. So we had to come out in September of 2024 because it's really important to be able to put your own eyes and hands on the object in the interest of objectivity. He actually really did say that you need to get as much data as possible and objective and so forth. So you need your own eyes on it. Like that's an objective. That's an objective source of information. Oh, the EDR. EDR isn't going to register a pedestrian collision. You guys caught that? The Lexus is 6,000 pounds and John is only 216. So it's absolutely not going to register from hitting a pedestrian. In fact, it's exactly what he expected. It's exactly what he expected, that there would be no EDR data showing any kind of an impact here. It's exactly what he expected. Who buys that? I'm sorry, I don't buy that. I don't buy that. It's going to register. It's enough to damage your car significantly. It's enough to cause injuries on the inside of the car. I mean, yes. It's not going to register. I wonder how many examples of EDRs registering pedestrian impacts are ready and waiting for cross-examination. You think Alessi's gone and read those studies? Because I kind of bet he has. He's probably read a few things about the sensitivity of the Lexus EDR, how it works, what it's picking up, what it's designed for, etc. Now, I will say something that I do kind of buy. I do buy the possibility that the car is not going to register a rear impact in quite the way that it's going to register a front impact. And the main thing I think has to do with the airbags. The airbags are they're going to come out. They're going to notice that, okay, there's been like a sudden stop. You're moving, you hit something, you come to a sudden stop, but you're going to continue to whiplash forward. And so that sudden stop is what the car detects, and it knows, okay, I need to get the airbags out so that the person doesn't whip forward and hit the dash, hit the steering wheel and stuff like that. And I'm sure it gets even more complicated with side impacts, stuff like that. Side airbags, like these systems have gotten so complex. But you don't have an airbag in the back. That's your seat design. You know, your seat is designed to keep you from being hurt if you get rear-ended. Right? Rear end is the opposite mechanics. You're stopped and somebody's moving forward and they hit you. You're gonna jump forward, but you know, your body is your inertia is gonna try to keep you in the same position, so your head's gonna go back. Well, there's no airbag back there. It's your seat. Your seat keeps you safe. So I could see a scenario where the crash detection system and the safety system is not necessarily made to register backing into something the same way as it would running into something head forward. It's just because of the nature of the safety things in place. But that said, then that just takes me back to all of the bells and whistles that are on modern vehicles when it comes to backing. Okay. How many times do cars back into other cars? I mean, it happens all the time. It happens parallel parking. It happens, getting out of the driveway. It's just so common to back into something. And so now we got all these mirrors and all these sensors and the things that scream at you. I don't have it in my car. When I was down in Chile, it was the first time I'd driven a car for like a fairly extended period of time that actually has the whole backup camera in the system, and it tells you, it's got the little gauge like when you're safe and like when it's green and when it starts getting yellow. So like slow down, don't back up hard into that. And it was super helpful because I had this very tight little parking spot. I had to like get in between a couple concrete pillars, and you got to, get it in real carefully and back it in and get it just right. And it's so helpful for that. And this was like a Hyundai or something. Okay. This is not a 2021 Lexus luxury car with all the bells and whistles that car is going to have. So you might not have like airbag types of sensors for a rear impact, but surely you are going to have a whole host of other safety features that relate to a rear impact. Maybe those would just be in tech stream and not in the EDR. I don't know, but I find it awfully convenient that he wouldn't even expect the EDR to register from hitting a pedestrian. Wouldn't even expect it. I would definitely expect it. Boy, now I'm kind of tempted to look up one of the recent cases that I had where, we had a pedestrian collision and we had a accident reconstruction that needed to be done. We had a car seized. We had a bunch of data evaluated. Tempted to look up and see what did they actually get off of this. Now, this was an older, in my case, it was an older pickup truck. So, yeah, they did. They got crash data. Oh, wait, this is a different one. Well, anyway, I find it very hard to believe you're not going to get crash data just because it's a pedestrian. Dude, you hit a deer, it can like kill you. You can have a very serious accident. A deer is not that much bigger than a human. Cause massive damage to your front end. It can get pretty messy. So that, as soon as he said that, I'm just like, nah, I don't buy that. I would buy that maybe it doesn't for a variety of reasons, but you didn't expect it. You're over egging the pudding with that one. You definitely expect it. If there's a collision, you expect a collision to be registered in the EDR, especially if it's a collision that is strong enough to cause damage to the vehicle and to kill another human being, you expect that to be in the EDR. Now, there might be reasons why it wouldn't be, but those would be the extraordinary types of reasons. Once again, wouldn't it? Isn't that what we would expect? So just add it to the list of extraordinary circumstances that all have to coincide for this to have gone the way that the Commonwealth says it went. So much interest in John's vehicle, all the way starting as early as September of 2024. Of course, we know that's not when their interest started, because they had those photos that Proctor went out and took within days of this entire incident, before anybody had watched John's Ring camera video and knew that Karen had backed into his car, right? Well before any of that was available. And yet they knew to go and document the condition of the Traverse. But then this examination of the you take the rear bumper cover off, and there's the face bar and the energy absorber. Okay, you want to talk about things that would not be expected. A little dink would not be expected to do anything at all to a big structural steel part of the frame of the car. Of course, that wouldn't show anything. Of course, that wouldn't show anything. I mean, he's not going to try to suggest there should be some damage there based on the speed of the impact that we saw, that it was enough to potentially break part of Karen's taillight. He's not going to try to say, oh, that bumper, it would have been damaged from an impact like that. Surely he's not. But just kind of leaves the implication out there. Oh, I looked for the damage. There was no damage to any of that structural stuff in the bumper and underlying the bumper. Again, I'm not sure anybody would expect that at that point. So he independently downloaded the data himself. He did all this digital scanning. That map he did of 34 Fairview, I don't even know what we're supposed to make of that. I don't know why you're getting out there and spending resources on creating some type of probably like laser map of the scene when you don't have the kind of detailed information about the scene that sort of map would be helpful to evaluate. I mean, we heard Buchanan say he couldn't even be bothered to tie two pieces of string to the flagpole and to the fire hydrant and use those to give him points of reference to be able to locate the shards of glass and plastic and so forth, the hat, the shoe, all of those things that were discovered out at the scene. They don't actually know where any of them are, because other than the CERT team who took the GPS coordinates for the items that they found, but the GPS coordinates have a range of like 16 feet. And those are the only measurements that they ever even took. Everything else, well, it's just out there, the same general area. What do you need a digital map for? It's not helping you solve that problem of nobody bothered to document the scene and where everything was located. Not even John himself. Just have a kind of general idea. But then when it comes to locating the glass, locating the plastic, locating the shards, locating the hat, it's just there. There's nothing that a map is going to help add to that. All right, guys, we'll do a quick. We're not going to do a formal poll or anything like that, but I am willing to bet they make absolutely zero use of that digital map. We will hear nothing more about the digital map again. Because it was just done to look sciencey and to show us that they did it, but it is so not helpful for anything that they can do that we will not hear it again. It will not come back up. What do you guys think? Yes, we're going to hear about the digital map again. Nope, never again. It won't actually matter. It was just some fancy clothing to put on our case to make it look like we were really doing very diligent, very hard science here. So ignore the garbage in part of the equation when it comes to the scene data. Looks like she might be coming back.
Dr. Welcher, could you take us to slide 30? Could you zoom in a little bit on the right photograph and the text under the right? Okay. You were explaining to us the time relevance of 12:23:38. And could you tell us again, remind us, what is 12:23:38 referring to?
So 12:23:38 is syncing the text stream time to real world time. So we know how long the text stream is on. We know when the vehicle was turned on. So we're adding those two together. So if you add the 12:12:36 to, for example, 11 minutes, 2.8 seconds, or when the end of the trigger is, that gives you 12:23:38. So the end of the trigger in real world time, no longer in the running clock, is now 12:23:38.
Based on the infotainment clock?
Based on the infotainment clock.
And that's from the Lexus?
From the Lexus.
Your Honor.
Sustained.
And where's that from?
The Lexus.
Thank you. The 12:23:58 number, what's the significance of that?
So that is Mr. Keefe's cell phone data at point 154. Again, from the original data we had just at 154 and 155 and not the in-between points. So.
And at the bottom in parentheses, explain to us what that means.
Sure. If you look at where the text stream math works out to be, 12:23:38.8, and compare that to 12:23:58, the difference between those two is 19.2 seconds.
The difference between which clocks?
Between what the text stream infotainment system would show compared to what point 154 on Mr. O'Keefe's cell phone is.
And based on new data, do you now have information about what the variance, the difference is between the clock on the Lexus infotainment and the clock on Mr. O'Keefe's cell phone?
Yes.
And what is that?
Objection, Your Honor.
I'm going to allow that.
You need to advance the text stream clock 21 to 29 seconds.
You need to advance it 21 to 29 seconds for why? Why do you need to do that?
Because the cell phone is ahead 21 to 29 seconds.
After you advance the text stream ahead 21 to 29 seconds, can you then compare the information, the time that's coming from the infotainment system Lexus to Mr. O'Keefe's cell phone from his iPhone?
Correct. That's what you need to have an apples to apples comparison. You need to get them on the same time clock.
Thank you.
This guy's body language is worse than Yuri's. He's lounging here like he's in a pool lounger or something. Got both arms up there.
So I think we left off here. So that's 1162-1. So what we have is we have the cell phone data, the original cell phone data on the right-hand side. And then from that text stream data, you know, we have whether it's going forward, we have the speeds, and we have the steering angles. So from that information, we ran a simulation to show you what the text stream data means. This is what the 10 seconds of data is. And again, just because the simulation stopped, that's just where the text stream data ends. Again, as we showed you earlier, that the car's still moving, that's just the last data point we have. So what that text stream data shows is matching a 3-point turn on that Cedar Crest Street. So we have the vehicle motion, the timing data consistent with the interview statements about making a turn, 3-point turn.
Can you take us back to the data chart and show the 2 points that you just mentioned, the turning? Where is that reflected in the data?
Sure. So you can see
You have to enlarge that. I'm sorry, Doctor.
column N, that's the ship position. So that's looking, we start off going forward right here. And you can see at the start of the simulation, we're going about 9.94 miles an hour. And then as you start a 3-point turn, you generally start, in this case, if you're going to the left, with the left turn. So you can see we have this steering angle here, then the transmission. So again, we have the brake application. So you're coming in, but you're slowing down, and you get down to a speed of approximately 0. 0, shift into reverse, back up, and then start to turn the other direction as you're backing up. So again, you want the rear to go to the right, you turn the steering wheel to the right, right is negative, and then as you start to pull around and pull forward, you turn back to correct for the steering, and so that's what this shows. So again, if you put it all into a simulation program, the speeds, the shifting, the distance, keep in mind we only have that 10-second window of data, and the steering angle for that Lexus, that's what it indicates.
Can you enlarge the photograph on the right with the data points and explain to us the significance of that?
Sure. So again, what we're trying to do is we have the infotainment, we have a text stream. We're now trying to see how that correlates to Mr. O'Keefe's cell phone. So we had originally very coarse data points, 154 and 155. There's additional data points between here. So we're looking at how well does our predicted time compare to those two. So with the cell phone correction, you end up with the text stream data at 12:23:59 to 12:24:07. So that's actually right in between these two data points. And so we know 154 was closest, but it's on the right-hand side of the road. 155 is when it's turned around and heading back in the southerly direction. So the cell phone data corroborates the text stream timing data in conjunction with the infotainment system data.
Thank you. Please continue.
Okay, so we talked about 1162-1. That's the first trigger on the text stream. So we're going to go to 1162-2. So I've highlighted that in yellow. So we're now talking about the second trigger. So this is on the same ignition cycle. It's on ignition cycle 1162. We have that same continuous running clock, but we've now synced it to real world clocks. So instead of the running clock, we now have some information on the real world clock. So at this time, we know the ignition has been on for 19 minutes and 2 seconds. So at the trigger, 19 minutes and 2 seconds. And again, we have 5 seconds either side of that. So between 18 minutes, 57.6 seconds to 19 minutes, 7.5 seconds.
Could you enlarge that, please?
Which part?
That part where your arrow is. You were speaking about the clock. Could you explain that so the jury can see?
Sure. So again, this is continuous from when the time comes on. I just converted it to minutes and seconds here so you can see how long it's been on. This is the mileage. These are the speeds over here. And this is some information on how far it traveled. Again, we have the plus minus on the steering. That gives us some information on the steering. Really, there's very little steering going on at this point. Slight leftward steer.
Dr. Welcher, did you determine how long after the first trigger, that 3-point turn, that this second trigger occurred?
Yes. 3-point turn occurred about 8 minutes after.
You said the 3-point turn occurred
I'm
after.
sorry, this event, I misspoke. 11.2 occurred about 8 minutes after.
After the 3-point turn.
Correct.
Okay, thank you. Can you walk us through this data?
Sure.
Yeah, leftward turn doesn't make a lot of sense, does it? If she was turning while backing to hit John, wouldn't she be turned slightly to the right?
So we have the accelerometer data here. I've highlighted a shift from drive to neutral to reverse.
I'm
Come on,
sorry,
camera
we can
guy.
zoom that in so we can see it.
Absolutely. We have information on the brake switch, brake oil pressure. We have the acceleration data here. And then from that information and using the acceleration data, calculating the speed at which it's backing up. The reason we have slightly different calculations here is we have some evidence that the wheel's slipping on the ground. So we need to use the accelerometer because the wheel speed is simply telling you the speed of the wheel. It's like if you're stationary burning rubber, the speedometer reads a certain speed, but you're not going anywhere. But the accelerometer tells you how much the vehicle's moving. So from all that information, we get information on how far the vehicle's traveled. We've done it in terms of total travel distance. We've done it relative to the start position.
I'm going to ask you to start on the columns on the left and take us through the information that you have regarding this second triggering event. So if you can
Start
scroll all
on
the way
the
to
columns on the left and take
All the
us
way to the
through is not a question.
So the first column regarding time, can you remind us again what that is?
So again, that's the continuous running clock.
And the second column in blue?
That's where I take that time and convert it to what we more commonly use, minutes and seconds.
And now we have a key cycle event, different than the 3-point turn. What's the number?
So this is now 1162-2.
And
So again, it's technically in the system the same key cycle. I've called it 1162-2.
and the red number next to it to the right?
That's the mileage. So it's actually at the same mileage as 1162-1. So we know, we see they're within the same mile.
If you can scroll over a couple of columns. From your data, can you tell during that event how far the Lexus traveled during
Yes.
that event?
Yes.
And how do you do that?
So we have accelerometer data. We have velocity data or speed data back here. I've corrected for what you see down here is, and I go through this on a later slide, but right here you can see a significant increase in RPMs, but yet the acceleration is dropping. So what that means is if your RPMs are going up and the speed's going up, that means you should be accelerating more. But what happens because the acceleration is dropping, that means what's actually happened is the wheel's slipping. So what I've done is I've used the accelerometer's data to calculate the speed once the vehicle is put into reverse. And once we know the speed, again, feet per second, we know every data point is half a second. So speed times time tells you how far you moved. Feet per second, feet divided by seconds times seconds gives you feet. That's how far you went. So you get how far you went in each interval, then you get the total distance traveled. And so this is relative to the start. So 0 is the start. The vehicle goes forward about 34 feet. Then you see it basically stops in this area here, then begins to back up and ends up backing a total of 53 back from where it originally started. So if you add 53 to 34, you get 87. So the total motion, 34 forward, 53 back, the Lexus moved 87 feet total.
Dr. Welcher, when you say the Lexus moved 83 feet total, is that according to the data or is that the entirety of the movement of that Lexus?
No, that's just from when the data starts to when the data ends. So if you look at when the data starts, you can see that the vehicle is actually going 13.67 miles an hour. When the data stops, the vehicle is still going 23 miles an hour. And you can see,
I'm sorry.
you can still and see that it's still at 74% throttle. So, you know, this is 3/4 of full throttle in reverse.
So to start with the distance traveled, if you can go to the top, we see that the speed is 13.67. Is that where the data gets picked up?
That's where the first data point is. Again, the trigger is here. This is 5 seconds before the trigger.
Are you able to tell how fast or slow the vehicle is traveling before that data point of 5 seconds before the trigger?
No.
And likewise, on the bottom, the speed, at the end of the 10-second data points at 23.61, can you tell whether or not that speed stayed the same, increased, or decreased?
I mean, considering you're at 74% throttle, it likely increased. How much, I don't know. And you can see that up here, she's on the brake. Down here, she's not on the brake. And so she's not on the brake and at 74% throttle.
And what is the percentage of throttle that has to be initiated to cause a triggering event?
For a shift into rear and a rapid throttle application is 30%.
If you look at the next column over, if you can go to the top heading for the jury to see the engine RPM data, could you explain that?
Sure. Again, that's the engine RPMs. And so, as I mentioned, you have this jump in engine RPMs and a very dramatic jump in the reported speed of the vehicle. But when you look at the acceleration is actually dropping. So again, that's a telltale sign that the tire is spinning because the vehicle is not being accelerated. And so I've used the accelerometer data. Again, if you just, a process called integration, you integrate the accelerometer data, it will give you the velocity. So what I've done is it's called piecewise integration to get the speed data that takes into account the tire slippage. And from there, calculate the speeds or the position at each interval going across the top here.
If I could stop you at your column that says JBW speed at each time step.
Yep.
If you go to the bottom, please. So does your data indicate that the speed is changing at the end of this 10-second event?
Objection, Your Honor.
Sustain.
Is the speed changing at the end of this event?
Yes.
How so?
Well, again, you can see it's increased about 2.7 miles per hour. And again, we know from what I already stated that that last time step, you're still at 74% throttle and you have 0 brake application.
Is it possible from the data to tell how far the Lexus went forward before it went in reverse in total as far as feet?
Not in total, no. We just have this 10-second window. I can tell you what it did during this 10-second window.
Is it possible to tell how far it continued after the data?
No.
The shift position changes from 1 to 0 to 2. Can you again explain to us what that means?
Sure. 1 is drive, 0 is neutral, 2 is reverse. And then brake switch status, again, a 1 is you're on the brake pedal, enough to activate the brake lights. 0 is you're off the brake pedal.
Each one of those indicators, 1, 0, 2, how much time is for each of those?
0.5 seconds.
So can you tell how long the Lexus was in neutral for?
So again, it only occurs at 1 time step. And again, there's a little timing issue. Like we only have data every half second. You don't know exactly where in that time it was.
Okay, you can continue, Dr. Welcher.
Can you continue is not a question.
Next slide or continue on this slide?
Unless there's something else you want to point out to the jury on this slide.
No.
No, this is like such poor directing.
So
Not how you do it.
similarly, using this information to then try to tie it back to the cell phone data to make sure we have the real-time information. Again, this was written back in January before I got the additional information. So what you can see is, I'll zoom in. Again, we're now talking about trigger 1162.2. We know that that's 18 minutes that the vehicle has been on, 18 minutes, 57 seconds, 19 minutes, 2 seconds. This is the range. Again, the plus or minus 5 seconds. The 19 minutes, 2 seconds is when the trigger occurred. Infotainment system, adding those two together, 12:36, plus the 19:7.5 indicates the end of 1162-2 is at 12:31:43.
That 12:31:43, is it based on the Lexus clock from the infotainment system?
It is. It would need to be corrected to the O'Keefe cell phone data.
And when you reconcile that variance of 21.9 seconds, what is the time?
You end up with 12:32:04. So if you simply take this and add 21 seconds to it and add 29 seconds to it, so you get between 12:32:04
Got it, guys?
and
Just add some stuff to it.
12:32:12.
When you reconcile the two clocks and you have that range of 12:32:04 to 12:32:14,
12:32:12.
I'm sorry, 12:32:12. Does that simply accommodate the window of data, but not before and after?
Correct. So, again, even on John's O'Keefe cell phone, even within his cell phone, there's somewhere between 21 to 29 seconds difference on his cell phone. So even that one piece of instrumentation has some variance to it. So we know it's between 21 to 29
That's not what the
seconds
21
at
to
this
29
approximate time.
seconds means.
So this is taking into account that variance.
It's not the variance
So
within
the
his own
only,
phone.
Time window that you have is based on the data, and that's reflected in the 12:32:04 to 12:32:12?
Objection, Your Honor.
Sustained.
Is there any other window you can accommodate with the data you have other than that 10-second window?
Yes.
What's that?
So I was given information about a final lock event on the phone.
You
let's
already
stick
knew
with this
about it.
window,
It's
if
on
we
your
can.
freaking slide.
Since you only have 10 seconds of data, is it possible from the Lexus clock data to have a larger window than this 10-second window?
No, the text stream will only give you a 10-second window,
Okay.
but it doesn't tell the whole story because the vehicle's still moving.
Understood. Okay, continue, please.
Continue, please, is
So
not
I
a
have
question.
this other event, a lock event, and the information I was given that's at 12, it's 12:32:09. And so we have the text stream data ending at somewhere between 12:32:04 and 12:32:12, which puts this number right in the middle of that, more or less.
That puts
Okay.
this number
Is this a
right
good
in the
place to
middle of
take a
that.
Luncheon break?
Certainly are.
So why don't we do
Pronoun
that?
problems
So
here.
We'll take 45 minutes for lunch.
Is yours right this way?
And again, Dr. Welcher, you can just call
All
it.
right, thank you, Your Honor. Thank you very much.
You are muted.
So Alessi, yeah, could be objecting a lot more than he is to this continue. Continue is not a question. The reason why Hank is just asking him to continue is because Hank doesn't understand what he's saying. Hank doesn't get it. Hank doesn't know what the point is. If he was, he could just ask questions to get him to the point. But he doesn't know. He needs the expert to go up there and explain it all because Hank doesn't understand it. So that's why he's asking these non-questions, if they even are a question. Continue, please, is not a question in any universe. Okay, there's no putting uplift at the end and a question mark at the end that turns that into a question. It's not a question. It is directing a narrative. You're just calling for a narrative presentation. So Alessi is not objecting to this. He could. I don't know why he's not. Being nice, perhaps. I'm not real sure. He's definitely interfering when Mr. Brennan goes in and starts to lead him too much. He'll object to that. But boy, where else have we gotten here? Well, you see, if you just add some seconds to the time, then you get the times that we want, guys. This is a mess. This presentation, it just really looks like a mess. You know, everything fits only when you want it to, but it's totally fine if this didn't capture an actual collision because the data is only important when we need it to be important. And so if it didn't actually capture when Karen hit John, it's just, then it's just the data. I have such a hard time keeping track of when I am supposed to credit the data and when I am not supposed to credit the data. The car will register if you are in reverse and have more than a 30% throttle opening. That will register, but not hitting a human. Okay, hitting a human, totally don't expect that to register in the EDR. And then you do some stuff like a process called integration and you get different things and then you add seconds on. Yikes. Yikes. So you need to correct it to account for John's phone. Why? Because he was given info about the final lock event on the phone. It's on your freaking slide. You were not given the info. That is not why you needed to change it. You already had that info. You already had that info. You already had the info. You put it on your slide. So what even is this? Oh, but the data doesn't really matter anyway, because it might not have even captured. It might not have even captured when the incident happened. It's a mess, guys. The data is good when it supports their theory, bad when it doesn't. And I am not sure that much else has been made clear by this presentation. This is not a good or compelling PowerPoint. It is not a good or compelling explanation of a PowerPoint. It is not assisting with anything. I'm finding this very confusing. I have a hard time thinking this is landing with the jury because it really just sounds like we put some stuff in a chart and half of the chart is blue, meaning it's stuff that I did. And so I'm just telling you, accept this is correct because I did it. Why should you accept me as correct? I don't know. Let's spend 40 minutes on my resume. That's why. That's why. Basically, my read on this is a heavy investment in just believe this guy because he's believable and not because he's good at explaining to you why he's right. If he's right, usually you can explain that and you can explain it clearly, and it's literally your job as an expert witness. Explain things so that they make sense to people who are not crash reconstructionists or biomechanical engineers. They are ordinary people sitting in a jury box who need to understand what you're saying happened and why. But rather than letting the weight of the evidence and the strength of the analysis speak for itself, we gotta try to give him this very, impressive sounding resume, because that's what you're going to have to rely on. Him making sense out of all this? No, don't be counting on that. That is unlikely to happen. So just a little bit more of the, Ipsy Dixit. Why? Well, because I said so. I'm not going to explain to you how I came to that conclusion. Just trust me. It's a process called integration. It's like magic. It's like voodoo, kind of, but with numbers. Just going to tell you we did it, and then take it on faith, guys, because I gave you this resume. I don't need to show you how. That's what was so effective about ARCA last time, is how good they were at explaining things and showing things. Very intrigued by how that particular distinction may play this time. I don't know if we're going to get to cross with this guy today. What do you think? Can they get another 2 hours out of him? Haven't even talked about John's injuries and anything like that. I think we're stuck with this guy on direct for the rest of the day. That's what I'm anticipating at this point. I guess we'll see. Yeah, so we have the backing event that sort of happened, because trust me, some of it was recorded, but maybe not all of it. And we still have to get to John. This explanation has been this bad. John's injuries. Oh, guys, I don't know how well this is going to go. I really don't. Well, a little bit of a short break today. So guys, I am going to do my routine, do my pause, and step out and check everything. Everything's good here. We had a good weekend, got lots of things in order, things taken care of, a lot of stuff prepped for, the week to come. But the trees are constant. They need what they need. I got to go out and do some work on them though this weekend, which is always nice. We're into pruning season now, so got to start managing the growth and so forth. It means that, again, they kind of change how they respond to the climate, because they sweat through their leaves, so to speak. So if you take a lot of foliage out, the plant can't cool itself as well and stuff like that. So just little things to monitor. I will be right back. Thank you guys for hanging tight, and then we will get to some of your comments and questions. So hang out if you'd like, and I will be back shortly. All right, guys. Let's ease back in. Everything's still good here. They started the fan back up in the courtroom, so I guess they're expecting people back at some point, but not quite yet. So, yeah. For all of you hoping I would, over the lunch break, explain how all of this fits together to you, sorry. Afraid that won't be happening. I am about as lost as everybody else. We've had some words and we've had a position being asserted, certainly. But I tell you what I'm particularly interested in is that Voir Dire, why we had it, what it's about, why we aren't hearing any kind of argument about it, what was the outcome of it. Because it sure does sound like there were some more concerns about violating the sequestration order. Because he has now gone in and modified his PowerPoint. And that he did that apparently 8 to 10 days ago. Never probably produced that to the defense. I think we are to infer from the tone of voice there. Acknowledged, yeah, he's changing things in light of Burgess's May 8th report. That should be enough, really, to establish our record of the unfair surprise. The fact that it was a late production, a late change in the Commonwealth's analysis of the data. Hello, guys. If you didn't change anything, you wouldn't need a new report. But I don't know if there is any request that's pending to the court, if this is just making more of their record of what the situation was. She's already, she already ruled. It doesn't the fact that it was produced on May the 8th doesn't mean they can't testify about it. There's no discovery violation. There's no late production, nothing like that. She's already made that ruling. So perhaps they're asking her to reconsider. Perhaps they're just supplementing the record. Perhaps there's a new request that's out there. We just don't know. But I am fairly intrigued by all of these multiple conversations, including several with Tully. There's Tully right in the middle of everything still. Once again, awful lot of conversations these witnesses seem to have with the prosecutors and with the investigators, for the prosecutors and the investigators to not really know what's going on substantively with their testimony and their case. Just a little something I noticed. All right, guys, since we've got the chance, let's turn to some of your comments and questions. Nicole K. Anti-Karen Reed people have said that Proctor did not receive a summons and that the defense won't call him. I don't know. Yeah, I don't know either. There's always gossip out about what's going on in a case. Rarely do I credit any of it. Sometimes we mention it because it's out there, but always kind of try to point out it's gossip. It's not substantiated. We have no idea if Proctor has been properly served or not. If he hasn't been properly served, we don't know if that's because he is evading service or if the defense just hasn't tried to serve him. That to me seems unlikely. I would think that there has at least been some effort. And if the situation has been that they are unsuccessful, that's what's justifying them in asking for these replacement witnesses, assuming that's who they are. Again, rumor, we don't know, but the general rumor out there seems to be that the 4 people on the defense's supplemental witness list that was filed this morning have to do with Proctor in the group chat. So Rob Pate, long break might equal jury person being kicked off. Doesn't look that way. It looks like they were just having a much more extended discussion about what has happened with Welcher and Burgess and so forth. The defense is clearly keeping a close eye on all this and how it's unfolding. I think they do suspect there are violations of the sequestration order, so they're going to keep coming back to this and hitting on it. But I mean, even from when they first started the cross-examination of Shannon Burgess, they had already been watching, right? Last 72 hours, did Aperture take the link down? Last 72 hours, did you get notified about us looking at your LinkedIn? Last 72 hours, did you change anything, etc.? So we kind of know that they've been watching. How are these Commonwealth witnesses responding to what's happening as the trial is going on? Because, you know, if we can make an argument that this is not really coincidental, all these things happen, and then it just happened to go change your slides after you had a phone call with Hank. Not that that's what happened. I'm just saying. I'm just saying that might raise a question about exactly what is motivating all of this and what's the sequence of events that led to it happening. So no issue with the jury at this point. It does appear to have to do with Jud Welcher, his presentation, changing it. Did he hear anything from Burgess, et cetera, et cetera? Louis Pamapui, apologies if already addressed, but thoughts on D requesting absent missing witness instruction, potential risk for closing if denied. Love your commentary. Well, we have talked about it many times over the course of this trial about many, many different things. One of them had been the Sallyport video, you know, the way that it had been selectively drabbed out, and then the metadata. No idea if the metadata was able to be preserved or not. We've had now a stipulation to the authenticity of the Sallyport videos. Does that mean they got the metadata and decided that all of this is legit, or that they just did not get the metadata but are not made a strategic decision not to contest it? We have no idea, and we don't really have any way of knowing that. But I mean, that was one of the things that came up, you know, way back when, as possible grounds for a missing evidence instruction. You cherry pick the stuff. The 43 minutes is gone. The certain scenes, you know, are gone, that type of thing. Particularly then once we had the motion to dismiss, and it came out that, you know, Proctor had been hiding this one in his file, didn't produce it. Lally certified he'd made the diligent inquiry, but apparently, in fact, had not, because didn't get what Proctor had hidden in his file. So those things, would they warrant a missing evidence instruction or some kind of spoliation instruction? That's been on the radar for a while. So it doesn't look like they're going that direction in this trial, because they're just not making a big deal out of the Sallyport video. And that may be because there's nothing to see here, or it just may be that they kind of the Commonwealth was able to run out the clock on the defense's ability to be able to chase it down. I mean, we're getting started with the trial, and we're still talking about the defense's motion to get a forensically sound copy of the video recordings. And they're supposed to be dealing with all that, addressing it, having an expert review it, develop testimony about it while the trial is going on. It's unlikely. And so possible that the clock ran out, possible that they got it, and it doesn't show any kind of trouble. As far as the other witnesses goes, Proctor does seem like the one that is the most likely candidate, that if a missing witness instruction is going to be given, it would be with him. And the reason for that is because typically, if you're going to get a missing witness instruction, you have to prove that one party has like more or better access to that person or to that testimony than anybody else. And so the problem is with most witnesses, well, anybody can subpoena them. Anybody can go subpoena them. You know, he's not uniquely available to you just because he is or was a police officer. But if you haven't been able to, for some reason or another, you know, he's gone on the lam, and you've got your investigator, your guy who's supposed to be doing the service of process, and he's got his testimony about the days that he went out there and the time that he set out there and the steps that he took to try to hunt Proctor down, and Proctor is making himself impossible to find. Now you're probably in a little bit of a better position to argue, you know, no, I couldn't present this guy even though I wanted to. So the fact that the Commonwealth didn't produce a cop that I was unable to get under subpoena because he's evading me, the jury should hear about the decision not to call him. So he does seem like the strongest candidate for an instruction like that. I don't think they would give it for any of the folks that were inside 34 Fairview. If the defense doesn't call Brian Albert, Brian Higgins, any of those folks, I don't think they get a missing witness instruction for that, for pretty much the same reason. Say these witnesses are equally available to everybody. So if you didn't, if you wanted to call them, you could just subpoena them and get it in that way, if it's something that the jury should hear. But Proctor is a maybe. I think Proctor is a maybe. And that's why a little bit of this, just a little more information about the context would be so helpful as far as what we're dealing with here. And is he not showing up? Are we trying to bring the friends in instead? Like what's going on and driving all of this? So that's really my main thoughts about that. Proctor is the best option, I think, if they're going to get an instruction like that. Riri 911. If a witness pleads the fifth, can they still be brought to the stand and questioned? Can a judge exclude questions to prevent prejudice against the witness? This is a lot of it depends. And so because the fifth is very specific, it's a specific right. It's not a general privilege to just not answer any questions about anything. It's a privilege that's designed to protect you from answering only, questions that could incriminate you. But questions that couldn't incriminate you, you don't have any right to refuse to answer those. So it kind of becomes a question of how fundamental is whatever you are taking the fifth on to whatever it is that you're here to testify about. If it's just some kind of collateral issue that's being raised, maybe for impeachment, to make you look bad, make you look like you lack credibility, and you're going to take the fifth on that, that may not preclude you from being able to testify about other things. Taking the fifth on a collateral impeachment issue may not be a problem. But if you're taking the fifth on issues that relate a little bit more to the substance of what you have to say, then there is a much better chance that you are simply not going to be allowed to testify at all, because you don't get to go in and cherry pick what you're going to answer and what you don't. And so usually when this type of thing comes up, you're dealing with it outside of the presence of the jury. You're having perhaps a voir dire. You put him on the stand. You put the questions to him, see what he's going to say about it. If he's going to take the fifth, then the judge may have a conversation with him about, what about this is incriminating? How do we see potential legal jeopardy arising out of the answer to this question? That can be explored because that's for the judge to decide. Are you actually in jeopardy so that you have a right to raise the fifth at all? And then if they do indicate they're going to take the fifth and that is going to be, upheld, they're going to be allowed to do that. You do not do that in the presence of the jury. Like very disfavored to do that in front of the presence of the jury. So you would just, if there's going to be some testimony, but not that, then the attorneys are probably going to be told, don't ask that question. And it would be limited in that sense. Sometimes they might argue we should make them plead the fifth in front of the jury. It's really not a good practice. Certainly with the the defendant's a little bit of a different situation. Defendant doesn't have to, get on the stand at all, but it's just not an inference you're supposed to be making in a criminal case. That because somebody is choosing to remain silent, or because somebody is hiring a lawyer. The other one that came up, I really don't like it. I don't like leaning on Higgins got a lawyer to do the FBI interview. Damn right. And everybody should. There should be no negative inference arising from that. Kind of feel the same about the fifth, but it just becomes a question of fairness. And does that amount to cherry picking your testimony, or even worse, does it serve to bolster your testimony if you're allowed to testify about certain things, but then potential challenges to what you have to say, those don't get to get fleshed out because you're pleading the fifth. That's not fair. So all those things have to be calculated as part of the equation of what's going to happen. Is this guy going to be able to testify at all? Is he going to have to invoke in front of the jury, in response to this question? Is this collateral and we're going to avoid it altogether? It should all be worked out at sidebar. There should be a record of it. Again, this is stuff that could happen in the public eye. There's no reason that, we need to not have it on camera or something. So if questions like that are being fleshed out, it's kind of the process I would expect to follow. We'd have Proctor brought into court. We'd put him on the stand. We'd do a voir dire and we'd find out, are you going to invoke the fifth? If so, to what? And then we figure out what we're going to do from there. Mike Lewis, I've been curious on Colin Albert. Could you please share real quick why he's off the hook? I knew he wasn't in the house at the time of death, but my gut says he is suspicious, bad in trial 1. The worst thing he ever did in trial 1 was come up with that lame explanation for his bloody knuckles and that how he slipped on the driveway and caught himself by the fist. Like no human in history has ever done that, has ever slipped and reached down with your fist to catch yourself. It's ridiculous. When the whole thing was kind of, honestly, that whole line of like suspicion of Colin, to me, it was so weak anyway. It's super weak. This picture is weeks after the fact. His knuckles are scraped up like they get when you hit a heavy bag. You hit a heavy bag without your wraps on. That is what your knuckles look like. So to me, he just looks like the kind of douche who goes and punches the heavy bag, thinks he's really doing something, thinks he's really tough because he's not protecting his hands. But it's like, and then but the excuse for it is what's more damaging than the evidence itself. So what if he punches a heavy bag without his wraps on? Who really cares? I don't know. So, I mean, Colin is off the hook as far as we know, just because Judge Bev said so. She said that there's not enough to kind of qualify him as third party culprit. Higgins and Albert, we don't get to mention them in opening for some reason that also was not clear. But they at least are on the table as potential third party culprits. But Colin is not. What's Judge Bev's explanation? I mean, she didn't give one, so who knows? Who knows? But it's likely has to do with there's no direct evidence either putting him in the house when he said he wasn't in the house or otherwise, involved, particularly in the incident. They have impeachment. They have issues that they raised with the data that the Commonwealth presented in the first trial to try to show Colin was not there. Text message between him and Allie. Allie's Life 360 data shows she's going weird places. That whole story kind of tended to call into question whether he left when he said he left, but it didn't prove that he was there in the house. Just raised a question. So that would be my guess if I'm trying to project myself into Judge Cannoni's mind and where the distinction there is being drawn between Brian Albert and Brian Higgins. Just a lot more direct evidence of Brian Albert and Brian Higgins being there, having motive, etc. So Colin, as far as we know, is off the hook because Judge Cannoni said he's off the hook. And I don't know. I never really considered him super strong in the first place, but is one of those, the cover up is worse than the crime. That stupid answer about slipping and scraping your knuckles because you slipped on the ice. Nobody ever does that. Nobody does that. It's like so well understood when you're like learning to snowboard. I just bring this up because while we're talking about falling down on ice, what happens? You catch yourself. When you're first learning, you fall and you catch yourself. And if you're on ice, you got to be real careful that you don't break your wrist because you will catch yourself over and over and over and over again. And that's just your instinct. Put your hand down, catch you. You don't put your knuckles down. No human has ever slipped on the ice and caught themselves on a fist. ridiculous. Heather Erickson, Michael P. Arico lives on Meadows. Oh, possibly a neighbor? Very interesting. I don't know. I don't know who any of these people are. Lawyer's daughter. I have 4 young adult children, 3 with college degrees, 1 trade of choice. I'd say they'd question both sides. No white hat anymore. Socials flooded with conflict and exposure, used to deciphering BS and finding own truth. Interesting insight into the mind and the culture of a youthful jury. It's just very hard for me to kind of try to put myself in that mindset because I'm not young. But this does make sense to me, especially in the information era where there's anything on the internet, the days when you could just believe something because it's in print somewhere are long gone, long gone. I mean, it used to be if you read it in the library, it was a fact. But now the library has been replaced by this, digital warehousing system that we have for information now. And all of the bad is in there with all of the good, and being able to sort out good information from bad information. Yeah, I would expect that's a skill that people who are younger today, who grew up in the internet era, that they would need to develop well and quickly. It does make a lot of sense. And just also, like you're saying, socials flooded with conflict and exposure. Just socials in general trying to get your attention, the way that they will bait you, rage bait or just whatever. That's got to be something that they're used to, I don't know if they're attuned to it. I don't know if they're mindful of it happening, but just that's a part of the experience that you have if you grow up your whole life on the internet, versus those of us who did not, only started having internet culture later in life. Yeah, I would just expect that would maybe make you a little less prone to those kinds of ploys, those kinds of emotional ploys. Like if your emotions are getting tugged on all the time, are you going to get kind of numb to that? Maybe just not so responsive to that kind of stimulus. I don't know. These are interesting insights. Thank you for sharing that. James Fisher, is this level of downtime typical in trials? It seems a significant portion of each day is dedicated to sidebar discussions. It does depend on the judge. I've read through trials that, you go through trial for several days, never have a single sidebar. It's not necessary. Some judges and some lawyers, it's just how they do it. They want to hack everything out at sidebar. Don't do things ahead of time. Don't do things, pre-trial. A lot of that is personality. So I can't say this is atypical, but it's not ideal is the main thing. This is inconsiderate to the jury as far as they're sitting there cooling their heels in the jury room for like an hour and a half this morning. Just bored, nothing to do, knowing like, hey, we'd like to make some progress here, but you don't get to do that. So it's inconsiderate is really the problem. It's inefficient. It's not uncommon at all for things to just come up in trial. And you have to deal with it when it comes up, especially with a trial that we're in week 6 now. We're in week 6. Crazy. We're in week 6. And so, yeah, things come up and then you just have to deal with it when it comes up. That's not completely unheard of. But yes, to be dealing with all of these arguments and things that seem like they should have already been sorted out one way or another. Yes. I don't think that is particularly typical for use of sidebars. It's just not an efficiently run trial for the most part. 333 Damon, Norfolk County Bar Association awarded Cannoni Person of the Year, most ravaged by drink, given her obvious bias in closing court next day. What message does this send? I saw that went around on the socials. Yeah, Bev got some award. Guys, this is the club. This is the club. This is how it works. This is how the system works. You have a small community. You have a fairly small bar, a small local bar. The people know each other. And this is part of the game. They go and they play their golf together and they sit on their charity boards together and they go to church together. And it's just all part of the networking scene, because somebody who made it up onto the bench is going to have some pull, and they're going to have some networks of their own, some connections that might help you. So it's just all how the game is played. It's very congenial in that kind of context, because it's all just about how can this person help me out? If I'm cool to this person, how can this person be cool to me? So everybody's cool to each other because it might give you some benefit down the road. Going out and calling Judge Bev out in public is not going to get you a lot of reward. Not a lot of incentive to do that if you're some local attorney. A lot of downside. Number one, obviously, you go in front of Judge Cannoni's court. We're going to have to take it on faith that she didn't take that a little personal. But also, you've outed yourself now as you're not playing the game. You're not playing the game that everybody else would play. So, a lot of downsides. A lot of downsides to, going after somebody. It's part of the club. Close ranks and support each other. And that's how the cabal, if you will, maintains itself and its power. Bev sitting on the scales. AJ said it in his opening that Proctor was fired because of his actions in this case. He said it in opening. I just don't remember if it's come out from any particular witness yet, and maybe it won't matter. But just in terms of the jury is going to be instructed, once again, if the attorney said it, it's not evidence. It's only evidence if it's been testified to or if it's contained in an exhibit. So if a witness hasn't said Proctor was fired, technically Proctor was not fired. They don't get to consider that. But it may not really matter if the issue is just, have they been misled? And if they already have this from opening in their heads, then maybe they're, not thinking to themselves, oh, I wonder if he died. So Scotty 262 Runkle brought up, they may think he's dead because Yuri brought up they work in pairs because it's a dangerous job and one can die. I doubt anybody put that much weight on what Yuri had to say about the dangerous job of policing. Maybe. I mean, it's definitely possible, and you never want to assume that the jury knows too much. You never want to assume the jury gets something. If there's any question, make it explicit and repeat it a few times just to be sure. Like things that are really important, they bear repeating. So if they haven't heard, from any witness, let alone from multiple witnesses, Proctor was fired for misconduct. Proctor was fired for misconduct relating to his actions in this case. Then, it may not sit with them. But, you put yourself in the shoes of a jury and you're wondering what's happened to Proctor. Would you think they'd tell you if he died? And surely they would tell you. Unfortunately, he can't be here. He had I might expect that they would tell me that if I was sitting on a jury. And so if they didn't tell me that, I'm not going to assume he died. But I don't know. It's a possibility. I don't know that it's like the biggest worry ever, but it is worth making it explicitly clear. Take that off the table. Proctor was fired, period. AK, if the lawyer in the opening talk about a very important key witness, but that witness dies during the trial, can the defense tell the jury why they didn't hear from the witness? Only if they have a witness testify to it. So you could put on, like, if you're the Commonwealth, you could put on your lead detective at the end of the case. Yes, lead detectives really are a thing. You put on your lead detective at the end of the case. And they often do this. They'll bring on the lead detective to kind of summarize, here's all the different pieces of the investigation that you've already heard about from these other witnesses and so forth. And then based on that, I went and arrested, Karen Reed, and that's supposed to be the climax or whatever. And so we're done, right? The arrest is the culmination and the conclusion of bringing everything together. But if you have a witness like that, who's kind of the hub for all of the information, then you can just put them on. Be like, yeah, the witness died. We set an opening. Unfortunately, the witness died. They can testify to that. And then the jury would be aware. But the attorney cannot just on their own announce, not going to hear from this witness, because you'd have to have somebody testify to it. But usually it's not too hard to figure out how to get that done. Bev sitting on the scales. Anyone see, does Bev have her award on the bench? I didn't see it. I didn't see it. Don't know that she's necessarily all that proud of it. We can't even see it up here on her dusty bookshelf. Mike 67C is gifted 20 more Andrea Burkhart memberships. Thank you so much for that. Mike 67, some good stuff. Appreciate you sharing the green. Anthony Miller, could Proctor be taking the fifth? Possible. That would make him unavailable for purposes of testimony. That would open the door to potentially using his prior testimony. We talked about this a few different times. My initial thought was, well, hasn't he waived the fifth by answering the questions in the first trial? But then I'm like, no, because each time you testify, it's a separate potential crime. So each act of being called to the stand is a new potential jeopardy that you're placed in. So I do think he could invoke the fifth, in terms of he hasn't waived it by testifying in the first trial, but it just means that they would be able to work around that, either with his previous testimony, possibly bringing in other witnesses and so forth. So it's possible. Ellen Victoria Olson, no. But weirdly, Canoni's comments about only medical doctors can testify to injuries was not in the transcript, but only on video. That was curious, wasn't it? I remember that from the motion. I think it was one of Mr. Alessi's pleadings, where they dropped it in a footnote. They had to put in a link, a hyperlink to the timestamp on the video where that testimony took place, but it was not on the transcript. Yeah, that raises some red flags. A lot of reasons why things like this can happen. If you don't have a live court reporter, somebody sitting there in court doing stuff, and they're just working off of a recording device, it is possible sometimes the device cuts out, or the mic cuts out. You can't hear something. It becomes inaudible. Usually there's a notation for that, though. It doesn't just get straight out, deleted from the transcript. But that's not our situation anyway. We've got live court reporters here in the courtroom. And so what sometimes happens is there can be sort of questions about when is court actually in session and we're on the record and we're taking stuff down, versus court is no longer in session and we might still be speaking, but we're not doing court business. It's not part of the record. And sometimes that line can get a little bit blurred because you're still talking about the case. And maybe you've said we're off the record, but you're still talking about the same thing. So, those types of things can happen as like mix-ups, but that's not really what the context of this one was. That's not how that happened. Not how that happened. So, yeah, stuff not being in the transcript is not good. That is not a good sign. And that is part of why it's such a blessing for the defense, really for both sides, but it just seems to have worked out to where it benefits the defense here to have this live stream. You've got overlapping layers now of record that you can go back and refer to. You have it on YouTube, you have it on the FTR recording, and then you have the live transcriptionist there in court. So a lot of ways to double check what's being put out there and represented as being the record in the case. So yeah, I remember this. You're absolutely right. It did happen. It was disturbing, and it doesn't bode well for the cleanliness of the trial process. How is it that just happened to not be in the transcript? Wouldn't we like to have an evidentiary hearing about that? Ask some questions about that. Amanda Lang, is it possible that they wouldn't subpoena Proctor if he invoked the fifth re any new areas of inquiry, or is a subpoena needed before any invocation? You pretty much need the subpoena no matter what, because you need to protect your right. And somebody can say, I'm going to plead the fifth, but not actually intend to plead the fifth. And when push comes to shove, they might actually testify. So you really need to get him under the subpoena, even if he says he's going to take the fifth, because he needs to do that on the record in court. We need to have a record of it in court that that's what's going to happen, because it has legal significance if he does that. And it has consequences for, what does that mean in terms of his prior testimony and bringing in other witnesses and so forth. So no, I don't think they would just not subpoena him if they thought he was taking the fifth. It's in some ways like more reason to subpoena him. Make sure he gets in so that he's on record and you've got it nailed down one way or the other. Melanie, I can't believe this man is risking his career to try to say a car did this. I'm honestly in shock. Guys, he's not risking his career. I hate to be the bearer of bad news on this one. But no, a person who will take money to advance a position that the client wants will be in demand as a client. That person will be in demand as a client. Somebody who will come up with a theory, who will, find ways to organize data in a way to support it, reaching the conclusion that he wants it to reach, who will tweak it this way, tweak it that way, add a few seconds here, stretch out this event because it's not necessarily the same as the data being recorded. That person's going to be in demand. In demand. Because anybody who's got, I got this tough case I got to work on, I don't know how I'm going to do it. Maybe this guy will be able to dream up some kind of defense for my rock solid case. Dan Greenwood, I thought Rolf Harris had passed. Might just be a UK reference. Sorry, chat. Also, loads inside spine made me laugh. What made me laugh is, honestly, cadaver studies with load and stuff like that. It never really made a lot of sense to me to use cadavers for things like crash testing and stuff like that, because they're dead. They're dead. They're behaving like dead people, not like alive people. And so how alive people are going to shift their weight and compensate and things like that for loads is going to be different than what a dead person is going to do. I don't really understand that. I'm sure there are smart folks in the chat who can set me straight, tell me why using a cadaver as a crash test dummy makes some kind of sense. Just intuitively seems very off to me. Not that there isn't stuff you can learn from cadavers. There's a ton you can learn from cadavers, but in terms of human motion and forces and things like that, yeah, I'm much more limited, much more skeptical of that type of thing. Audrey Sova, this man is not a real specialist. He's defending his base research, not his ability to analyze something independently. We spent 40 minutes on his resume and his publications, none of which seem to really have anything to do with the subject matter of this case. He's a guy that is a professional expert witness. This is really what it sounds like. He built a company being a professional expert witness. He sold it to another company, and now he just works for a company as a professional expert witness. So I mean, I don't know why we picked him out of anybody else in the world. He doesn't seem uniquely qualified. If we were just looking at his research history, his studies and things like that, no, you wouldn't be like, oh, that's the guy to look at the. I mean, unless it's just the sideswiping. He wrote a bunch of articles with sideswipe in the title, and so maybe that's it. Maybe that's enough to make him an expert. Guys, I think that's where we're going after lunch. I think once we get back here, and she's taking her time today, taking a little bit of a longer one, I think we're going to be getting into that side swipe. And if you thought the data this morning was aggravating and incomprehensible, I can't wait to see. I can't wait to see what this side swipe explanation amounts to. Young Black economist Jud has no publications listed on his CV. I don't think I remember. I know his CV's been filed. I don't remember seeing it. I wonder if maybe they just left that out. A lot of times the publications are like the end. You know, sometimes many pages of a CV will all be publications. And so I could see it like maybe being filed without that part. I don't know. Alessi didn't dispute it, so I think he probably does have publications. Young Black economist, but does have on Google Scholar, unlike Ian and Shannon. So if we look him up on Google Scholar, Judson Welcher. Yeah, there he is. It looks like human subject kinematics and electromyographic activity during low-speed rear impacts, human occupant kinematic response to low-speed rear end impacts, lumbar facet joint and intervertebral disc loading during simulated pelvic obliquity. And that's going to be all of my reading for today. A lot of it, too, sounds like it's just kind of repeating a lot of the same that is what it said. I just read it. I don't tell you what it means. I just read the words out loud.
Dr. Welcher, when we left off, you had given us your opinion on this slide. Could we proceed to slide 35, please?
Slide 35.
I believe the next slide is 35.
Correct.
Okay. Now, when we look at this slide, I'm going to ask you to zoom in, and if we can start from left to right, and we can identify each category as you discuss it and explain to us the importance of the columns.
So we already touched on this from left to right. The first column is the continuous running clock. Second column is where I converted it to minute and seconds. You can see we're on trigger 1162.2. This is the second trigger. The particular boxes that are highlighted are where there's change. For example, in the upper right, when you're transitioning from drive to neutral to reverse. And then I already discussed this a little bit, but where the wheel's slipping, you can see you have high acceleration pedal application, increase in the RPMs. But when you look at the effects on the vehicle, you can see that it's accelerating less. So that's indicative of slippage of the wheels. And then I simply show at the bottom the math I use to derive all that. So again, we touched on most of this. It's the same slide you saw before, just to show how corrected for the speed.
If you could zoom in for a second, I want to ask you a question about the RPM column.
RPM column, go ahead.
If you could zoom in.
Oops.
You see in the last line, the last piece of data captured, the RPMs changed from 3,200 to 3,300.
Correct.
And the accelerators is, if fair to say, is that depressed? What's the way you characterize that?
Objection, Your Honor.
Sustained.
How would you characterize 74? What does that mean?
I mean, it's 3/4 of full throttle. It's 74% of full throttle.
If above it's 74.5, it drops to 73.5 and then back to 74, why is the RPM higher than above?
So there's, again, this data is referred to as being asynchronous. You're reporting it at particular times, but the computer's scanning the network for the data. So it's not all on exactly the same time step. Not only that, but there's frequently, I'm sorry.
Sorry.
There frequently is a delay from when you step on the accelerator pedal to when that translates to increased RPM at the engine. It takes a little time to build it up or take it down.
Okay, thank you.
You're welcome.
I hate his "you're welcome." I wish
So
he would
similar
stop
to what we
doing
did on
that.
the first one, basically what we did is we took all the tech stream
It's worse
data
than lounging
that
in
we
a
had,
beach chair like
which
this.
includes the shifting, the forward, the reverse, and the steering. Again, there was a tiny bit of leftward steer, and put that into a simulation program where we're simulating what the Lexus will do. So we've taken into account the mechanical characteristics, the steering response of the Lexus. So this is to show what it represents on the left-hand side. So each one of these little hash marks, a different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, initially pulled forward, then backed up, past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. And then it accelerated in reverse, past its initial starting position, and came to rest right there.
Doctor, when you say it came to rest there, do you
I'm
have
sorry.
data that the defendant's Lexus stopped there?
No, it did not come to rest. That I misspoke. That's where the tech stream data ends. As you can see here, it's still going. It's still going
So your visual
approximately
is trash
23
is
miles an
also
hour
what I'm hearing.
when that ends. God damn it.
You'll have to zoom in on that so the jury can see what you're referring to. Please.
So again, as I mentioned, the tech stream's taking a window of data. It doesn't take anything outside the window. You can see that when we account for the wheel slippage, that the vehicle at the time of the last data point, again, is at 74% throttle, 3,300 revolutions per minute, and is going backwards approximately 23.9 miles per hour. And you can see it's traveled a total distance backwards of 53 feet back from where it initially started. Or if you consider where it pulled forward 34 feet and then backed up 53 feet, add those two together from the point it pulled all the way forward.
How about if we subtract? It means she went 20 feet beyond where she started when she backed up.
So this is 10, 20, 35 forward. And then I'll go 10, 20, 30, 40, 53 back for a total of 87 feet. So from the maximum point I pulled forward to where it backed up, again, that was 34 feet forward, then a total
Wasn't
of 53
the worst
back,
presentation I
total
think
travel
maybe I
distance
have
of
ever
87
seen.
feet. So went all the way forward where it stopped, it then backed up 87 feet. And when the tech stream data stopped, it's still moving. It's still moving about 23 miles an hour, and you're still at 74% throttle and 3,300 revolutions per minute on the tachometer, RPM gauge.
We could turn the light on for a moment. Dr. Welcher, in your analysis of the data and the information you acquired and the evidence that you relied upon, did you come to some conclusions and opinions regarding the defendant's Lexus that evening?
I did.
As part of that opinion, you mentioned that you considered mileage to map distances as one way of mapping the location of the vehicle. Do you remember that?
I do.
If you could provide us with slide. I believe it's slide 25.
Yeah. Amateur hour here.
And could you widen the left-handed box a little bit? And you mentioned you measured or you ran information about distances between different routes,
Correct.
specifically regarding Fairview to Meadows, the first box. Do you see that?
I do.
There are 3 different mileage numbers.
Yes.
And then there's streets to the left. Can you explain what's set out in that box?
Sure. It's basically 3 different routes you can go. Sherman Street, Pleasant Street, Washington, and Sherman Street.
These
When
are
you
just the ones
considered
Google
the
gave you.
shortest route, 2.3 miles on Sherman Street. Did you attempt to determine how long it would take to travel 2.3 miles, how fast the car would have to be moving or how slowly it would have to be moving to travel 2.3 miles in 4 minutes and 15 seconds?
Yes.
And what did you determine?
So to go 2.3 miles in 4 minutes and 15 seconds, you would need an average speed of 32.47 miles an hour.
What if you took the longest route, 2.8 miles, and you considered 2.8 miles in 4 minutes and 15 seconds? Did you make a determination?
I did.
Could you share that with the jury?
It's 39.5 miles per hour.
Is that what the average speed of the Lexus would need to be to travel that distance in that
Correct.
time? Okay.
This is so out of
Now,
order
turning
of
to your
anything.
study of these
Hank,
tech stream events, do you have an opinion to a reasonable degree of engineering certainty how many triggering events occurred? How many triggering events occurred in that ignition cycle 1162?
Objection, Your Honor.
I'm going to allow that.
In 1162, the tech stream recorded 2 triggering events.
And do you have an opinion as to the type of triggering event, the type of movement of the defendant's Lexus in those 2 triggering events?
I do.
Regarding the first triggering event, 1162-1, do you have an opinion to a reasonable degree of engineering certainty what type of event the first triggering event was?
Objection, Your Honor.
I'm going to allow that.
The actual trigger was excessive rearward acceleration. The event was during the course of a 3-point turn.
And do you have an opinion to a reasonable degree of engineering certainty the time between triggering event 1 and triggering event 2 in that cycle 1162?
Yes.
And could you share with the jury your opinion to a reasonable degree of engineering certainty the
Engineering
time
certainty.
between those 2 triggering events?
Approximately 8 minutes and 5 seconds.
And do you have an opinion to a reasonable degree of engineering certainty as to the type and triggering event of the second event, 1162-2?
I do.
And could you share with the jury your opinion to a reasonable degree of engineering certainty the type of event to that second triggering event?
Objection, Your Honor.
I'm going to allow it.
It's, again, the trigger event itself was a transition into reverse and then high throttle application. It's a forward motion followed by a lengthy high-speed rear impact or rear motion.
Your Honor, I'm going to move to strike that portion of the answer.
Yes, I'm not going to highlight it.
That's
So get the answer again.
Would you like me to ask the question again, Your Honor?
Yes.
I'm not going to
because we
highlight
see
it, so
yes,
ask the
right?
question again.
I'll strike the previous answer. Go ahead and ask the question again.
Okay. Do you have an opinion to a reasonable degree of engineering certainty as to the nature of the second triggering event, 1162-2?
Just for the record, Your Honor.
Yep.
Yes.
Could you share your opinion with the jury?
The triggering event was high throttle opening in a transition to reverse. It's a forward motion followed by a higher speed rear motion. And at the end of the trigger event, you're still at 74% throttle.
Do you have an opinion to a reasonable degree of engineering certainty the entire distance captured in that 10-second window during the backing maneuver or 1162-2?
Do I have an opinion about it?
Do you have an opinion to a reasonable degree of engineering certainty about
Yes.
the entire distance that is captured in that
Forget your
10-second
script, dude.
window of the second triggering event,
Engineering
1162-2?
certainty.
So it obviously only captures what's going on during the trigger. It doesn't capture before or after the trigger.
Understood. Do you have an opinion as to just what is captured as far as the distance?
Yes,
And what is your opinion?
that it's 87 feet. So again, the initial forward motion is 34 feet, followed by it backing, crossing the initial point, and then backing up an additional 53 feet.
And finally, regarding this part of your analysis, do you have an opinion to a reasonable degree of engineering certainty as to whether the defendant's Lexus was decelerating, accelerating, or remaining the same at the end of that data captured at the triggering event 1162-2?
It was accelerating at 74% throttle.
In addition to your analysis of the tech stream data, one final question. Do you have an opinion to a reasonable degree of engineering certainty the relative time this backing maneuver occurred with the defendant's Lexus that you just spoke about?
Yes,
And could you share with the jury your opinion to a reasonable degree of engineering certainty?
sure. It matches the window of the cell phone data for Mr. O'Keefe that puts it in front of 34 Fairview. So the backing event occurred somewhere between 12:32:04 and 12:32:12.
So I
end
now
of the
want to
event.
turn to a different part of your study of this case.
Okay.
Yes, let's start talking
At some
pirouettes.
point, did you try to determine whether there was an intervening event that could have caused damage to the defendant's right rear
Oh, no.
tail light
Gotta get to the
separate
traverse
from a collision
first.
at Fairview?
I did.
Objection, Your Honor.
So the form of the question, Mr. Brennan.
Okay. At some point, when you looked at the data and analyzed this case, did you consider including or excluding evidence, or did you analyze evidence to reach a conclusion, including or excluding whether there was an intervening event that caused damage to the defendant's Lexus right rear tail light?
Yes, I did.
When you started your analysis, what information or claim or evidence did you become aware of that you want to analyze to include or exclude as the cause of that damage?
Sure. So my approach to this case is three prongs. I'm looking at the downloads, the technical information. I'm looking at this backing incident, and then I'm looking at Mr. O'Keefe's injuries and how they relate to the events, potentially. So the second prong, which is looking at this data. So I had a Ring doorbell video showing Miss Reed backing the Lexus out of Mr. O'Keefe's residence at approximately 5 o'clock in the morning. And so we wanted to look at the backing activity and whether that backing, contacting Mr. O'Keefe's vehicle, whether that was sufficient to cause or what damage it could cause, and particularly was it sufficient to cause damage to the right rear tail light of the Lexus.
When you were asked to engage in the study, were you ever asked to reach a certain conclusion?
Never.
Was there ever any influence other than the data and facts on your analysis?
Your paycheck.
There's never been any influence. The influence, again, it's
Don't try
whatever
to
the data
pretend your
shows.
paycheck doesn't
When
influence you. We all know it
engaged in
does.
whatever studies you undertook that you'll explain to the jury, were you given any direction or limitations on what you could or should do?
No.
When you received the information, did you understand, regardless of the result, it would be provided to everybody?
I guess generally, yes. I mean, I go through the data, I give you the results, you do with them whatever you see fit.
And in this case, when you decided to engage in that study, had you had an opportunity to review the ring video footage from Mr. O'Keefe's home on the morning of January 29th, 2022?
Yes.
Tell us how you went through your study, how you began, and the steps you took, please.
Sure. Probably be best on the slides. So one of the things we first did was to get an exemplar Lexus. What does
Yeah.
exemplar mean? It just means I got the same exact year, make, and model vehicle as Miss Reed. So Miss Reed's vehicle is on the left-hand side, taken during my inspection. And then I found this exact same year, make, model, manufactured the same plant, everything Lexus in Texas. So even though it looks like a European plate, it's a Texas plate. Purchased the vehicle, had it shipped out to California. So I verified that the Lexus is in fact the one I got, the same exact one as Miss Reed's. These are all the standard equipment. Miss Reed's is on the left. My exemplar is on the right. It says Reed Lexus TIS, that's Toyota Information Services, or Toyota Information System. So I ran it through TIS, which is the umbrella program under which TechStream runs. I also ran it through My Lexus, which is the Lexus website. And then started about doing what's referred to as a photogrammetric analysis of the video.
Can you explain to us what a photogrammetric, help me with the word, photogrammetry?
Photogrammetric. We're doing photogrammetry is a photogrammetric analysis.
What does that mean?
It's just a big fancy word to saying you're looking at data and photographs. And what we're trying to do is take two-dimensional images, say you get from video or photographs, and knowing some information about the photographs and some of the dimensions of things in the image, get or convert it to a three-dimensional space. In other words, be able to get exact three-dimensional measurements out of that two-dimensional image. So I had the video, just to show the provided video that I was given. So Mr. O'Keefe's vehicle. I don't know if you noticed, but there actually is contact between the vehicles.
Yeah, we know.
So one of the first things we wanted to do is determine the frame rate, which is how many video frames are played per second. Your normal kind of video camera has about 30 frames per second. Your standard movie is 25 frames a second. You know, a modern IMAX is like 60 frames a second. The frame rate of the camera, how many images it shows per second, because video and films are just single images played really fast, so it looks like motion. And so determining the time between each frame tells you how much time occurred. So if we know the time between each frame, and then we can figure out how far the vehicle moved, distance divided by time is speed. So we put it through a couple different programs. This is called AMP5. We got 19 frames a second. This is a specific forensic program called Axon Investigate, 19.8 frames a second. This is a publicly available program called FFMS. Same thing, 19.8 frames a second. Another program, Media Info, 19.8 frames a second. Anyways, 5 different sources, we're getting 19.8 frames a second. So then what we've done is add information now. So now that we know how many seconds each frame represents, we now put a clock back in to tie that into time. So it's the same exact video, except we have a frame counter now, and we have a time. So we have some information now on the time between each frame. So here's frame 0. This is frame 265. We're 13 seconds into it. Here's frame 305. Notice you see brake lights on the back wall here. Notice how they're not super red because you still have reverse lights on. Now they all go off. So the Lexus brake lights have been turned off at frame 353. 356. I say brake lights begin to come on. 357, they're back on. Lexus comes to a complete stop at frame 369. 384, the reverse lights turn off. So now look how red this is because we no longer have the white reverse lights in it. And you can see the Lexus starts to drive forward. So frame 825, this is after the Lexus has left the scene, but notice the tracks in the snow. So we have very definitive locations for the wheels of the Lexus. We lay over a grid on the various frames. So we then took the images and did what's called clarification, which is where you overlay images from multiple versions or multiple views of the same vehicle, and it helps sharpen the image, but it slightly dulls the color. So you get a little cleaner, crisper image. So here's Mr. O'Keefe's vehicle before clarification, after clarification.
Excuse me, Your Honor, pardon my interruption. Could we get numbers of the slides as we're toggling back and forth?
Sure.
Which one is that?
Absolutely. Okay, I'll make an effort. So
Looks like a
slide
little
76,
deformation
You're
in the
welcome.
snow in the bottom
going to
part of
slide
the bumper
77.
down there.
We're going to focus in on this area here. So what we will actually show is where the snow was displaced in these two spots, the spots right across from here and right across from here. If you could focus your attention on those. Slide 77. So slide 78. To bring us all together, we went out to Mr. O'Keefe's residence and took a scan, a laser scan. So you see the laser scanner over here. Laser scanner is right here. Fence hasn't changed position. The camera's changed a slight position. We can account for that. So here's the subject video. We have the correct resolution. There's a new camera. It's going slightly faster frame rate. That just means we have different times between frames on the new camera, but we're simply using it for calibration to the old camera. It's the same container for the MP4, and it's using the same video codec. A video codec is how the computer encodes the video.
Next slide number, please.
Oh, yes, thank you, Your Honor. Slide 79. Slide 79, part 2. So really, we care most about is the resolution. So slide 80, you can see these are what are called control points. So from the laser scan, we locate these various points. So the 3D scanner knows the exact position of all these points on slide 80 in the image. And so what we can do is use this information in conjunction with the video to create a scaled version of the video. So when we have three-dimensional images or three-dimensional measurements, we can then use that to give us some three-dimensional information from our 2D video. So there's the points on slide 81. Slide 82, excuse me, slide 81, second part, we're basically just fading in. So what you see now, if I go back to the beginning of slide 81, this is the picture from the video camera. And then what you see here is, which is barely any difference, and that's because what we've done is we've now overlaid the points from the laser scan. So now each one of these little speckly points, we know the exact 3D coordinates of those. So we can now know the exact position of all these fence posts, all the positions on the driveway, and we can use that to calibrate. Going to slide 82. So using that information, it's called solving for the camera. We verify that we have appropriate residuals, meaning we don't have too much error. Slide 83.
Definitely don't
Okay,
want too much
subject
air.
video.
Take the air away from this guy.
Then this is the subject video with the control points overlaid on it. That's the subject video where we're phasing in the laser scans of the scene, 84. So this is both on slide 84. I'm just toggling between the point cloud and the video. And what I'm trying to illustrate is how well we were able to overlay the point cloud onto the video data. So for example, if you say watch one of these fence post points
Am I
up
supposed
here
to go, ooh,
while I toggle between the video. There's a laser scan. There's the video. So we've done a good job. Again, the residuals show that we've done an adequate job of matching the data.
Good
Slide
job or
85.
an adequate job?
So what I'm doing here is toggling between, this is the video of the car. And remember I told you I went out and I inspected Mr. O'Keefe's vehicle and did a laser scan of it? So we're now taking that laser scan of the video, or excuse me, of the vehicle, and overlaying it onto the car in the video. So this is the video image. That's the laser scan laid on top of it. So we know all the dimensions in the laser scan. We know all the dimensions in the scene of this. We have the tire tracks. We can create and take data points along the tire tracks. Create a map of those. So green is the right rear. Again, the vehicle's backing out, coming, slide 87, coming out this direction, backing here, stopping, pulling.
It's going to change the orientation for some completely unknown
Pulling
reason.
forward towards the bottom of the screen.
Going to shift
backing
it a
out
good
here,
45, 50
pulling
degrees
forward
to
like
the
that.
right. Why?
88.
I don't know.
So this is the Lexus lined up. This is when the Lexus has come to a complete stop. So this would be maximum engagement. Again, this is just toggling frame 88, showing that we have the time and the frame number. 369 on the same slide. We've now overlaid the Lexus laser scans on top of the image of the Lexus. So there's the video image, a still image that we took from the video. And here's where we overlay the laser scan of the Lexus. So we've overlaid the laser scan of the Lexus onto the Lexus. We've overlaid the laser scan of the Chevrolet onto the Chevrolet. And we've overlaid the laser scan of the scene onto the scene. So now what that allows us to do, we now know the position of everything in there. And we've also tracked the position of the tire tracks. So that's what it looks like if you overlay the computer model of Miss Reed's vehicle onto the tire tracks.
Slide over, please.
Oh, my apologies, Your Honor.
That's okay.
Slide 89, and then I'm just toggling slide 89 where I turn the vehicle off so you can see how the tire positions match up. Another toggle of slide 89, how the tire positions line up with where the end of the snow was. From all that information, again, we lined it up in the video, we lined it up in the scene, we have the two vehicles. We can get the exact position of the vehicles when that Lexus stopped. So when that Lexus stopped, that's going to be the maximum engagement.
What about when the Traverse's
So
wheels
from that
move?
information, we can get the angle of the vehicle,
That seems like the important
we can
point
get the
to me.
degree of overlap, the impact configuration. And it's hard to see because of the angles and because these vehicles are not at right angles to each other. The exact contact. Now I mentioned, and we're on slide 94 now, that contact on the rear of the Chevy Traverse. So you can see we actually, I mean, you can't see. So we took a whole bunch of data points within those two areas where the snow got dislodged. And we're looking at where that is. So if you look at that on the vehicle, so this is where it is on the rear of Mr. O'Keefe's Chevrolet. You can see it's about 25 and a half inches above ground, 32 and a half inches above ground. Here's Mr. O'Keefe's vehicle. So these marks are kind of, this is the Chevy Traverse words, are approximately right here. Again, I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle. We then mapped that data onto Miss Reed's vehicle to look at where that height is. So you can see the only contact marks are down at the bumper level. I mentioned how that bumper sticks out. This is exactly where you'd expect it. So the only evidence of contact is nowhere near the upper taillight. I emphasize the word upper taillight because it is right in line with the lower taillight, but yet the lower taillight also was not broken. So again, 25 and a half, that's 24 right here, 25 and a half. That's 24 right here, 25, 25 and a half. That's right where that scuff mark was.
What are we 25ing?
It's also right at, again, the level at the top of that light. This light is not broken. I've looked at the front of it. I've looked at the back of it. I've looked all around it. It's not broken, and it sticks out further than the light above it. So using those positions, matching the overlay of the vehicles, we can get the speeds from that. We know where the Lexus is. We know how much time it is between each frame. So we know how far it moved. And so what we know is that when it first came to a stop, right before that, it was going about 0.7 miles per hour. So realistically, somewhere between 0.5 to 1 mile an hour, just to account for some variations, but definitely going 1 mile an hour or less at impact.
Slide over, please.
Oh, thank you, Your Honor. Slide 99. That's the dimensions. Slide 102. Similar to what I said, no damage to that light, no damage to Mr. O'Keefe's Traverse in that area. And then if I could, I would like to go back because I realized I skipped over something. So this is slide 85. So this is Mr. O'Keefe's vehicle before contact.
You don't know your own presentation either, huh? I thought you guys just went through this like a few days ago, a couple of times, because that's when you talked to Hank. Haven't you guys been through this a bunch of times? But even you don't know your PowerPoint.
I don't know what happened this time.
I don't know, guess you changed something. Perhaps you don't remember.
This slide shows that there was snow here, now there's no snow there.
Dr. Welcher, did you look on the driveway after the touching between the two cars to see if you could see anything on the snow at the back of Mr. O'Keefe's vehicle?
He's not even listening to you at this point, Hank. He's stuck in his own world, trying to sort out his presentation.
So referring to this slide, this is after the Lexus has pulled away. Looking in the snow, I see nothing in the snow.
Were you looking for anything in particular?
Of course I was. I was looking for taillight fragments.
In any of the videos that you have that show Mr. O'Keefe's vehicle after the defendant's Lexus touches it, do you ever see any remnants or shards or fragments of taillight?
You're going
on
to
the
tell
ground?
me
I do
that
not.
quality video in the dark. You're going to expect to
When
see
you
something
did your
small in the
analysis and study,
snow.
trying to include or exclude this touching as the source of damage to the defendant's Lexus rear right taillight. Did you consider speed as part of that analysis?
I did.
That's the question.
Did
I
you?
consider speed, and then again, knowing we have the positions of the vehicle, we looked at the degree of overlap, and there's only about 2 to 3 millimeters of overlap between the vehicles, which is insufficient to cause the tail light that's recessed in from the edge on the right rear of the Lexus to contact the rear of the Chevrolet.
Considering all the data and analysis that you did you come to a conclusion to a reasonable degree of engineering certainty whether the right rear taillight of Miss Reed's Lexus was broken or damaged during the contact with Mr. O'Keefe's car at around 5:07 a.m. on January 29, 2022?
That impact did not break or crack that taillight.
Is that your opinion?
That's my opinion.
Is that to a reasonable degree of engineering certainty?
That's to a high degree of engineering certainty.
You mentioned there were 3 areas of study, and we've been through 2.
Correct.
Could you tell us what you focused on your 3rd area of study regarding this case?
So the third area of study, I'm now focusing in on the
John,
injuries, the at scene physical evidence, taillight fragments, broken glass, things of that nature.
Okay, and when you conducted your studies and reached conclusions, did you, in your PowerPoint, provide slides to help explain your process and inevitably your conclusions?
Yes, sir.
If you can take us through the 3rd section of your efforts regarding this case, specifically your efforts to identify the different pieces of evidence and your conclusions about a collision in this case.
Absolutely. Slide 104.
Please.
So this is a,
Is this 105, Dr. Welcher?
I'm sorry, 105. Yes, sorry. Slide 105. This is a picture of Mr. O'Keefe's right arm, forearm, hand, and wrist. In anatomy, your arm is defined from your shoulder to your elbow, and then from your elbow to your wrist is your forearm, and then this is your hand. So technically, when you say arm, it really means from your elbow to your shoulder. Most people call this whole thing arm. It's actually the upper extremity. Arm is from shoulder to elbow, elbow to wrist is forearm and hand. So you can see I wrote arm and forearm So arm, elbow to shoulder.
How many times do you need to say
Elbow to
that,
wrist
dude?
is forearm.
Did you say it like 8 times?
So looking at the injuries to Mr. O'Keefe's arm, forearm, as well as his hand. So this is me. I'm actually 6 feet, half an inch tall. What you see in the upper right is the coroner's examination report for Mr. O'Keefe. He's 73 inches tall. That's 6 feet, 1 inch tall. At this time, I was 220 pounds. Mr. O'Keefe, at the time of this incident, was 1 pounds. So I took
Now we
measurements of
know why
myself.
they picked this guy.
I'm actually wearing the same make and size shoes as Mr. O'Keefe, the same brand of jeans as Mr. O'Keefe, the same brand and size shirt of Mr. O'Keefe. You see the Lexus in the background.
Is he going to
We
paint his
have
arm now?
matched the height to the Lexus. What I'm showing here is both my height, and then keep in mind where the height of this wing is relative to my right eye.
Here's eye. He is. Oh my God.
So now I'm wearing, in addition to the same shirt and shoes, same type of sweatshirt, and actually the same kind of baseball hat. We tried to
Oh my
determine
God,
the
you
exact
really
glass
is gonna
from the
say that?
waterfall grill. Found out they were getting different ones at different times, but I ordered my glass from the same distributor that Waterfall Grill ordered their glasses from. So you can see in my right hand here, I have a glass. Here's a glass. It looks similar. It's from the same location. And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. So the first set of slides, I'm simply standing next to the Lexus. We know we have a broken taillight. We know how scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position of the taillight.
Dr. Welcher, if you could back up one slide, I have a question for you. In the middle photograph, at the top of the Lexus, there's like a rim. What do you call that?
I call it a wind wing. I mean, it could be a wing.
Okay, thank
The
you.
spoiler.
Air dam would be another. Okay, so
There's the paint. There we go.
I then
There's
set
the
about to do a
paint.
little bit of testing with the Lexus. The first test you're going to see is me just walking backwards or actually sideways into the Lexus. What I've done is I've painted the Lexus right rear tail light with what's called grease paint. And sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled into the Lexus with my arm out to see what the damage pattern looks like. Or basically where someone of Mr. O'Keefe's height
Wow,
arm
look, you could
would
hold your
contact the
arm in
rear
a
tail
certain
light.
way.
So then what you see is I've shown the photographs again. I show the paint transfer onto my arm. The yellow grease paint on my hand was to show where my hand would hit the taillight. And so just kind of me walking slowly sideways into it, the approximate location of the taillight, and I'll line it up with the broken taillight in a second, lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
Dr. Welcher, let me ask you a question. When you're engaging these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No, so we don't know exactly how he was struck, and pedestrian impacts are
That's correct,
extremely
you don't.
sensitive to exact angles. And so where exactly your foot is, whether your foot's off the ground, can have an effect on where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know we have lacerations in Mr. O'Keefe's arm. So I'm trying to see if there's any correlation between all those.
Well, can body
Is that what you're
posture
doing?
on a clip or a side swipe collision change the trajectory or the injury?
Of course.
Can the way somebody moves or reacts before impact change it?
Objection, Your Honor.
Sustained.
What are other things that can change the trajectory of the person and the injuries?
So for example, if you get hit and knocked off balance or clipped and knocked off balance, you can take additional steps. That'll affect how far your body travels. If you have 1 foot on the ground versus the other foot on the ground, affects how the body rotates. If your arm is at 90 degrees or 85 degrees, will affect the kinematics. We attempted to model different possibilities, and we're getting results that were all over the map. Small changes in
no
the pedestrian
kidding.
position give you huge change in the output. And so from the tech stream data, we don't know exactly when in the tech stream data he was hit. So we don't even know the exact impact speed. In most pedestrian reconstructions, you typically have a point where the impact occurred, like where the person was, like in the crosswalk, for example, and they get hit and their tire leaves a rubber scruff. That's called the area of impact or point of impact. You then can look at how far they were thrown and using some laws of physics, calculate how fast the car had to be going. Well, we don't have that in this case. We don't know exactly where Mr. O'Keefe was on the roadway when this happened. Sorry, I'm about to go to the next slide.
Without having an exact point of impact or an exact speed or an exact body position, are you able to specifically replicate the actual collision and the way Mr. O'Keefe's body would move?
Exactly replicate? No. And again, in terms of how he would move, again, we don't know where exactly on the roadway he started. So in terms of how he moved, that's a function of where he started. We don't know if when he was clipped, he took an additional step before falling backwards. So that will change how far you are off the roadway. So the impact, which you'll see in a second, even at 2 miles an hour, will induce rotation of the body. So depending on the speed, the higher the speed, the more rotation.
Not projection.
So if I may, so slide 111, this is simply showing where I walk sideways, how this lines up with the location of the lacerations on Mr. O'Keefe's arm. Here's the post-contact scuffing on the taillight. Here's a picture of Miss Reed's vehicle on the right-hand side. So now I said, okay, that was me walking into the car. Let's have the car drive into me. I did this at very low speeds. And you'll see, and we'll throw this from 2 different angles. That's me showing I'm doing test 2. That's me showing I'm doing test 2.
The test, guys. Very sciencey stuff here.
This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2 mile an hour impact. But even a 2 mile an hour impact redirects me back and causes me to rotate and take a step.
Completely nothing fakey about this at all. This is absolute real world, legit, apples to apples.
Can we approach, please?
Yes.
Look at how much it forces him to rotate. Forces him to rotate. I mean, this looks like a kid. This looks like a kid playing. Isn't that how kids play with each other? You run around and you bump and then you real dramatically do your big pirouette and your turn. And there's probably finger paints involved. This looks like a child's experiment. Oh, I got secondhand cringe for this guy when the paint came out. I wasn't expecting. My expectations were not high, guys. I heard how Mr. Alessi described this. My expectations were not high, but it is, in fact, at least as ridiculous as I envisioned and possibly more. Possibly more. You really went there with your making it extra science-y by backing the car into you at 2 miles an hour, which seems to be not what happened, according to what has been alleged here. I just had to look up what does it even cost to do a 3D scan of a vehicle. Guys, look at how much they threw at trying to prove that the tail light could not have been hit when Karen hit John's car, even though everybody saw the car move. And half of us with real world experience out there who have backed into something and broke a tail light instantly went, Yep, that looks like a tail light breaker right there. Look at how much they invested into trying to prove that didn't happen. That's all a lie. The reason why that missing part of Karen's tail light was never recovered, just coincidence, apparently. Cost to laser scan a car can range from a few $100s to several thousand. Scanning a larger, more complex object like a full car chassis may cost somewhere in the $1,000 to $3,000. Thousands and thousands and thousands of dollars they have thrown at this. Thousands of dollars they have thrown at this. The paint, how much do you think he was getting paid to play with finger paints and do his kid on the kindergarten playground reconstruction there? How many hundreds an hour does he charge to do that? Thousands. Thousands they have paid for all this. That's really what baffles me, honestly. With everything that you have put into this, and your presentation is still this bad, you're still this disorganized, you're still this inarticulate about being able to put the pieces together and explain them clearly and coherently. I feel like the trying to disprove that she busted the taillight when she hit John's car, that to me almost hurts their credibility more than if they had just never addressed that. Because dude, we can see with our eyeballs that she hit his car. It's very clear she hit his car. And so going out of your way to prove how we didn't really see what we think we see. Okay, there's no damage on his car, but there was contact. You acknowledge there was enough contact to move his freaking car. Because we can see that with our eyeballs. Why is he measuring all this from the point in time when the Lexus stops moving? Isn't the point when John's car moves? That's when we would know we have contact. I don't know if her car stops moving at exactly the same time or sometime a little bit later. But if I'm interested in a collision, I'm interested in the point in time where we can be sure there's a collision, and that's when his freaking car moved. It's not when her car stops. Did he even see the wheel move? I think he did, because he did that call out how, oh yeah, we see that there's contact. How do you see that? Because you saw the car move. You saw the car move. So there was contact between them. It was enough to, at the very least, move the snow. But we're supposed to throw that out. Ignore your eyes, guys. Ignore your eyes. Don't worry your little head about how many drinks you think Karen Reed took. Don't believe your eyes. Just listen to what we tell you. Just because you saw her hit his car with your own eyes, with her right rear tail light area, guys, doesn't mean you saw what you think you saw. Why are we not looking at the point in time when his car moved? Seems easy enough to identify which frame that is. Am I wrong about this? That's when the contact happened. I have no idea if her car continued to back for a few frames for a full second. I don't know. Yikes. It really is amazing how much they have spent on this. It really is amazing. All of this because poor Trooper Paul could not write a supplemental report that made them happy. Couldn't write a supplemental report that made him happy. He had to write a supplemental report, and they said thanks, and then they dumped him and hired these guys. And they have thrown all of this money, all of these resources at this guy to wave his hands and say that there's data that clearly does not show a collision. You have to acknowledge it doesn't show a collision. It shows at best that she backed up quickly. And then you got some paint on your arm. You played with finger paints. It's unbelievable.
And what slide is this? I think I just can't see it. What slide is this?
114.
Thank you.
You're welcome.
One moment, Dr. Welcher. When you were showing us this video, you walked to the side of the passenger side of the car, didn't you?
I did.
And why did you do that?
I was discussing with them what to do.
You were discussing with who what to do?
The driver.
In no way were you trying to imitate or give a demonstration of what you believed Mr. O'Keefe's movements to be?
Oh, no. This speed's just 2 miles an hour. I was having a discussion with the driver about what we needed to do to conduct the test.
So when you walked up to the
It's not-
passenger side, it
this
wasn't to
is this.
replicate a study
It's
or a
not a
movement given
replication.
No, that walking had
simply-
nothing to do with this case except for me instructing the driver what to do.
Thank you for that clarification.
Sorry about that.
No apology necessary. Could you go back to the beginning when you were explaining this so we can go through it?
So this is the dynamic test 2. So again, this is the view from behind. Just to avoid the confusion, I will start it here.
What speed is the car traveling?
He like leans into it.
You can see it.
You can see him lean into it.
About 2 miles an hour.
Okay.
Excuse me, Your Honor, that is the objection that we spoke about.
Oh,
that
okay. All right, so that's noted, Mr. Alessi.
So similar to the other tests, this is the post-contact image of the transfers onto my arm. Actually, this yellow paint, you can
All
see
he's
from
done
my
is shown and dream up away
hand is here.
where
This
his
is
arm
from the
lines up
arm
with the tail
and
light.
forearm. Here's the paint transfer pattern.
And that's slide number,
I'm
Dr.
sorry,
Welcher?
I'm terrible with that.
That's
Slide
okay.
116 now. That was 115.
Thank you.
Slide 116. What I've done is I've taken these yellow lines to show the extension of the components on the rear of the exemplar Lexus. Then I've done this extension of those same components on the rear of Miss Reed's Lexus and shown how the approximate location of the fractures in the taillight match up with the approximate location of the contact of the arm onto the taillight.
And so what part of that taillight is
Dr.
made out of
Welcher,
pig,
do you have any
out of curiosity?
indication of how Mr. O'Keefe's arm was bent, what angle it was bent at?
Not exactly, but for these to be taillight shard fragments, they would need to be in the area of the taillight, but it could be further up. We know from the police photographs that there was a damage to the rear body panel in the area I'm searching here. So it's possible his arm was a little higher up and the glass hit the rear of the Lexus and caused that damage.
In the bottom right,
Excuse me, your objection is speculation.
I will strike that last part about the glass.
Thank you.
There's a problem with
purpose of
the
the circle
configuration of
is
these
for what,
wounds.
Dr. Welcher?
To show, in this case, primarily the location of the lacerations up on the arm, the upper part of the arm, and that they match up with the locations of at least the one remaining shard in the rear taillight of Miss Reed's Lexus.
Looking at the picture of the Lexus, bottom right, middle, are there any marks on the Lexus itself that you took note of?
Yes, it's on the next slide.
Thank you.
Actually, it's 2 slides. So there, again, this is the evidence marker. There was a horizontal scuff. We know Mr. O'Keefe had blue jean type pants on. There's a scuff in the area that would approximately correspond to hip level for Mr. O'Keefe.
Oh, so you recovered some
Yes,
paint
ma'am.
transfer
118.
from his pants then, did you? Oh, that's right.
Did
That's
you
right. No,
describe what you
didn't.
saw on the bottom right-hand corner photo as well?
I believe, yes, I did. That's the scuff that lines up with the approximate height of Mr. O'Keefe's right hip. So then I included previous image that you've seen, slide 119, with the reconstructed photograph of the rear taillight, showing where some of the fragments are. You can see where those fragments are relative to the curvature of the taillight. They'd be in the area somewhat centered within the region of the 2 yellow lines on slide 119.
Is there anything about the photograph in the top right-hand corner that's important? If so, could you zoom in and show us?
So again, it's showing that this is when it's, I believe, in the Sally Port at the police station, showing that scuff on the right rear body panel.
Did you see any similar scuffs in the middle back
So
of
if
the
his
car?
hip there is there, then how come the bumper
Sustained.
didn't
Did
hit
you
him
see
in the
anything
femur?
notable as far as damage to the middle back of this Lexus?
The middle,
Yes,
like back where the doors are,
but with the middle of the back of the car, did you see any similar damage to the middle? or
there
the
were
left?
scuff marks that ran along the bumper.
Okay, continue, please.
So
Continue,
this is
please.
showing
Again,
his
not
jacket he was wearing, that
a
the
question.
puncture marks coincide to the marks on his arm. This is from the autopsy report. A couple things it notes: a 0.5 centimeter abrasion on his right lateral knee. He's got a laceration on his right eyelid. That corresponds to the height of that rear fin
He's literally saying the spoiler.
wind wing on the back of the Lexus.
Didn't like demolish,
Thank you.
destroy his eyeball, or
How tall
even
was Mr.
bruise him.
O'Keefe?
73 inches tall, 6'1".
And how high was that wing from the ground on the back of the Lexus?
It was about It's about 5 feet 11 inches, maybe 5 feet 10 and a half.
Thank you.
You're welcome.
Mm.
Did you notice anything about Mr. O'Keefe's right knee?
I noticed there was a 0.5 centimeter abrasion on the right lateral knee.
Did you note how high from his foot that bruise was on his knee?
We don't know the exact length of his knee. The abrasion appears to be right here at knee level. If you go back and look at where my knee is, that would be at the proximate level of the bumper.
Could you focus in on the bumper to show it relative to the height of your knee?
Sure. Oops.
Camera guy, get yourself fired. Go ahead and just walk
So my
yourself
knee's
right out of
approximately
the
right here.
because you are useless.
This is where the bumper is. So the side of Mr. O'Keefe's knee will be in this general area.
Okay, thank you.
So he's putting the scrape on the knee as the point of impact.
Sir, do you have an opinion to a reasonable degree of engineering certainty about the lacerations on Mr. O'Keefe's right arm and forearm regarding its orientation relative to the broken taillight on the defendant's Lexus?
Yes. Your Honor, may I read my report, my opinion?
Okay.
The location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570.
After considering these three different subjects that we discussed, the tech stream data, analyzing the touching between the defendant's Lexus and Mr. O'Keefe's car, and then your demonstrations regarding the injury to Mr. O'Keefe's right arm, did you consider further evidence in reaching any conclusions as an accident reconstructionist and a biomechanical engineer?
Yes, I did.
Could you turn us to slide 124, please?
So this is some of the location of the physical evidence.
Mm-hmm. Remember all that
plastic,
stuff that
clear
Sir said they
plastic.
found in the street that now is up on the grass?
There, his point of rest was indicated to be 7 feet off the roadway. There was a sneaker that was found near the curb. There were various fragments of taillight found in the snow on the morning of the incident, as to the afternoon of the incident.
Could you zoom in on those photos so that we can see the dates?
The date?
Yes.
Oh, sure. So January 29th at 5:46 p.m. This one's at 5:52. One's at 5:59. This one down here is at 5:46. So there were various fragments of the taillight that were ultimately pieced back together and determined to be from Miss Reed's right rear taillight. Additional evidence was found. This is taken on the afternoon of the accident, again, around 5:50 p.m.
Could you zoom in, please, for us?
Sure. So what
That's
you
not
see
at or near the point of
here
rest.
is was later identified as Mr. O'Keefe's right shoe.
And this slide number, Dr. Welcher?
Yes, ma'am. 127.
Could you show us the time and date, please?
So it's at least 7 feet away
January
from Dawn.
29th at 5:50 p.m. So a series of photographs. Again, you can see on the right-hand photograph that this is the roadway. This is the curb. The grass will be up towards the top of the right image on slide 127. The shoe was found, up against, in the roadway, up against the edge of the curb.
But it's not at
Baseball
or
hat.
near his point of rest.
Again, acquired a same baseball hat. Baseball hat was also found in the snow. You can see,
I want you, before you move ahead, the baseball hat, could you give us a close-up view and also the date and time?
so that's where it's buried in the snow.
Oh, so helpful.
These were taken on
The frame of
February
reference
3rd. I'm
there.
not sure what time it was. There was also red liquid identified, I believe they indicated to be blood in the snow as well.
And could you give us,
Objection, Your Honor. Can we
So-
approach on this, please, for-
I'm going to sustain that objection and strike the last part of it.
Thank you, Your Honor.
I
We
understand.
don't need to come to Sidebar, right?
Just describe the color of what you saw rather than what it was.
There was red coloration in the snow.
And could you give us that date if it's different than February 3rd?
I thought that was February 3rd as well.
Is there a date on the photograph to the left?
I don't see one.
Okay. Do you know if those photos were taken by the Canton Police Department?
Objection, Your Honor.
Sustain.
Do you know when exactly those photos were taken?
I don't, except I have them dated as February 3rd. But I think that may just be the baseball hat photos.
Okay, can you continue?
Here we have photos of a broken glass. Surrounded by red marks in the snow.
Continue, please.
This, by the way, is the flagpole.
And that slide number, please, Dr.
Yes, ma'am, 129.
Thank you.
Slide 130.
Can you enlarge that and explain to us what that is?
Sure. So at the bottom, it indicates where it's from. So this was from a presentation I gave looking at pedestrian injury biomechanics back in 2005. And what it's showing is where what are the most common injuries in pedestrian impacts. So what it shows is head injuries are the most common injury in pedestrian impacts.
Well, no
So on the
shit.
right-hand side, it's all injuries. You can see of all the individual study, the highest prevalence or highest or most common injury was head injuries. In those that
Where's the
sustained
rest of
severe
them?
life-threatening injuries, again, the highest was also head injuries. So head injuries are very commonly associated with pedestrian impacts. This is anatomical drawings just to help you understand the anatomy. The middle section here is from Mr. O'Keefe's autopsy report. The lower right diagram, the green line represents the fracture lines, predominantly here, at least in the base of the skull. So in the biomechanical and forensics just means the legal related scientific industry, there's something called hat brim line or hat line analysis. And what it is it's looking at where the hat line you can imagine is where the brim of a hat would be. And what it is, it's literature that's looking at where head injuries from falls commonly occur.
Your Honor, I move to strike that.
I'll strike, I'm going to strike. I'm going to
Have
strike,
it removed from the screen.
Yes.
please.
yes.
Thank you, Your Honor.
So that was slide 131.
No, that was 132. I moved it because you said to take it out of the screen.
Your Honor, one more request is to agree to not take that into consideration.
So jurors, when I strike something, that means don't pay any attention to it.
Thank you, Your Honor.
Continue, Dr. Welcher.
Your Honor, I need to go past that slide.
Okay, go ahead, go ahead. Slide.
This is the next slide.
Okay, if you can continue.
Sure. So I provided peer-reviewed scientific literature that looked at a metric where they were publishing research trying to delineate falls versus blows or assaults. And so this metric is in that scientific literature. They looked at a total of 400 different events, 235 falls, 165 assaults. And so you can see where it says mandible. So mandible is your lower jaw.
Can you enlarge that a little bit, please?
Your Honor, pardon the interruption. I'm moving to strike.
Yeah, let's take that slide down and I'm going to see you at sidebar, please.
Oh, this is more hearsay stuff. This is more hearsay stuff. I don't know why we're concerned about mandibles at all. We've heard nothing at all about any kind of mandible injury to John. Guys, this is a mess. We just heard from the MSP about Lockhard's exchange principle. Did we not? Like the whole basis for a bunch of this trace analysis, this idea when two items come into contact, there will be at the very least a microscopic exchange of materials. That's what a whole bunch of different forensic disciplines are based on. So if you're going to try to tell me that the paint on Karen Reed's car is scuffed up because of John's jeans, you're going to need to show me where on John's jeans you found the paint, because the paint went somewhere. Where's the paint on the jeans? If that's your explanation, where is it? Nobody found any paint on John's jeans. Nobody found any car paint on John's jeans. For heaven's sake. I don't have time to pull this up right now, but the whole geometry, he's trying to say the geometry of the taillight and the injuries and stuff, it all works. It does not. I have a photo we'll look at when they're done for the day. Just so I can show you what I am seeing and how it does not add up with this strange little show and tell that he did with the finger paint. He really did go there. He really did go there with the spoiler. The spoiler caused the aperture, the laceration to John's eye. The spoiler didn't bruise it, didn't damage the eye, didn't apparently hurt the socket at all. Just happened to cut his eyelid. And the car hit him on the outside of the knee and scraped him. The bumper scraped him. That's the point of impact. I can't believe they're actually going here. What sort of testing? I'm just already envisioning the cross on this. What sort of testing did you do to ascertain what type of damage would be caused to a human knee struck by a bumper going in reverse at 24 miles an hour?
Mr. Alessi, Mr. Brennan is going to do this in open court. Just talk to Dr. Welcher for a minute. Okay.
Yeah.
Is there any objection?
I have no objection. Are we on the transcript?
Yes. Right.
Okay, I made it.
This is a mess. What on earth is going on?
Yes. Absolutely.
And they're going to be removed.
No talking, court still in session.
And we're going to remove the heading on each one of the slides. I don't want to repeat what it says, but on each one of them. Thank you. Anything else? That's all I was going to. And I'm going to now use the minutes to see if there's anything else in the report to be waiting.
So it starts on page 124. that right, Mr. Brennan and Mr. Alessi?
I don't have the whole one in front of me.
Dr. Welcher, is that where it starts?
That appears to be, Your Honor, yes. 124.
Page 124 is where it starts. We have no idea what it is.
I actually have 122 is already redacted, but I have it at 123 as well.
All right, I don't have it on 123.
123 was a blank slide.
May I approach, Your Honor?
Yes.
I have 123 as a blank slide.
Okay. So
So from
124.
Triple M, we do not have that. But for 124.
So that it is 120. Thank you.
Guess we're redacting his slide on the fly. Is that what's happening?
124 through 138, is that accurate, counsel?
Checking out what it is. I'm just going to do it.
Chrissy, do you need a break? Do you need 5 minutes?
Yes, Your Honor.
Okay. So if you could do that for us,
Absolutely, Your Honor.
Dr. Welcher.
I'm doing it right now.
We can bring the jurors back.
Your Honor, if we could just, now I just want to look at the rest.
Okay,
2 minutes. And then
Sure.
Your Honor asks us to do that.
sure.
So that's what it looks like. The jury, I guess, has been let out, and they're having to go through and modify the presentation on the fly, because in the multiple times that they went over it with Mr. Brennan, not only do they still not seem to know it very well, but they also did not make it admissible. This is something they were on notice of
Mr. Brennan at 1.4.
because, of course, this PowerPoint has been being litigated for months.
Not on the record, Chrissy.
Remember, like way back when he was supposed to provide his revised PowerPoint, and then Alessi came and told us he didn't actually change anything. There's like a few words that he changed, and that was it. And that was because once again, we'd had an objection and a motion, and then we go in for the hearing, and Brennan says, "Oh yeah, there's not going to be any problem with these objections because he's going through and revising his PowerPoint anyway." And then lo and behold, what happens? It didn't happen. What Hank said was happening did not in fact happen.
Sure, and
And
it won't
we've
be
heard
on the
that
record, right?
multiple times now.
Do we need it on the record?
No, thank you.
Okay.
Dr. Welcher,
Yes, sir.
please turn to slide 137.
How's my sound if I don't mute it? I don't really want to mute it because they keep going back
That
and forth. But
opportunity.
I know my audio doesn't always love it. I'll just keep it going just in case. All I can tell is it sounds like slides 124 to 138 are getting yanked, but not totally sure about that.
Going back once the heading's on, right?
Correct. There may be, depending upon what's in the video, there may be more. That's why.
Right, but the ones, all right, so.
So I can go back and show them.
Yes.
I don't want to offend the court.
Okay.
Laughing like she's so amused.
So are we starting on slide 132?
132, Your Honor.
Okay, thank you.
So now I guess we're not skipping 124 to 138. This is not much of a record that's being made here, but I don't know what was going on at Sidebar. I feel like this is supposed to be some gotcha that head injuries are most common with a pedestrian impact. This is not surprising whatsoever. Like, of course, you're going to fall, you're going to hit your head. That seems like the most predictable thing pretty much ever. You get hit by a car while you're a pedestrian, you're gonna fall and hit your head.
May I inquire if Dr. Welcher's PowerPoint is ready on the screen?
It looks like it's up. Is it ready, Dr. Welcher?
You got me scared when you asked me that. I need to double check. Yes, I believe I redacted everything and we are on slide 132. Thank you.
All right.
And by the way,
It appears that way to me, Mr. Alessi, from here.
the battery died on this.
Okay, thank you.
Or in charge of. I mean, I brought my own, fortunately, but
Okay, thank
actually, no, I can't find mine.
you. Oh, Ms. Gilman has one.
We've had the captions off while we've been watching when they, have the, oops. Boy.
Equally bad. These laser pointers do not work on those monitors.
Yeah, we've had that too.
My white doesn't want to move right now. It's just going to be that kind of day, I guess. Oh, he's got a nice metal pointer. Going to shift over to that. Oh, now they're going to take a break. Oh my good Lord. All this just to get his slideshow corrected on the fly when Mr. Alessi tried to bring this to the court's attention more than 6 weeks ago. That's where we're at, but she certainly is amused by it, isn't she? It's good to see she's not getting annoyed or irritated with these types of inconveniences that serve to really disrespect the jury's time. Just trying to get the
Dr. Welcher, if you could return to slide 132. Actually, 133, Dr. Welcher.
now you're going to change it to 133. Chaos will chaos will erupt.
132 or 133?
133, please. The next one after that.
So we did skip over 132.
So we skipped over that one as well.
Do what you're told, witness.
Going. Here we go.
Do what you're fucking told. You're not running the show
You can
here.
relax that
Answer the
slowly
question
for
you're
us.
asked. If he says slide 133, go
Now,
to
you
slide
mentioned that there was studies that
133.
talked about guiding the difference between potential injuries.
Correct.
Okay, explain that.
Sure. So I gave 3 papers and someone's dissertation on this issue. They are creating a analysis methodology to differentiate whether the nature and pattern of injuries are more consistent with a fall or more consistent with an assault, or they're calling it blows.
Okay, could you walk us through what this chart means?
Sure. So this is their flow chart in terms of their assessment. So it starts at the very top. You can see they analyze a total of 400 events, 235 falls, 165 blows or assaults. So what you do is you ask yourself on the first set of arrows, you look at the mandible, the jaw. And MRS, as you can see at the bottom down here, refers to a simple fracture or multiple fractures. A is no fracture. Mr. O'Keefe has no mandible fracture. So that means we go down this row. It then looks at all facial fractures. So these are the bones that constitute the face. So if you have a facial fracture, you go to your left. If you have no facial fracture, you go to the right. So if you have some event, no mandible fracture, no facial fracture, what they've indicated that is predominantly associated with falls and not
It's got
assaults.
orbital fractures, but
Thank
who
you.
says
You're
you
welcome.
can't have
In
an assault
addition, did
and
you
then
do any
fall?
further study on the force of a person falling back and landing on their head?
Oops, I did.
Could you
So what I did was I did what are called drop test. I took an anthropomorphic test device, ATD, was just a fancy name for a crash test dummy, and dropped it backwards onto a hard surface to look at what happens if you were to say fall backwards and hit your head onto a hard surface. So on this particular photograph of Mr. O'Keefe in the upper left, there's noted to be abrasions above the fracture line in the area. You can't see that at all. You can see, noted to be abrasions right here. Your Honor, I brought a hat. That was the one I used in my testing. May I put it on and demonstrate something?
Mr. Alessi,
If you would like a sidebar or.
No question
are you
pending.
objecting?
I am objecting.
That's sustained. No, you can't put it on.
Okay, so I will show you the dummy test I did. Watch when the shoulders hit the ground, then the head hits the ground. It creates kind of an arc path that will drag and slide objects up the head. So if you have something such as a baseball hat, it'll cause it to drag across the scalp, dragging it up to a similar location to where these abrasions are. So here's the testing. Again, this is a crash test dummies you see on television. This is myself.
Camera guy.
Me giving me similar instructions, telling him what we're going to do. I said, and watch. Shoulders come in, then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface, you'll get extremely high loads on the head. If you compare that to data in the science.
I'm sorry to interrupt.
Yeah.
Pause that, please explain what the chart is before you explain.
Oh, sure. This chart up here?
Nope, the next page.
Right,
You can enlarge it, tell us what it is before you get into the details.
absolutely. So this is actually kind of a famous study that was published, one of the first studies looking at head fracture or skull fracture tolerances. So what you see, the portion at the back of your skull is called the occiput bone. So that bone, if you put your hand on the back of your head, is your occiput. So we're looking at occiput impacts. And what you can see is that when they took cadaver skulls and dropped them from as low as 40 inches onto a hard surface, they were getting linear fractures. And you can see even at 40 inches, there is called a stellate fracture. Stellate means star-like. You get a fracture that goes out like a star.
Oh,
So
no
even at a
kidding.
40-inch drop height, you have sufficient force when landing on a hard surface to cause skull fracture and a level 3 type skull fracture. So Mr. O'Keefe, again, is 73 inches tall. His occiput is about 4.6 inches down from the top of his skull. That means it would fall a total of about 73 minus 5 would be 68. So just under 6 feet. So 72, 4 inches under, so 5 foot, 8 inches is the fall height. What is data showing that even at a fall height as low as 40 inches onto a hard surface, you can get fairly severe skull
If
fractures.
you drop a skull.
Thank you. Dr. Welcher, regarding your third part of your analysis, did you come to a conclusion to a reasonable degree of engineering and certainty whether or not the defendant's Lexus collided with Mr. John O'Keefe on the evening of January 29th, 2022, around 12:32 a.m.
Yes.
Before you give me your opinion, I'd like you to share with the jury what that opinion is based on.
Sure. So it's based on the 130 slides you've seen. It's based on my personal inspection of the Lexus, the correlation of the text stream data with the infotainment data, as well as Mr. O'Keefe's cell phone data. It's looking at, I guess, where the taillight wasn't broken. It's looking at the physical evidence at the scene in terms of taillight fragments, glass fragments, red color in the snow. We have the cell phone data, the location and position of the arm lacerations, the air temperature at the time indicative of sufficient to freeze, the location of the fracture on the back of his head relative to the scientific literature, my testing of forces available falling onto a hard surface, published science on the fracture forces associated with falls. And, I'm sorry, I'm reading from my report.
Yes, we know.
I'm reading from my report.
Can you answer without reading from your report?
Probably it's more complete if I read my report.
Any objection, Mr. Alessi?
I do. This
Yes.
question,
Have you never been in court before?
reading from a report with this question. So I'm hearing reference to the email.
So, try not to read, don't read from your report.
Okay, doke.
Okay, Dr. Welcher, let me ask you again. Based on your analysis, data available, reviews, study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes.
And could you share the bases of your opinion before I ask you your ultimate opinion?
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged. I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight. I have looked at fracture tolerance data for falling backwards onto hard surfaces. I've looked at the metrics of where his injuries were and what injuries he didn't sustain. I've looked at the cell phone data, and then I've looked at Ms. Reed's interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Going to allow them.
I can answer. Yes, based on the totality of the evidence, DNA, everything I've talked about, that is
DNA,
consistent with that happening with a
everything?
reasonable degree of scientific certainty. That is what happened.
Objection, move to strike, Your
So
Honor.
I'm gonna strike that. I want to see Council Sidebar just.
DNA just out of nowhere. DNA. What about the other two guys in the mix? Welcher. Where did they come from? God, this is a mess. This is an absolute mess of an expert cross. I mean, direct. God, we're not even on cross. We're on direct. And it's going this badly. Now we know where Alessi got the star-like fracture from, don't we? When he was cross-examining Dr. Scorty Bello. Huh. Turns out it's in this guy's report that you get a star-like fracture at certain forces At least if you drop a cadaver skull on the ground. How does that translate to living humans? You would have to tell me. I don't know if that extrapolates cleanly or not. I mean, isn't this excruciating? It's taken him like 15 minutes just to get to, yes, I think she hit him with the car. Yes, I think the evidence shows she hit him with the car. And what evidence? Well, I'm just going to keep dumping all of this stuff that I looked at as my explanation. I'm not going to show you how that supports my theory. I'm just going to say it's there and it does. The wounds on his arm are at the right height to be the taillight. Okay, no sort of detailed analysis about how the human body works, how skin works, how polycarbonate works, what types of forces are involved, what type of injury pattern would result, what type of, again, applying the Lockhardt's exchange principle, what we might expect in terms of being able to detect taillight in John's wounds or John's blood or body tissue on taillight fragments. We're just going to dump all this DNA. We're going to dump that out there like the DNA wasn't a mixture of multiple people. Like there isn't dog DNA. Not even dog, it's pig. It's pig. It's pig DNA. We haven't even heard about the pig DNA yet. Exactly what sort of pig is this taillight made out of? The totality of the evidence. What about that pig DNA? How did the pig DNA get on the taillight and then into John's sleeve? What a mess. What a mess. I mean, this is going to be a very lengthy cross. We already know that. I'm interested to see how this, kind of puffed up Eric Clapton does on cross. I've gotten, what he's reminded me of so far a little bit with his demeanor. I love old Phil Hartman, man. Old Phil Hartman on the Saturday Night Live and stuff. Some of the most just hilarious stuff ever. And the Chop and Broccoli. He's reminded me of just the vibe of that guy, Phil Hartman, listening to the Chop and Broccoli. He's like really into it. He's feeling it. You can see him really feel it. Somehow this guy's demeanor and his expressions and just the way he seems to perform a little bit like that, it's given me Phil Hartman chop and broccoli vibes just a little bit. Thank you, Lisa Davis. I agree completely. You are the first person. Oh wait, no, this is deep state thrombosis. Sorry, Lisa said it first. Wait. Things are skipping around on me so fast. Here it is. That's where I saw it first. Eric Clapton. Yeah, Dana Carvey did the Chop and Broccoli. He was the pianist. But Phil Hartman was the guy that was listening. He was the guy that was listening. And not the guy playing the piano, the guy that was listening and taking it in and reacting, getting that jazz vibe. That was Phil Hartman. He did it's absolutely wonderful skits. He was the notorious caveman lawyer, unfrozen caveman lawyer. I like thinking about Phil Hartman a lot more than I'm enjoying any of this direct examination. Right? We're not going to get to cross. We're not going to get to cross today. We're gonna drag this out enough that we're gonna eventually sort of reel out this conclusion that everybody knows we're already ending up at anyway. We know he's going to say he thinks Karen hit him with a car, and then we'll have to come back tomorrow for all of the cross on this. So we already know that's going to happen. But how I ended up down the sideline anyway is I'm interested to see how this guy reacts during cross. What's his attitude going to be? What's his demeanor? Is he going to look to the judge for help some more, like he has been? Judge, can I do this? Can I put my hat on, Judge? No, you may not. You may not put your hat on. You are not here to run the show. You are here to answer the questions that you are asked. If he says go to slide 133, then that is your job, is to go to slide 133, not to do what you think you want to do. So I'm intrigued because he's presented himself so far as a little bit low key, not he doesn't come across as a real like high strung kind of guy. He's not like excessively nerdy. He seems like just kind of a bro, he's kind of a reconstruction bro. So you're gonna keep that bro energy when it's time for cross. Guess we'll see. Oh God. You guys, where is it? Sometimes the chat runs too fast for me and I can't catch the things in time. I see it fly by and I want to pull it back up, but I can't find it. Somebody made a comment about Eric Clapton's greatest hit, The Wonderful Tail Light. That made me laugh. That would be fun. Yes, indeed, sweet Lorraine. Phil Hartman was murdered by his wife. She shot him in his bed while he slept. Actually, he might have been awake. I think he was asleep, though. And then she called somebody to come over to the house. And then she killed herself while that guy called the cops. So, yep. Very sad story. But women abusing men is nothing to worry about, guys. It's no big thing. It's no big thing. It's just been happening for decades. It's just been lethal, frequently, but don't pay any attention to that. Women are only victims, you see, unless we're over here in Massachusetts. Now over here in Massachusetts. Now we try cases on don't put your dick in crazy tropes.
I don't want to steal Okay, so those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and please be very careful with your social media use. So we'll see you tomorrow.
Oh, there they go.
Oh, I'm sorry.
no.
We're starting an hour late tomorrow. Is that what this is?
Oh,
Yes.
So we'll start at 10 o'clock tomorrow. So we'll see you at 10
leaping in
o'clock.
already.
We'll tell you about your specific directions.
Wow. You can sleep all the way into 5:30. I can't hardly wait.
Do I need to pack all this up? It's okay. I mean, I can come in early. I came in early this morning and set up.
Welcome. I mean, we don't really want it.
Seems like they're just chit-chatting logistics.
Yeah, I'll be back.
All right.
Did Dr. Welcher leave?
Dr. Welcher can step down. I know he has to come back and have his
So just
equipment.
leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please.
Roger.
All right. So, Mr. Alessi, I will hear you as to your objection.
The deep sigh. Now suddenly it's time for a deep sigh. We've been amused with the shenanigans all afternoon. But now it's objection time, so deep sigh.
Thank you, Your Honor. Would you like me to go to the podium or stand?
Right there's fine, and let's try and wrap this all up by 4 because I've already heard you at sidebar.
We'll do so, Your Honor.
That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Alessi.
Thank you, Your Honor. The point number 1 is the question of whether, based on a reasonable degree of scientific or certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time with equivalent. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The
Well, it isn't,
defense
but I get it.
strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the 2 questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All
It's a
right,
good
Mr.
argument.
Brennan.
I don't agree with it,
So what
but it's a
Mr.
good
Alessi is
argument.
arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and
This
over
is a
again, there was no collision.
Stupid response.
Over and over and over again. And he just told you that when his expert takes a stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the tech stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe. And he's also allowed to answer, in his opinion, the issue of a collision. Putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify.
It's for the
not
jury
our
to
fault that
find.
ARCA didn't testify.
You also
or
get to
look
say
at the
murder
evidence
in
we
your
did, or they don't have
opening.
an expert for it. It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022 around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper. And there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Consistency with a side swipe or a clip.
okay, so this is not the end of Dr. Welcher's testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case, oh, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me. And I have the report of.
Is that a new one or is that
This is the new one.
okay.
It's also, the old one is the same. So I can, either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that, because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. So there's two questions I said in sidebar. And for reference, Your Honor, for the most recent is page 15. There is no.
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right. So we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right. So I'll see you in the morning.
All right.
Oh, for heaven's sake. How unsatisfying is that? We'll just come back tomorrow. An hour late, though. That's kind of exciting. What a painful day to have to recap. Ugh. Well, let's just grit our teeth and get right down to it. We're going to recap the day and then go take up many, many comments and questions in the queue. So, of course, we started off with a very long sidebar, approximately an hour and a half sidebar and recess that led to the Voir Dire, little short Voir Dire of Dr. Welcher, where we talked about changes that he made to his PowerPoint, who he has spoken to in the last couple of weeks, conversations he had with Brennan and Lally about the topics of his PowerPoint presentation, including that on Sunday, they went through the presentation top to bottom, but then he said we ran through it again. So twice you ran through it, and yet it went this badly. That seems to be what he's saying. And so then Brennan suggested that he make some changes to his presentation. Specifically, there was a slide that referenced testimony he wasn't allowed to have in a slide, and yet it seems you still left it in the slide. Are we still redacting stuff on the fly? He made another change to a slide that had something to do with Dayton and the travel time and stuff. He made that change about 8 to 10 days ago. Don't know who he told, but seems the defense was not in the know on that one. Burgess is his colleague over there at Aperture, and unfortunately, he's been bombarded with emails about Burgess's unfortunate resume problems, but he only read 1 or 2 lines. It was just they would come in and they look like legitimate business emails because, yeah, you know, you suck, all caps in the subject line is the giveaway. I don't know how these look like legitimate business emails or who is emailing him, but this is always like the harassment and stuff. We heard the same thing with Amber Heard. Not to always go back to Amber Heard, but you know, all the harassment, the people contacting her, never once saw a piece of evidence of that actually happening. So you will have to pardon me if I'm a little skeptical of the "I received a bunch of nasty emails" excuse, but it's possible, I suppose. It's just that I require these people to verify their information at this point in time. So then he acknowledged that, yes, he changed. He elaborated on the 1162-2 trigger event time frame. That's based on Burgess's May 8 report. Yes, he intends to incorporate it. He is altering and correcting his prior presentation with better data, and he's only doing it because of Burgess's May 8th report. And it does move the time. He acknowledged that it moves the time. Acknowledges that it's significant, that where that device lock event takes place in relationship to all the other action that they're talking about, that is significant. So that's what we got for a Voir Dire. That's the record. No ruling, nothing like that. This just seems to me like this is making a record after the fact based on the ruling that Judge Bev already made, that no, there's no problem with doing this May 8th revision, this Shannon Burgess stuff. She's already said, yes, you're going to be allowed to do it. This is just making a record as to why she shouldn't have done that, but she's not going to change her mind. She didn't even ask like she was expected or being asked to change her mind. So we just got the record, and apparently that's it. No grave concerns, nothing like that. So then we got his 40 minutes of his resume that was just not really didn't hold my attention. It wasn't that interesting. I don't care about your life story. I don't really care why you were interested in whatever you were interested in. So he gets his PhD in biomedical engineering. Okay. You can call me crazy, call me stupid, call me whatever, but biomedical engineering, isn't that something quite different from just biomechanics and accident reconstruction? Isn't biomedical engineering about things like stents, pacemakers, devices, materials for hip replacements, things like that? Isn't biomedical engineering about engineering biomedical interventions? That's kind of what I thought. And so I'm really not sure what being able to design and fabricate a replacement human hip has to do with understanding whether an injury was caused by a taillight or a dog. I can see how there might be some overlap, but I am definitely not seeing the direct applicability of this PhD, this specialty, biomedical engineering. That's medical research. It just kind of sounds to me like you were, considering maybe a a little sideline, a little career change or something like that. I don't know. And so then he's done, all these papers that I really didn't care about at all. They're just not very interesting, but a lot of them have sideswipe in the title, so they must be really important. Something about the Toyota event data in low speed impacts. Okay. Guess he's written an article about that. So he doesn't care, guys. He actually doesn't care. He's just there to critically analyze the data. He has no dog in the fight. Okay. Don't mind how much he's being paid to do all this. Don't mind how much any of this actually matters. Hey, I'll wait till we get to it. But yeah, I get to cash. I get to cash a little check I wrote during that direct. So he doesn't care at all, guys. He's completely indifferent as to the outcome. So he looked at the police reports, the cars report, the ring video, the cruiser cams, the photos of the vehicle, photos of the scene, video of the Karen's car pulled into the Sallyport, the 360 diagram, the McCarthy's and the waterfall videos, the Cantonport Sallyport videos, the Lexus Connect Verizon records, the Lardon.com videos, John O'Keefe's phone, the coroner's report, Jen McCabe's Celebrate info. Jen McCabe's Celebrate info. He relies on for this accident reconstruction. Okay, dude. The Lexus infotainment system. Oh, this was interesting. Not like transcripts of the testimony of numerous witnesses, but testimony summaries. Summaries of the testimony of numerous witnesses. So somebody told you what they said, characterized it, cherry-picked it, etc. And that's what he relied on. Karen Reed's various interviews, the Bodie lab reports, the I can't even read what I wrote there. Oh, the crime scene services reports, the criminalist trace file folders, the dog DNA records, the location data, medical records, retrograde extrapolation report, neuropathology report, diagrams. So much stuff he relied on. Is this like the basis for my opinion inflation version of the discovery dump? I'm just going to spew everything that I was given, everything that I had access to, because it makes it sound like a lot. It makes it sound like my opinion is really, really, really substantiated. And yet, when it came down to his opinion, hasn't mentioned very many of these things, has he? Which of the witness testimony summaries did you, in fact, rely on as part of your opinion? Just curious. Just curious. Went out and did those scans, both the cars. Okay, he gets his contract, and on November 23rd, 2024, he is right out there immediately because, guys, he needs the most objective data possible. That's why he needs to use his own eyeballs. So he had to come out, inspect the car himself, scan it, do a 360 scan, download the data himself. Okay, so all this stuff, it's already been done. It's already been done, but he had to recreate the wheel and go do it again right from the very, very outset. The fact that there was nothing registered in the EDR for a collision that killed a man and broke Karen's taillight, according to them, is completely expected because the Lexus is 6,000 pounds, but John O'Keefe is only 216. And so there's not going to be any kind of register in the EDR from that type of collision. That's exactly what he expected. This looks like, to me, I mean, if that is not foreshadowing a rebuttal, a cross-examination on this point, I'll be real surprised. I'll be real surprised if Mr. Alessi does not have studies or something like that up his sleeve to establish when and to what the Lexus EDR system will react. So then, of course, he looked at John's vehicle, and guys, he took that rear bumper cover off, and he saw that the frame, the metal frame, the steel frame, it's like an I-beam, like a tiny little I-beam back there making up that bumper. It wasn't damaged. So therefore, clearly wasn't a collision. Clearly wasn't a collision with Karen's car. Nothing that bad. So then he did his own testing with the tech stream data. He says he ran a test with Karen's vehicle. He did a sudden acceleration test, and he was able to like get his own key cycle identified. So he knew which one that was. Didn't tell us which one it was. And I do have to wonder because surely we have even more key cycles now that we have to account for that we know nothing about. They've hauled her car out to this crime scene at least twice, out to 34 Fairview at least twice just for jury views. So we know they've done that. Wherever it was that he got it is clearly not in the Canton Sallyport garage. Where was it? Was it out in the, I don't know where it was, but it was put there from wherever it has been. We have no idea over the last couple of years how many times this car has moved and where. So great, he's got his key cycle. I don't know that helps us a whole lot in trying to work backwards and figure out what key cycle is at interest outside of 34 Fairview. Here's where I get to cash my check, guys. I get to cash my check because he went out to 34 Fairview and he did that scan. He took that he got that digital map. Didn't explain either what that was. Is that LiDAR? Is that what the hell is this? I don't know. It looks terrible. And remember, I made the bet. You're never going to see that again because you have nothing to interface with it. You have no valid data of where anything happened to overlay, to compare it to. So why on earth you would need this accurate down to the millimeter scan of outside of 34 Fairview? You don't need that. You can't actually do anything with it because you don't have accurate data about the conditions of the scene or any of the events that you're alleging took place to overlay on it. So I told you guys, we're not going to see that again. Guess what? Guess what? Have we seen it again? I haven't seen it again. I haven't seen it again. Oh, I guess we got a little bit more tomorrow, so maybe we'll see it then. No, this was just a way to build a case. So then we had the mileage. 12,665 was the mileage on that 1164 and 1167 key cycles. 1164 we know from the last trial was the one that Trooper Paul claimed was his, but that's why the count didn't work. 1167, I don't remember what that one is. I don't have any idea. Not off the top of my head. But several key cycles apparently that did not add up to any miles because it's still at 12,665. And then it's at 12,629 at the backing maneuver. So that's where we get the 36 mile difference that has to be reconciled. All the places that Karen drove back to Meadows, over to Jen McCabe's in the morning, over to John's, over to Dighton. All of those have to be exactly just right for that to be only 36 miles. You know, another thing I wondered, we were talking about while they were having that testimony, the way that the car records the odometer mileage, and it's like the wheels turning, and where they pick up that measurement. You know, I'm sure there's probably different sensors, different systems, you know, depending on the car. But whether it's pulling it from the wheelbase, whether it's pulling it from the transmission or whatever, it's the rotation of the tire, the 360 rotation of the tire that is that's the basis for the calculation of the mileage. So it just made me wonder if it's really slippery outside and you don't have very good traction. There's a lot of snow, for example. It seems like your wheels are going to spin more. And if your wheels are going to spin more, then it seems like it's going to overcount how far you actually are able to go, right? Because your wheels are going to spin more than you're actually going to cover the ground. Just kind of crossed my mind about a possible other basis for a discrepancy there. But I mean, if the car drove absolutely perfectly the whole time and they only took those short routes, did you notice too, when they're looking at Karen's route the following morning at 5:07, they have her going from One Meadows Ave to the waterfall and then directly to Jen McCabe's house. Where's he getting that assumption from? Didn't explain that. Didn't explain where he's getting that assumption that she went to the waterfall and then went to Jen's, and those are the only places that she went that morning. It somehow still took her 40 minutes to get all the way from One Meadows Ave over to Jen's house. But it only took them, 6 minutes? Something like that? To get from Jen's house back to John's? Seems like a lot of assumptions built into that mileage observation. So a lot of what he had to say, it was quite confusing. The trigger event. So he talked about the stops, the clocks. So there's the running clock that's like a stopwatch that starts when the power comes on. And it starts running this continuous clock. And then if you have a trigger event, it captures a 10-second window. So it captures 5 seconds before and 5 seconds after. Don't really understand how that works either, but that's just what I'm told. And so if the trigger has ended, then after 5 seconds, there's no more data recorded. You would have to have another trigger for that to keep recording beyond 5 seconds after the event. That's how I understood what he was saying about the trigger events. And the reason why that stood out to me is because he was saying, for example, when he got into the data, that the trigger for this second event on the 1162 key cycle that he was interested in, it was because of a high throttle while in reverse. And that was all very unclear to me because that was still happening when the, quote unquote data stopped. She was still at the 74%. He said the threshold's at 30. You're at 74. So how is that not meeting the threshold for a new trigger event to continue recording it, if that's what, in fact, the trigger event was based on? That was not clarified for me at all. So, yeah, we did this whole reconstruction with the 36 whatever miles based on our assumptions about where she went. They made that math fit. They did their best to make that math fit. Just a lot of confusing stuff. 8 minutes between the two triggers, 1162.1 and 1162.2. corresponded with the GPS location data. Okay, but that's with the phone, right? It didn't really correspond. You just matched them up. Yeah, a lot of very confusing and kind of all over the place stuff. Then we sidelined into, yes, we acknowledge that devices don't all have the same clock. They have different clocks. Now, he said there was a difference. He knew that there was a difference between the clock on John's phone and the TechStream clock, but he didn't receive the data about this GPS point 154 until May. That seems to not be the point, does it? GPS point 154 is not any kind of magic thing. It's just what he and Burgess have highlighted as what they have decided the point of the 3-point turn is. We have no idea when Lexus thinks a 3-point turn has taken place. We have no idea, just out in the real world, outside of any of this data recording and stuff like that, if you were going to define when has a 3-point turn taken place, I don't know. I don't know when you decide that. Is it when you start to turn while you're backing up? Is it only when you come forward? Like, I don't know. But they've decided GPS 154 is what matters. And so then we're looking at this chart, all this different information on the chart, the shift position, the speed, the engine, the RPM, that yaw rate sensor. I still want to know about the yaw rate sensor. I'm gonna have to go do a little homework of my own just to get a sense of that, because it seemed like to me, just objectively, a high rate of yaw going on in all of this data. And that's just a type of thing. Yeah, I would kind of expect to see that in snow, but in general, like, not something you want to see on your vehicle at all. You don't want to see the wheel, the rear end getting all squirrely. That's not what you want. But I don't know how to read, I don't know how to read that chart. I don't know if it's really squirrely or not, but it just kind of looks like it. I would expect anything above 0 to be like, I'd rather my car not be doing that. I'd rather it stay in nice alignment, back squarely behind the front, everything balanced, etc. So the trigger for the first trigger event was the accelerator opening ratio, which he described as that's how much you're stepping on the gas pedal. So it's because she stepped on the gas pedal hard, it registered a 3-point turn. I don't understand these. I really don't. I don't understand the logic. The accelerator opening ratio. So she stepped on the gas pedal a little bit hard, doing a 3-point turn. Whatever, we get to his conclusion that happened on Cedar Crest, 3-point turn, 12:23 after the car had been turned on, with a clock variance of 21 to 29 seconds. So then if you sync it back to the real time, you just add some seconds here or there. Just throw some seconds on. And that gives you the regular time frame. So if you do that adjustment, like he says, you get to the 12:23:59 to 12:24:07 when the trigger event 2 is happening. Second one. So then that one, it showed some speed. Backing up, it showed a slight leftward turn. Now, I was trying to get a visual on this. A slight leftward turn means if I'm parked on the normal side of the road where I'm supposed to be, the right side of the road where I'm driving. If I'm making a leftward turn, I'm assuming that means from my perspective as the driver, I am turning the steering wheel to the left. And so what direction is that going to take my car? It's going to take me away from the curb. That's going to take me away from the curb. We had heard a little bit in the first trial. I don't think we've heard it in this trial, but that there is a slight curve in the road, in Fairview Road, kind of coming up to the Albert's house. If you're coming from the Chapman side, which is at the south, if you're looking at the map, like we've seen the map a few times. Cedar Crest is up at the north. Chapman is down at the south. If you're coming from Chapman, it's got like a little bit of a curve in it. But the curve is the other direction, isn't it? I'm not sure. But I noticed that slight turn because it caught my attention, because that's going away from the curb. If that's from my orientation as the driver, that means the car, I'm backing up and I'm backing away from the curb. So then we have the evidence of the wheels slipping because the acceleration is dropping, but the RPMs are going up right in the middle of all this, guys. This is down towards the end of what he's describing as the trigger event. The car only starts to slip like after it's already been backing up. So then we get to the geometry of how this happened. And I'm really not sure how this works, because if we have Karen parked out there by the flagpole, where several witnesses have placed her, Jen McCabe put her car placed out there, waiting out there. Ryan Nagel had her stopped out front, but then, scooting forward a little bit. So in that kind of general area of over on the towards the left side of the property, nearer to the flagpole and the fire hydrant, according to this, she went forward 34 feet. Okay, but then she backed up 53 and a half. So that means she went forward 34 feet. Then she backed up that same 34 feet to where she started, and then also backed up another 20 feet and was still accelerating once this data stopped being recorded. So where is John? Where's John? Where's John? Was he where she dropped him off? Is he 20 feet back? Is he not even in the picture yet? Where's John? Where did this collision take place? How does John get projected to end up by the flagpole if she's backing up another 20 feet beyond where she started off at the flagpole? I don't have an explanation for any of this. Commonwealth didn't give me one with this evidence here today. At the end, she was still at 74% throttle and going 23 miles an hour, according to the data. He said the threshold for a trigger is 30% throttle with the car shifted into reverse. So why do we not have an additional trigger? If that's what the car was doing, he said it'll stop recording 5 seconds after unless there's another triggering event. The threshold has been met by his own testimony. Why do we not have another triggering event that continues to record the data until we see when the car comes to a stop, and then what it does after that? Where does it go after that? We're still not even sure. Did Karen just leave, pull away straight, go down to Chapman? Or did she pull the U-turn out front and go back up to Cedar Crest the way that they came? We don't know. So the 30% shift with the shift in the rear, the 30% throttle is the threshold for the trigger, but for some reason we didn't get another trigger here, even though she exceeded it. So yeah, then we just heard about, he did some things, a process called integration to get the velocity. And so once again, with the clock time adjustment, he puts it at 12:32:04 to 12:32:12. And he was given info about the final lock event on the phone. You already knew about the final lock on the phone because you had that in your slide. You got that from Ian Whiffen, who wrote about it back in January. So you already had that event. It was in your slide. You were not like given that at some point later and needed to address it. Like it was always there. It was always there. What you didn't have was how can we tweak the clocks to make it fit within the timeline? That's what they needed to come up with. So as far as we know, the car is still moving at the end of that trigger event because we only have the 10-second window. No new trigger got recorded, even though the trigger threshold was exceeded, and we don't have an explanation for any of that. So conclusions that he reached regarding her Lexus, that, so first off, then he looked at, this was a total aside, like the jury didn't catch this at all, I'm sure. How could they? Because I don't think they've heard about Karen's Wi-Fi yet. But Hank is already down another road, asking about the differences to get from Fairview to Meadows, depending on the different routes that you take. And he gets an average speed to get there in 4 minutes and 15 seconds. Depending on which route you took, you'd have to average speed of 32.4 up to 39.5 miles per hour. And he puts it out there like that sounds very reasonable, like those are perfectly normal average times. Not in town. Not in town they're not going to be, and not in town during a storm they're also not going to be. Didn't we just get a big data point by data point breakdown of Karen coming up Cedar Crest and doing a 3-point turn and going down Fairview, and she's going like 15 miles an hour the whole way? But suddenly we have this high average 32. Now bear in mind, for this to be average during in-town driving, you're accounting for the fact that there will be stop signs, there will be stop lights, there will be times that you have to come to a complete stop before you can continue. So that is going to mean you have to be driving that much faster when you're actually driving to offset that time that you are not moving forward. So exactly how fast is Karen booking it back to Meadows? The jury has no idea what that was about because I don't think they've heard about Karen's Wi-Fi yet. We know because we watched the first trial, those of us that did. That's what this is about. 12:36, she connects to the Wi-Fi at Meadows. That means you have a very, very, very narrow window to get back there. And what's fascinating is that for all of that relying on Google Maps, Google Directions, Google Routes, etc., he didn't pay any attention to Google's driving time estimates, did he? Because Google does not estimate that you'll be able to cover this distance in 4 minutes and 15 seconds. It does not. So his opinions with respect to the trigger events, the first was caused by excessive rearward acceleration that took place during a 3-point turn. Okay, so we know that this trigger can happen just from a normal 3-point turn, not a crazy collision, driving straight at somebody to knock them out of their shoes type of, no, literally a normal, perfectly normal low-speed 3-point turn produced this trigger from excessive rearward acceleration. There was 8 minutes and 5 seconds in between trigger events. And then the second trigger event was due to a transition into reverse with the high throttle. And it still had high throttle at the end, 74%, but for some reason, no new trigger event. It just stopped. It covered 87 feet total distance, 34 feet forward, and then backing 53. It was still accelerating at the end of the event. And it matches all of the phone data that puts him in front of 34 Fairview at 12:32:04 to 12:32:12. That's his ultimate opinions about Karen's car. So then we moved on to the tail light. Disproving with the photogrammatic analysis, okay, that Karen broke her tail light by running into John's car like we all saw happen. Why? Well, because you don't see those pieces in the snow. I'm sorry, how high def is this camera supposed to be? Under the best circumstances, with a good camera and good lighting, I don't know that you're going to expect to see a couple little pieces of tail light fall into the snow. I just don't know that that's going to be picked up on camera. But then you throw in, this is at night and this is not well lit. And this is just a security camera. It's not made for that type of definition. So I don't know why you expect to see that. But we got this very sciencey process and explanation, because once again, we got to go do more scans of things. God, the just amount that they spent on this, it's just mind-boggling. It's mind-boggling what they have thrown into this. So first, we do see, the snow's moved. We see at the very least, there's been some snow. Snow moved off of John's car. But through his magic of photogrammetry, according to him, he's proved there's not enough overlap to allow any kind of contact with her right rear tail light. So his conclusion, that did not break her tail light. It didn't happen. I noticed he had her going at 0.7 miles an hour, but he never translated that into anything like, so what sort of force would that generate with a 6,000-pound vehicle? What kind of force would that generate? And likewise, what kind of force would be expected to cause, I don't know, any type of observable damage to like that steel frame underneath John's bumper? What sort of forces would you expect to be produced by that? They have the data available to do it, but they, for whatever reason, are choosing not to present that. So bottom line, doesn't matter that the cars didn't touch in the right place. That's his conclusion. So the fact that you saw it move doesn't matter, because we measured when Karen's car came to a stop, not when John's car moved, which would seem to be the best time frame for identifying the exact point when there was a collision. When you had a reaction, you had a visible reaction to that. That's not the point that we measured from, but we measured from the point when Karen's car stopped moving, and decided based on our scans that because they're very good scans. You saw how the fence post, it didn't even move. It's a very good scan. And so based on that, the cars, they didn't even touch each other in the right place. So totally did not cause the damage to the taillight. Don't worry about anything else. It's just it touched wrong. And so then he looked at John's injuries, and boy, the finger paints, man, the finger paints are a low day for science in the courts. I can't believe sometimes. I try not to be too jaded about what to expect, particularly with scientific evidence in courtrooms in the United States. Guys, trust me. I mean, the bar could hardly be lower. And yet, I'm still amazed. I really am, that you can just stand next to the car and kind of lean into it, you know, while it's backing up, and just, you know, put your elbow into it. Like, why not? Why not? And that's science. That's science. Now, of course, this is not John's actual movements, and it's not intended to be an actual model of what he did, because the pedestrian impacts are very sensitive to specific angles. Yeah, they would be. Like if your feet are over there behind the car, then you're going to get hit by the bumper. Like you're going to get hit by the bumper. But how you're oriented can affect perhaps how you rotate, the number of steps you might need to take. Why would you rotate, you ask? Why would a person rotate? Because you're not hitting them in their center of mass, right? That's why. That's what we've been saying. The problem is John has ended up at some distance from the roadway. So did he get thrown there? Or now it sounds like they're saying he walked there. He rotated, he got stumbled. Okay. But once again, he would be, the momentum would be taking him closer to the front door of 34 Fairview if he was hit where he was supposedly, you know, left over by the flagpole. Then he would have stumbled past the flagpole. Like, I just, very little of this is making a lot of sense as far as just matching. The John's GPS data never showed him going over towards the neighbor's house. That's where he would have had to go for this accident to be taking place the way that they're describing it, and for him to end up over by the flagpole. But the phone data only shows him getting closer to the front door. So none of this is making an awful lot of sense, but it sounds like he did a lot of science, didn't he? And they can't replicate all this stuff. They modeled all these different possibilities, got all kinds of different results. Yeah, you think? You don't say. You don't say. And how many of those produced results that are not like what you have in terms of the damage to Karen's car, the injuries to John, and where he ended up, and so forth? How many times did you have to model it before you came up with this? I'd really be curious about that. But they don't know where he was. They don't know how he moved. They don't know if he moved. We had that ridiculous video of him leaning into the car while it's backing into him. He's now pointing at scratches on different parts of the car and saying, look at where this part of the car lines up with John's jeans. It's right there on his right hip. Then where's the paint on his jeans? Because the paint is scraped off the car. The paint is scraped off the car. So where is it on his jeans? Nobody found any paint on John's jeans. Then he didn't remember that there was damage. There's that chip kind of up high. He didn't remember that. Brennan tried to walk him into that a couple times. He didn't remember. He just remembered there's some scuff marks on the bumper. The punctures in the sweatshirt, those coincide to the marks on the arm. No comment about the puncture in the sweatshirt and how that lines up with the taillight, or does it? Does not look to me the way, like, what a sharp taillight might do to a piece of fabric. It looks much more like a snag, like something you get from, a tooth or something. And then he really actually is going there. He's actually going there with that laceration. That laceration over John's eyelid is because he was hit by the spoiler of the car. And yet all he got was a little cut on his eye. He's actually I can't believe of all things that you expect me to believe, that he gets hit with a 6,000-pound Lexus by the spoiler, okay? Small. This is like a small. This is narrow. A narrow little, piece of painted metal, rolled over painted metal, thin, slaps you right in the eyeball at somewhere between 13 and 24 miles an hour. 13 and 23 miles an hour is what we have for this these speeds during the trigger event. You get hit in the eyelid by a 6,000-pound vehicle at 24 miles an hour, and all you have is a little cut. Dude, I'm sorry. No, your eyeball is exploding. Your orbital bone is busted. I mean, this is nuts. This is nuts. Think about how this moves. Like, you could see it even just when he was leaning into the car, right? That's how your momentum is going to work. Your body is going to try to stay where your body started. The car is trying to move it somewhere else. So you're going to be reacting into the car. And you saw him do this. I mean, I don't even think it was intentional, but when they're doing that backup test, you see him kind of lean into the car and then roll off. Think about that now if this theory works, right? Because now remember, not just that the eyelid is up there at the spoiler level, but the knee is also at the bumper level. And guys, he had a little scrape on the outside of his knee. He had a little scrape at the outside of his knee, right at the level of that bumper. So I want you to think about how this would actually take place if this type of contact is made. If his bumper is hitting his knee, then that is the first point of contact. The bumper is the most projected part of the vehicle. So unless John is, leaning into him, leaning into the roadway or something like that, some very strange angle, his knee is getting hit first. So his knee is hit first. And then what's going to happen? His upper body, the momentum is going to try to keep it where it started. So then his elbow, is shorter on the lever of the torso. It's going to hit next. And then his eyeball, his eyelid is going to be the last thing to smack into the back of that Lexus. And all he gets from that at 24 miles an hour, 6,000-pound vehicle is a little cut on his eyelid. I'm sorry. You can expect me to buy a lot of stuff, at least entertain it. You can expect me to entertain a lot of possibilities. That's ridiculous. That's just insane. It really is. A scrape on a knee and a cut over the eyelid, and you're going to try to make that a car accident? It's honestly worse than the paint and the injuries on the forearm, guys, and trying to make those consistent with the tail light. All right, let's look at this. Let's look at this photo I was talking about. Let me pull it up here. Right here. So I screenshotted when we were looking at this particular photo. And the reason why, let's see if I can make it a little bit bigger. Yes, I can. The reason I screenshotted this part of his presentation is because this is when he said that the injuries to the forearm were consistent with the geometry and orientation of Karen Reed's taillight. Here's the problem, okay? Look at, I don't know if you guys can see this if I do this. Look at the angle of his wounds on the arm, and they're all parallel all the way down the arm. They're all parallel. If his arm is straight, they're all parallel. But for him to get this paint to match, he's got to bend his arm. So his arm is at a 90-degree angle. So you got to take John's arm and turn it 90 degrees. And then what would the pattern of the injuries be if it was consistent with his arm at a 40 degree, or 90, saying 45, but it's a 90-degree angle? they're going to be like perpendicular to these ones up here because your arm now is perpendicular to your other arm. So they're going to be running more lengthwise down his forearm if they're following this same pattern. So I did not see at all that this demonstration, as he's depicted in this photograph here, establishes that John's injuries are consistent with the geometry and orientation of the right rear tail light at all. No, you got to bend his arm. You got to bend his arm 90 degrees to get it to work. And then if you do that, his injuries wouldn't look like that. So I don't know, guys. I don't know. This is all a little bit of a mess. Then we get into John's point of rest, he says, was 7 feet off the roadway. According to whom? Great question. We don't know. We don't know. There's no documentation. I don't know how we got to 7 feet off the roadway or who said that. Perhaps that will come out in cross. That will be explored, the basis for that assumption. The sneaker, according to his label on his presentation, was at or near the point of rest, but no, it was not. It was in the road. And so by your own testimony, it had to be at least 7 feet away from John. Isn't this why crime scene measurements matter? This is why they matter. It's not at the point of rest. It's 7 feet away from the point of rest. Then you have the blood in the hat found in the snow. No issues with why that blood is on top of the snow that was not there. Wasn't there at 12:30, wasn't there at 1. Why is it on top of that snow? No real concerns about that. And then, we heard that there's head injuries are the most common injury to get in a pedestrian vehicle impact. It seems unsurprising. It seems very likely that you would hit your head, or you would get whiplash, and you would get like a concussion. You get some kind of brain injury like that. It seems very unsurprising to me, because you could get that even if you just get, it's a low impact and you just get a bruise, or maybe not even really a bruise, but you just get knocked, you're still gonna hit your head. But then they had this whole studies looking at the literature on these falls versus the assaults and the kind of injury pattern, I guess, to help you tell if it's a fall versus an assault. What if it's both? What if it's both? What if somebody is punched in the face and then fall backwards? Because that happens not infrequently. What if it's both? Why does it have to be either or? It doesn't have to be either or, but something about this study is there to tell us if it's more consistent with an assault or a fall. And so the fact that his jaw wasn't broken and he didn't have other facial fractures apparently means it's probably a fall and not an assault. I don't know what counts as a facial fracture, but because the orbital roof, I would normally, personally, layperson, consider that a facial fracture. It's your eyelid. It's kind of over in the more front part of your skull. I don't know if that counts or not. You can get your orbital bone broken in a fight. That's another not uncommon one to see. See that in the boxing ring a fair amount. So John didn't have any of these things, therefore it's probably a fall and not an assault, but those things are not mutually exclusive. It doesn't have to be one or the other. It can be both. Then we saw him dropping the dummy onto the ground. Just failed that trust test with the doll. And then we saw a chart that looked at forces and what type of fracture it produces, a linear fracture, a stellate fracture. So now we know where Mr. Alessi was getting that question for Dr. Scortibello about the type of fracture pattern that John would have if he fell backwards onto flat ground. Wouldn't it be more of a star-like pattern, he said? She did not agree, thought linear would be fine. We did not get any greater elaboration on that chart from all of that, but it just now brought up, oh, hey, now we're talking about star-like fractures, and now that questioning by Mr. Alessi suddenly makes sense. So we left the day observing that John O'Keefe, his occiput, gotta call it the occiput, because that's what he was calling it. Occiput it to your mom. John's occiput would fall about 68 inches because it's, it's low. It's back of your head. That little knot that you feel at the back of your head. It's generally what they're talking about. It's the occipital knob, occipital bump, something. There's like a name for it. I forget. It comes up a lot in anthropology because it's one of the things they look at with prehumans. Different shapes in different parts of the skull, and occipital bun, I think, was Homo erectus, if I remember right, but I don't really remember right. We're too busy occiputing it to your mom to remember what's erectus and what's not. So bottom line, we left the day with a debate over whether he is even going to be able to testify to whether he believes there was a collision or not. We had the argument from Mr. Alessi. He's arguing it's the ultimate question for the jury. Brennan says, no, it's not. And by the way, if they're saying in opening, this is such a terrible argument. What they say in opening is what they expect the jury to conclude. And if you're saying it's the ultimate issue, you're saying it's for the jury to decide, not for one of the witnesses to decide. So these are not inconsistent things. To say in opening, there's no collision, that's what you're going to conclude based on the evidence. But I do tend to think he's right that it really isn't the ultimate issue. Alessi had the case law, and I haven't seen it, but I'm sure somebody caught it. It's probably going to be out there on Twitter, so I'll be interested to see that case law. But normally, I would not expect this to be the ultimate issue. Whether or not there was a collision is not the ultimate issue. Just like whether somebody was stabbed, he used this analogy of if somebody is stabbed, you don't get to put a witness on the stand and say that they were stabbed. You do, though. You do. That happens all the time. Like from a medical examiner, an ER doc, anybody, they will testify all the time. Here's a wound. Yeah, this was a stab wound. So I don't really see this being the ultimate issue. It is an ultimate issue, but it's not really invading the province of the jury because there can be a collision that's not criminal. And so the ultimate issue is she guilty of the crime or not? And the law is really clear on that. Yeah, you don't get to offer opinions about whether the person is guilty or not, but about fact questions that lead to the conclusion of whether the person is guilty of a crime or not, I think that's usually okay. So want to see his case law, but offhand, my knee-jerk reaction to that one is I think it's it's a creative objection, but I don't think it's a winner. I don't tend to think it really is the ultimate issue. But we'll see what Judge Bev says. She's of course not going to rule from the bench, not going to give us any sort of guidance over the evening to be able to come in tomorrow morning, know what we're dealing with before the jury comes in. But hey, late start tomorrow, guys. Late start tomorrow. That's cheerworthy. Okay, I am going to take like 3 minutes here, go and refill my tea because we've got a big queue, and I will see what I can do to get this get myself a little bit rehydrated, and we'll go through your questions and comments, and yeah, see where we're at for the day. That's our wrap up. It was excruciating, but hey, it's over. So all right, I'll get some tea and be right back. All right, guys. Thank you so much for sitting tight. I feel better already. Little tea to keep me going in the afternoon. Our morning came early today, guys. Can't lie. I was getting all used to this early schedule. Then she goes and gives me a holiday. It's like starting over from scratch. Let's see what you guys have had to say. Michelle, Google Crash 99, the first full-scale human volunteer crash test for chiropractic. It's an article, the spine and low speeds impact crashes. Let's just say 3-day program, 7 miles per hour, human volunteers. Kind of crazy to think about human volunteers for injury, types of accidents like this. I'm not super familiar with like where exactly the line is drawn when it comes to the ethics of human experimentation. Obviously, you get to do some things, but obviously you get not to do others. And what people consent to or not consent to, seems to be a little bit of the issue. Like part of the problem with my understanding anyway of some of like the vaccination tests, you can't do it. You can't do a blind. You can't do a double blind study because you can't, give somebody a disease and then give them a placebo. Like that would be unethical. Not allowed to do that. So they have to, structure certain types of experiments in different ways. But can you volunteer to be hit by a car? See what kind of accident? Apparently you can. I don't know where the line is drawn between what kind of human experimentation is okay and what's off limits. But interesting to know that has been going on. Z, Aperture doing presentations and demos at Commonwealth conferences, but they still botch investigations, whilst ARCA is working with NHL, DOJ, Department of Defense, and saving lives in real life. Well, Aperture apparently, at least this guy's company, got off the ground by suing carnivals, would be my guess. I mean, he's talking about our Disneyland, he's talking about amusement park rides. And that's what he did a lot of, study on and research on and stuff like that. It was, came out of his 40-minute resume. I mean, I will grant you, I've seen some hairy looking amusement park rides. Some little county fairs with like a zipper. Looks like maybe it's on its last legs. Might be rattling a little more than you'd like to see. Sure, there's plenty of that stuff out there. But if you're an expert witness, then it's to be expected that that's what you're going to focus on. Is you're going to focus on your client base and serving them, giving them what they need, what they want. And I mean, the same incentives work for ARCA as well. ARCA is not exempt from, profit motive just because they're ARCA. But it seems like their area of expertise is not, it's not limited to, accident evaluation for lawsuits. It's really preventative types of studies. So just maybe a little bit of a different approach to similar types of problems. OCD Shaggy, any chance the defense introduces Dr. Wolf as Crash Daddy? Thanks for streaming this live. No, sadly, no chance, but it's okay. It's okay. We all know. He just has to show himself. He just has to show himself on the stand. And we already know, oh, there's a Crash Daddy for us. AP, frame rail. It's a unibody. He overpaid for his PhD. There are no frame rails behind the dash plate of a unibody car, only in the engine bay. See, my chat knows all kinds of stuff. They know interesting things. So, hey, he showed me a picture of what he says is a frame rail, and it did indeed look like a piece of steel, like a big piece of steel going across the back of John's Traverse. Now, I don't know what that's for. I don't know how much of that is that structure for the car. Is this like part of the crumple zone thing where, the bumper will collapse, but that steel bar will prevent my gas tank from getting punctured and exploding? Maybe something like that. I don't know. I don't know. Interesting insight here. Rhonda, Iowa girl. He actually said the car wouldn't register hitting a 216-pound guy. I find this convenient. Very convenient. Very convenient. Who would even expect a crash recorder to record a crash? Like, have you been following this trial? We're in Canton here, okay? Don't you know that's not how things work? In Canton. Michelle, Commonwealth Direct is like a local band headlining a world tour concert. They stink, but the anticipation and sidebar teasers make Cross so much better. I do worry sometimes that I might be getting ahead of myself with anticipating the Cross. Because I do. I feel like this has been a lot of just very poorly organized, poorly articulated, poorly presented information. I understand their bottom line that they want me to get to. But as far as walking me through their process so that I can see it and internalize it and agree with it or not, evaluate it independently and decide if I believe it or not, I feel like this has been very poorly done. So if the jury is inclined to just, hey, I'm going to pick a side that I believe and give all of their witnesses the benefit of the doubt, then you have what you need. But if the jury is actually thinking critically about what the evidence is and what it proves, I don't know that these guys have been super helpful, because they really are far more on that just trust me, bro end of the spectrum when it comes to explaining their theory of everything. Sentient Dreamer, hearing Welcher explains how they got and used Burgess. Well, he was convenient. He's been convenient, isn't he? The thing that stood out more to me about Burgess, kind of after reflection, of course, after reflection a little bit, sometimes things just have to simmer for a little bit. I mean, the number of times that he revised his CV to say he's working on this degree, still working on this degree, 2016 to 2018, 2019, 2022. He's got all these different dates on his resume. But how all of it really, if it wasn't intended to be deceptive, it certainly had the effect of being deceptive. And so that you wouldn't notice that is just, it's quite hard to believe. especially Aperture yourself, your boss, putting it on your bio page. It just seems a bit difficult to believe that it never crossed your mind that there was any kind of way that somebody might look at this and think, oh, this guy has a bachelor's. This is legit. This guy's background and training and education is what I expect it to be for somebody testifying in this capacity. So the very fact that it was misleading and apparently, in fact, even did mislead his own employer, that's really what stands out to me about it, because it's hard for that to be an accident, particularly with how many times you went in and modified it. You went in and modified this several times so that you could maintain that potential for misinterpretation, but then you turn around and blame the people who took it at face value as though it's their fault. So that to me is kind of classic presenting things in a way to obfuscate and not in a way to clarify. If you want to be clear and you want to minimize confusion, you would just say, I don't have a bachelor's. There really does not need to be anything else said about it. You don't need one for this line of work. I have this other training. I have these other qualifications that I got. I've worked in this field. It's acceptable to not have any kind of college degree. That would be enough if you wanted it to be clear. But if you want to obfuscate, then you use these, you use wiggle words and you use qualifiers and you build all this deniability so that people will reach an inference, giving you the benefit of the doubt. But then you get to say, no, that inference isn't what I intended. That's your mistake. That's not me. That's really what stood out to me about Burgess more than anything else at that point, is how he had set that up so he could blame us for misunderstanding his education status instead of taking the responsibility for getting it right in the first place. And he still to this day, hasn't fixed the fact that the degree he's claiming he's been working on all this time, through how many iterations of the CV, the degree doesn't exist. Oh, that's just an error. That's one of the errors. How unfortunate to have a bunch of errors in your CV. 4 knots to nowhere. Why don't we know the exact route? Oh, the Commonwealth lost Karen Reed's location data from her phone. LOL. But they also went and got her CDRs, right? We know that from the first trial. They went and got her call detail records, totally did all that, did the cell site location analysis to try to pinpoint where she was, went around and collected all the surveillance data, the surveillance video from all the different locations the following morning, got her on camera in a bunch of different places all over town. And somehow none of this could narrow down where she went, what route she was on. I don't know the answer to that. Greg, Welcher's communication is so bad, I'm starting to have an opinion that he didn't write this report himself. Well, I don't know about the report. The PowerPoint is coming across as very collagey, like it almost comes across as more of an art piece than a helpful demonstrative that clarifies and lays out the information for you. It's just like a quilt of different screenshots that have been like cut and pasted and put next to a photograph and so forth. It's a very suggestive one in many ways. I mean, just look at that one we just looked at with the blue paint arm next to John's lacerated arm. And you put these side by side to kind of make it look like they're kind of similar. If you ignore the fact that the one guy's arm is perfectly straight and the other guy's arm is at 90 degrees, yeah, then maybe it would. But it's just put together in a way to suggest that without pointing out. Here's a little bit of the issue with reaching that inference. He's really not a good communicator, and not just that, he didn't seem to know what was in his report. He didn't seem to know what was in these slides. He's confused about where they are and what they're looking at and where's this one. Very amateur hour. Michelle, what are your thoughts if the defense rests when the Commonwealth is finished? In closing, the defense can stress the Commonwealth can't explain his injuries or motive. You could. It's pretty much always an option you have on the defense side to just go ahead and rest and rely on the burden of proof argument. And that seems to be much closer to what their strategy is this time than it was during the first trial. The first trial, they came out guns blazing. Karen Read was framed. And so implicitly assumed a certain burden of proof to back that up to the jury. By making that commitment in the opening, you've signaled pretty loud and clear you're going to be able to show that. They have not done that this time. They have focused on the questions the investigation didn't ask, the problems with the investigators, the reasons they had not to look too closely, and so forth. So they could, in theory, just rest at the conclusion of the Commonwealth's case. I don't love it just because I think it leaves too many things on the table. I think that they do need to hammer on John's arm. These are dog bites. These are dog bites. These are not taillight scratches. You can't just let that go unanswered by Welcher. This is scratches from the tail light. No, you need to point out that's a dog bite. It doesn't even matter what dog it is. What matters is that there is no room in the Commonwealth's explanation of what happened here for any dog bites at all. Their explanation does not incorporate a dog. So if those are dog bites and the punctures in the clothes are punctures from the teeth of the dog, the claws of the dog, whatever, that needs to be answered. They got to get the rest of that group chat, Proctor's group chat, into evidence. They just have to. They made that commitment in opening. His own words saying no shit on the homeowner because he's a Boston cop too. You got to get that in. If you're gonna tease that, you better be prepared to follow up on it, or the jury is not going to be happy. So I don't think it's likely that they will do that. It is, I think, more conceivable this time around in this trial than it was in the first one. Certainly, it's more feasible that they could do that, or even that they could just have a very abbreviated case because there's not that much that they do need to put on. But there are some of those basic things that I think they do have to answer, and just the other seeds that they've planted. If John didn't have hypothermia and he didn't have frostbite, that also seems important. That doesn't really fit within the Commonwealth's theory. And just sometimes it's a matter of knowing what questions we should ask. Like I have lots of questions. I don't know if some of them are good questions. So if I know that there's another expert, for example, who is asking similar questions, like, hey, how did John's body temperature get to 80 degrees from being outside for 6 hours, but he doesn't have any frostbite? If a medical expert is asking that kind of question, then I feel really good and validated that I am also asking a good question. And even if I don't have the answer to it, that's okay. It's not my burden to provide the answers. It's the Commonwealth's burden. And they, again, have to provide an explanation that's consistent, that accounts for these kinds of details. So if there's no room in their theory for a dog, there's no room in their theory for some sort of death event that does not coincide with being outside in the cold for 6 hours, then the Commonwealth hasn't met its burden. So I think that's where the defense is likely to go. My Mini 67, the heroic hair. Valid clocks are John O'Keefe, Karen Read, and infotainment. Running clock is text stream. No data on SD card. 3-point turn does not get recorded as an event. Events are from anomalous sensor input. Hope this helps. Kind of. I mean, trying to sort out everything. No data on the SD card was that came out during Burgess's testimony, and it was bizarre, wasn't it? After making this whole stink about how there was lost data because they didn't get what they expected they were going to get, but then discovered that this micro SD card had been overlooked. So he went and pulled it off the board. But ultimately, he didn't get anything useful from the SD card. So where did this, user data come from? I'm just the chain of all of this and trying to keep track of what exactly they have and how they got it. It's very confusing. It shouldn't be that difficult. It should be pretty straightforward. Here are the sources of data. Here's how we got them. Here's what we considered. If we didn't consider this one, this is why. If we didn't have this, this is our explanation for why we didn't have it. I mean, it's should not be that hard to be systematic about science and data. I can't believe he pulled that back out in that closing. Facts, science, and data. Yeah, we know that the 3-point turn itself was not the event. The event was the acceleration while it's in reverse. That was what he said the triggering event was. But we had the acceleration in reverse at 34 Fairview at the end of the trigger event, but it was not causing a re-trigger. They bought this exemplar Lexus to do all this testing on, and I have yet to hear anything about these thresholds, how these events register, what causes them to register. And so isn't that exactly why you get an exemplar vehicle to do the testing on, so that you can see, oh, when you do this, the vehicle records it like that. And then that helps you understand the safety system better, and you get a better picture of what would need to happen to produce these types of event recordings in this system. But I haven't heard anything about that. All I heard is just they did testing. They got the exemplar vehicle and they did testing. What testing? What testing? I'm still not clear on that at all. Lawyer nurse, this is all SB data and presentation. Why is he repeating it when he should be covering biomechanics of John allegedly being hit by Karen's car? Well, maybe they wanted to put off getting to that point where the spoiler hits John in the eye and leaves nothing but a small laceration, despite being a 6,000-pound vehicle moving backwards somewhere between 13 and 23 miles an hour. Maybe they weren't excited to get to that. Perhaps they suspected that would be a tough sell, as for me, it most certainly is. I'm not buying this. The car hit him in the eyelid, guys. They're straight up going with the car hit him in the eyelid. The car hit him in the eyelid. Didn't even so much as bruise him, just gave him a little laceration. Yeah, that's probably why. Hi, Jud Welcher, facts belcher. I don't know about them facts. They're facty. Are they facty? Like they're sciency? Anita Whiteclaw. First and foremost, AB, you're a gem. Second, this witness feels to me like he's winging it. I didn't watch the first trial. The Commonwealth is failing in my eyes as a juror. I love getting the perspectives of people who didn't watch the first trial, because I've said from day one, I can't put myself there. I can't. I would love to be able to, but it's not reality. I watched the first trial. I know what's there. It's in my head. And there's just no realistic way to be able to put that aside and evaluate what we're getting. It's too much of a morass, what we already know, the new stuff that fits in, how it relates to the old stuff, and all of that. So I have made no pretense of trying to do that. But that's why it's so helpful for me to hear from people who are hearing this for the first time, because my impression is that they're doing significantly worse this time than they did in the first trial. But it's really hard for me to be able to base that on something. Now, Trooper Paul was bad. Trooper Paul was embarrassing levels of bad. But is the pirouette and the crime scene speaking to him, and it happened that way because it just did, is that worse, what we got from Trooper Paul, than today hearing from a guy with a PhD that the spoiler of Karen Reed's car hit John O'Keefe in the eyeball, cut his eyelid? Is that less ridiculous? I don't think it's less ridiculous. I really don't. So I think they've dressed some of this up in a more attractive way, but so much else in the case, it just does not seem to be going anywhere near as well as it went the first time. I think Jen McCabe got undermined a lot more this time. She comes out a lot more clearly as being unreliable, being shady, having a lot to hide. The taillight pieces and the lack of the chain of custody, I don't know that they've done it better necessarily this time. It's just always been, confusion and a little bit of a problem area. But certainly the glass, they did that whole chart with the glass and what matched and what didn't match. And the fact that the glass that's found on Karen's bumper doesn't match anything except a piece of glass that Proctor finds supposedly 3 weeks later out in the street. That was certainly brought out a lot better. So maybe, I don't know. Is there a better indication this time around of, if not a full-on frame job, at least a lot of sloppiness that left the door open for something like that to happen? It feels to me like there is. And Proctor being this ghost, I don't think is helping the Commonwealth in that regard. I just don't think it's helping. He's this boogeyman that you've hidden away, but if he's a boogeyman, that's not how you want the jury thinking about your lead investigator. So it's good to know this. I mean, it confirms my gut, which of course makes it a great thing. You enjoy hearing the things that confirm what you tend to believe. I like hearing this. I do have the impression that that things are going not as well this time as they went the first time, even with the distinctions between Hank being technically a better lawyer than Lally. Lally just killing us with the repetitiveness, saying the same thing over and over again, having to call every single witness, no matter how trivial, all of that. It was excruciating in so many ways. And yet I feel like Lally might have pulled it off a little bit better than Hank so far. So that's my impression, but it's just so hard for me to separate myself from the first trial that I don't like to put too much weight in my own impression. JL, my AI says 1400 RPM and her Lexus gives 4 to 5 miles per hour in reverse. It would need 6,500 to 7,000 to hit 25 miles an hour. However, it said that a safety feature doesn't allow you to hit that speed. I don't know if reliable because AI. Yeah, good information. The RPMs were very surprising to me. I'm sorry, but even an idle RPM of 600, 700, that seems very low to me for a gas engine. I totally expect a diesel to run like that, but a gas engine, I don't know, just seems low. I expect to drive a gas engine at, minimum of like 1,500 RPMs. And when you're just like normally driving down the street, 2,000, 2,500. I mean, there's going to be a lot of variation with the car and so forth. But that's just the gas engine operates at a higher RPM. So I don't know how it works in reverse. I don't know what kind of safety features are at play that would keep you from doing that. 6,500 to 7,000 RPM surely would set off some kind of notice, something. I mean, that's high. Surely that's redlined in this car. I mean, that would be redlined in my sports car. I'm pretty sure I hit redline at like 7,000 RPM. So surely that would redline the Lexus, and that's going to register somewhere. I don't know. It's a good find, but it is always hard to know how much faith can you put in the AI. AI does lie to you guys. It will lie to you. It will lie to your face. Done it. Done it many, many times. Gray space. Tech stream and infotainment are separate. Burgess got the info from the chip. Welcher got the tech stream. So they're both relying on each other's data. This is not clear. I mean, I buy it. I believe what you're saying. I don't have any reason to challenge it. It's just not clear. And I thought Burgess did concede. There was no usable data from the chip when he went and did the chip. Have to go back and find my notes for that day, but that's what I recall coming out. And so maybe I'm wrong about that. But they're not clarifying these things. You might be right, but I didn't get that, and it shouldn't be that hard to get. You know, what did you download? How did you download it? I thought that Burgess was the data guy, so why are you doing the data stuff? Even just something very simple like that. Please explain to me why you both have your hands in the data. What data sets you each have your hands in. It would be helpful, because this might be right, but that's not at all clear, I think, from the testimony. Audrey Sova, I just explained multiple meters and Horace Latin poetry to my 8-year-old and was still more concise than this guy. Oh, you had a conversation about aeolic meters, did you? How exciting. I never got into the Latin poetry. It was not my thing, but you know, I did the classics minor in college, but I was more into Greek. I was more into the Greeks. Romans a whole different thing. I imagine you were. The running on and the question in as just continue. Just do your narrative, sir, because I have no idea what you have to say or how to get you there. So please just take yourself on this tour through your PowerPoint. Wild way to conduct a cross or conduct a direct. Aunt Boo Boo, wouldn't Karen's team benefit from using a demonstrative simulation or even a physical model to articulate whatever the Commonwealth theory actually is? Yes, perhaps. I would love to see that. Please show me the model of the John getting hit in the eyelid by the spoiler. Okay, first in the knee by the bumper, because that would have to be first. The bumper is protruding the furthest out. John's leg is in the way. Then it's hitting his knee first, and then his arm's going into the tail light, and then his eyelid is going onto the spoiler. I would love to see that. Seems ridiculous. Just trying to visual it in my own mind's eye. It seems ridiculous. So perhaps it would be helpful. Mike Scott, Andrea Burkhart, why no digital reconstruction animation? Are database models allowed or are they avoiding it? Well, we saw they did some, right? They did do some. They recreated that 3-point turn. They did that little demonstration, that little recreation of the 3-point turn. Now ask yourself, why didn't they do that with the accident that they're claiming happened? Now ask yourself, why aren't they trying to model that? Well, they're building themselves a lot of wiggle room, right? Well, we don't know all of the exact parameters and the details can really matter. Great. Then just give me one. Just give me one scenario where this works, where it makes sense. It produces these injuries. It produces this degree of damage to the vehicle. It puts John and all of the other evidence where you found it. Just give me one that shows that. But they didn't do that. And so, yeah, perhaps we should ask why. They can recreate a 3-point turn and demonstrate that, but they're not going to try to demonstrate this impact. Why? Perhaps it looks a little too ridiculous when you go ahead and demo it. Nas, did he say she reversed and hit John O'Keefe with a 3/4 throttle? Well, she didn't say that's when she hit him. Because, of course, he doesn't know. All he knows is just that there was 5 seconds after a trigger event At the end of that 5 seconds, she is still accelerating with a 3/4 throttle. And why that is not triggering a new trigger event, we don't know. It exceeds the threshold, but for some reason, car isn't registering that. So we don't know if she's supposed to have hit him before this, after it. You would think before, you would notice. The car is going to react. Okay. Just because, yeah, it's a 6,000 pound car and yeah, he's a 216 pound man, but you hit that, especially you hit that, at speed, that's force. And the force is going to, equally react hitting the car, just like the car is hitting the body. So force being acted on the car, is that going to be enough to register in like the wheels not moving, the car coming to a sudden stop, even just for a split second? I don't know. I guess I'm gonna have to wait to ARCA to see if I can get those kinds of answers. But yeah, reversing and hitting John at some point in the middle of having the throttle 3/4 open. Judy V, wouldn't it be fascinating to hear jurors' questions? I zone out and depend on you to explain. They don't have that advantage, lol. Yeah, they don't. Jurors asking questions, it's a little bit of a touchy subject with the lawyers. They're not precluded from doing it in Massachusetts. They can. It's in the judge's discretion. Allow the jurors to ask questions. There's instructions that are out there in the forms for like how to handle it if you're going to do that. But it is pretty much, looked down on really everywhere. I mean, I don't know. Maybe there's a couple of outlier courts or outlier judges that are like, yes, it's great for jurors to be able to ask questions. We're going to do that all the time. Most of the time it's frowned on. It's allowed, but they don't really encourage it. And there's just a lot of reasons for it. It's an adversarial process. So it's supposed to be on the parties to present you what their best evidence is. If they haven't presented something, then either it doesn't exist or perhaps it's not admissible. And so if jurors are highlighting, here's the thing I would like to know, but I haven't seen it, often it's because it's not admissible. So in the first trial, for example, we got that jury question about wanting to see the cert report. It was like the first question they came back with, please, can we see the cert report? No, you cannot, because there is no cert report in evidence. I don't know if a cert report even exists. But if it does, it's not in evidence, and it would not be admissible in evidence anyway, because it would be hearsay. Reports generally don't get to come in unless you just go ahead and volunteer to let the other side's entire expert report go in front of the jury. Then they can see it. No objection, says Mr. Alessi. So just a lot of times with the juror questions, what they're interested in is stuff that is not going to be admissible or, just is otherwise kind of problematic. And so then you just run the risk that they're going to wonder, why don't we get to hear this, and just stuff like that. So it can get things a little bit messy, but sometimes like they did in the last trial, they'll ask the question anyway. They'll just wait till the trial is over and then signal kind of what they are paying attention to. But they're not going to get me explaining it to them if they have a question. They're going to be told, go back and refer to the evidence. Read the instructions already given to you. Rarely, if ever, are jurors given something substantive in response to a question. They're just told, you have all the evidence, go consider it, use your collective memories, refer to the instructions on the law. Audrey Sova, I'm an internist. My job is to ponder and inform. I don't sense this guy does either. Didn't get a lot of pondering. Reed didn't strike me as a super deep thinker. And like I said, he's more of a bro. He's the bro that you know from the golf course, and then hire him to be able to help you get your settlement, from your accident. That's just the vibe. Just the vibe I get. Informing, not in his skill set. It's not a good, clear communicator. Maybe he could be, but there's a reason why he's not being that in this case. Can't rule that out. But the bottom line is that is not what we are seeing from this witness. Megan O'Leary, I am so confused despite listening to attorneys on YouTube trying to explain it. There is no way a jury person could understand this at all. I don't feel like it's probably making a lot of sense to them. There's just so much that's so random. Even Hank, I think is falling into that trap of you forget what you know versus what the jury knows. You get so in the weeds with your own case that it's very difficult to get out of that perspective. It's just a problem that trial lawyers have all the time. You know it so well, the jury knows nothing, and you have to be able to keep track of what do they know and what do they not know, and make sure that they get everything that they need to get them up to your level, to where you are. And so Hank seems to be losing track of that whole sideline down to the 4 minutes and 15 seconds it would take to drive from 34 Fairview to Meadows. The jury has to be lost because they don't have the frame of reference to know what we're talking about. We that watched a trial last year and all of these pretrial proceedings that have happened since then, we know, it's because she connected to his Wi-Fi at 12:36. They don't have that background. So how are they supposed to make any sense out of that little sideline of questioning that Brennan went down? They have no idea what that's about or what the context is. So yeah, I have a hard time. I have a hard time imagining that the jury has sat through all of this and has a real clear vision of what the Commonwealth's argument even is. If we go back to the opening, the Commonwealth says the facts, science, and data are going to show that she hit him with the car. A why or a how would have been nice and would have been helpful. I think if I'm a juror, I would have appreciated that. It's going to show these specific things that are going to lead to the conclusion that Karen hit John with the car and caused his death. But we didn't even get that. We just got this facts, science, and data. And that just kind of seems like what we're seeing in the presentation. There's no why. The juror's not giving a why. They're not getting a how. They're not getting encouraged to look at the evidence and walk through it together so that we can all be on the same page about what we're doing with this information and where does it lead us. We're just being shown a bunch of things and told, here's what it means. But showing us what it means is always so much more persuasive. When the jury can look at the evidence and reach its own conclusion, they're going to be far more persuaded by that than just, well, this guy says this one thing and this guy says this other thing. Which one do I believe more? You're not going to have a real strong opinion if that's just your basis for making a judgment. But if you've walked through the evidence and okay, well, we have this fact, and because of that fact, we can infer this other fact, and here's how these things fit together, and you've reached that conclusion, that's a strong opinion. But I don't see the Commonwealth giving them that at all. Mr. Brownstone, why Aperture need 2 experts? Burgess set times that Welcher added context to accident reconstruction. Is Judson avoiding putting his name to trigger times? I really don't know why they needed both at this point. It's confusing to me, especially if he just went in and downloaded his own data anyway. It's not clear to me how much of Burgess's data he even relied upon. And I again, not overlooking Gray Space's comment from earlier. He did the infotainment. This guy did the text stream. But it's just such a mess as far as what is coming from what and how they interact with each other. And what their respective roles were. When you have Burgess on the stand basically saying, I have no idea what Dr. Welcher was doing, Yeah, we were on the same team. Yeah, we were both hired for this job. Yeah, we have some conversations over the course of it, but I don't really know what he was evaluating. Well, then, I mean, how do we even get to a scope of who's doing what? You know, that doesn't seem very credible to me either. But I guess that's a little bit aside. I don't know. I have no idea why they needed to. Hap. Wouldn't it be good to at least put Proctor on the stand, even if he took the fifth, or would the judge just tell the jury to disregard? Well, who? Is it good for who to put Proctor on the stand? You know, the Commonwealth? Especially if he's going to take the fifth. No, that's not good. That's not good. You don't do that. The defense? Again, it's very questionable whether this would be allowed to be done in the presence of the jury anyway. It's not preferred at all to invoke in front of the jury. But sometimes, you know, people do it anyway. Judges do it anyway. So it's not entirely clear that the jury is even going to know if he invokes the fifth. So in and of itself, that consideration, I don't think can play a huge role in whether you pursue somebody as a witness or even necessarily whether you call them as a witness. You call them because they have information you want to elicit. And then if they're going to plead the fifth, you deal with that and you deal with the implications of that and you sort out, does that mean other things get limited? Does that affect the questions I want to ask or not? I mean, are the group chats incriminating to Proctor in some criminal way? Not sure that they are. Not sure that they are. They certainly make him look bad, but I don't think that they're a crime. So does it even interfere if he were to take the fifth? You know, does it even interfere with your ability to get what you need from him? Not real sure that it does in this particular case. Gray space. It looks like he has 4 first author papers in the past 24 years and none since 2011. And he's the 5th out of 6 authors on both of the Sideswipe papers. So they did spend a lot of time on his resume, trying to kind of build him up as this research guy. He's done all these papers and the Sideswipe and the Toyota safety and all of these types of things that sound like they have a lot of crossover to the case, but he's basically the guy that provided a couple of footnotes to the work that other people did. He's 5th out of 6 authors. Maybe it's not that bad, but it's not his brainchild, I think is the bottom line there. Sentient Dreamer. Commonwealth isn't accounting for extra time the Lexus was pulled out and then back into the Sally port. I'm not sure defense even knows about it. That matters. Yeah, I mean, we're talking about the different testing. We're talking about the bringing it out to the site location. They did it during the first trial. They did it again during the second trial. So that seems like that's 2 key cycles each time, right? Loading it onto the tow truck, getting it out to 34 Fairview. Jury comes out and looks at it, get it back on the tow truck, take it back to, is it still at the Canton Police Department? I'm not even sure if it is or if it's in some kind of like temporary storage yard at this point. I would sort of hope so, but I really don't know. So yeah, I mean, there seems like there would be other things, and that's just, again, that's what we know. That's just what we know. If they're keeping this in a storage yard now, at some point they had to move it there, and you know, then what? Does it just sit there? I don't know how they track all of that at this point in time. That's why this guy having his particular key cycle as of September of 2024 just doesn't really seem that helpful. Does this police department seems like the type that has kept a detailed and accurate record of the times that they have started and moved the car? No, they don't. They do not seem like they have that kind of documentation as a priority. So I doubt they could recreate it even if they were so inclined. Henke is a cockwomble. How do we know they didn't use the exemplar to get the results they wanted and use those? I guess we don't know for sure. We are counting on the ability of cross-examination and review by ARCA and DeSogra, the other defense experts, to identify if something like that happened or if something like that was feasible. So perhaps this is a just wait for the defense to get going kind of situation. Kristen J, I'm really trying not to fall asleep. You are not alone. You are not alone, Kristen. That was a rough one for all of us. Amanda Hubbard, something that has been bothering me. Where is Karen's GPS data and health data? That has stuck out at me with all of the talk of John's data. Her data is never mentioned outside of the phone calls, texts, and the Wi-Fi connection. It's a good point because, yeah, there should be some, shouldn't there? And I don't remember hearing about it. Don't remember hearing about it. And even in that first trial, for example, when they were Tully was trying to chase Karen around, follow her path of travel for the following morning, the morning of the 29th, before she went to Jen McCabe's house. What did they rely on? They relied on the call detail records, not the phone itself, the information you get from the phone company. So why isn't this information just already available on her phone? We've heard, you're right, little to nothing about Karen's phone and what kind of data is on Karen's phone. So again, if we're not hearing about it at this stage in the trial, I have to assume it's because there's nothing there that's beneficial to the Commonwealth. But I don't know whether there's anything beneficial there to the defense. We're going to have to wait for the defense case, I think, to find that out. Rhonda, Iowa girl, is he aware a car repairman was there that morning? Jen told us that. Even the car repair guy was there. That was on the 30th. That was the day after, right? Because that's when she and Carrie went over to John's house and then had the little driveway meeting with Lank where they both forgot that they went to Jen's house first and then went to 34 Fairview and then went to Lank's. They both just happened to not mention that. But she remembered that even the car repair guy was there at John's house that morning. Everybody was there. What a slip of the tongue. Audrey Sova, forehead is still your head. Feeling cute, not a physician or anything. The whole forearm versus arm, he had to say that like 8 times. Like this is a really critical and an important and technical distinction that he needs to make. This is how a small man with an inferiority complex makes himself feel important like a doctor. This is the arm. This is the forearm. Yeah, that's a good point. That's a good point. Your forehead is still your head. Science sleuths. He makes a bad assumption. If John O'Keefe's car has no damage or snow moved at tail light height, there was no collision when collisions can have damage to only one car. Haven't we all experienced this? I've told the story now a million times, like not long before the trial last year, and I back out of the driveway and I back right into my husband's truck and I crack my taillight, leave taillight pieces right there on the driveway. It wasn't a ton. I didn't hit it that fast or that hard, but shattered my taillight. Nothing on his truck. Nothing. Not a speck. No sign of any type of disturbance whatsoever. So I have personal experience with that. Yes, it's an anecdote, but it's a thing that happened. And so if it can happen to me, how do we know it did not happen in this situation? There's no rule that says there has to be damage to both objects. Bev sitting on the scales. Okay, Trooper Paul, we got you. So took off his shirt, rolled his sleeve, bent his arm, held a glass, but not enough to bruise him anywhere else or cut his hand. Did I miss anything? I think you wrapped it up. I think you wrapped it up. It's not enough to bruise him even there. Even his arm is not particularly bruised. Certainly not broken. It's just got scratches on it. Even the abrasion on the side of his knee. It didn't say there's a bruise there. It's not bruised. We didn't hear about any contusions. He just has a little scrape. A little scrape. No bruise anywhere except right on the back of his hand, with the two punctate marks. Remember those little punctures? I'm still fascinated with those. We were kind of circling around maybe a spider bite, but it's winter. You know, what kind of spiders are out in Massachusetts in winter that might bite a guy on the back of his hand? Still no real good explanation for those punctures, but what I don't see is anything on the back of Karen's car that would cause an injury like that. We're past the taillight now. We're past the taillight. So how did he puncture his hand over there? I don't know. It's a weird one. Mystery question. Lisette Morales. Does it make sense for him to do a demonstration without a shirt? He had a sweatshirt on. Highly unlikely that the scratches would be that deep. I mean, yeah, so he doesn't have the sweatshirt on. That does matter if we were looking at like what sort of damage would be caused to the sweatshirt as a result of hitting a broken taillight. But he never, of course, takes it to the level of actually breaking the taillight, right? That's what ARCA did. That's what ARCA did. I do wonder, remember the structure of his presentation. Doesn't he get to address ARCA's opinions, their first set of opinions in his direct? And then ARCA will testify to their first and second set of opinions. And then he gets to come back for his limited rebuttal of the second opinions. That's kind of how I remembered Judge Bev laying out how that's going to work with these late reports going back and forth and so forth. So if that's the case, then we should still expect, as part of his direct examination, that we would hear about his reaction to ARCA's testing, because ARCA did look at what it takes to break that headlight or that tail light, the kind of forces involved and how that would be produced by different scenarios. So I would expect him to address that. And if he doesn't address it, again, I'm going to want to know why. Is it because he doesn't have an answer for it? It's easy to just stand there with paint and be like, look, these are the same height. These are the same height is quite a ways from, this is a feasible injury mechanism. At this impact, shattered this tail light, caused these scratches, didn't result in any body fluid transfer onto the pieces of tail light, didn't result in any tail light being embedded in John's wounds, nothing like that. I mean, I would buy that, yeah, a high impact crash with things breaking would scratch you and would scratch you pretty deeply. But I'm not seeing this. I'm not seeing this weird linear straight arm pattern being real consistent with that busted tail light. So yeah, I don't know. I don't know what to make of this. I mean, no, none of this really makes sense. But perhaps that's almost part of the point. You know, if it made too much sense, you might get the wrong conclusion. Rotorman Dan, Welcher is the most overpaid crisis actor of all times. What is his hourly? Did anybody happen to catch what his hourly is? I'm sure it's been out there. I feel like we've seen it. I want to say, is it like 500 and something? Maybe more. 5 something an hour. I don't know. It's a pretty good rate of pay. Josh H., his scientific methodology is off. He began with a conclusion and worked to make his report fit that conclusion. That's definitely what it sounds like. And he really almost did seem to say the quiet part out loud a few times. You know, we were trying to make it fit. Yeah, we know you're trying to make it fit. You're not supposed to say that. You're supposed to say, we just followed where the data led us. And this was the inevitable conclusion of following the data. But sometimes when you're a little too honest, Things just come out naturally. You say it the way that you probably didn't mean to, and you acknowledge we were trying to make it fit. Law and Order. That whole John Carr line was just a show, a 3D model with a broken tail light, so it looks like it had it beforehand. I don't know what the point of those scans were. I mean, yes, I understand. Okay, we did this whole photogrammatic analysis. I'm just so skeptical of it. I'm so skeptical of that. They didn't look like very good scans. I mean, okay, you're telling me they're good scans, but why do they look like they still have the snow on them? I don't know. From one Adam, in the last trial, defense expert showed Karen pulling away after striking John's car with a small piece of tail light missing. I kind of vaguely remember this, that this was, they took a look at the One Meadows Ave, the ring footage, and like they had an interpretation of the ring footage. The problem is that I'm not sure any of it really matches. If we go with like what Be in Trouble 31 has shown us, the tail light does, how it works. It's LED. It's got this diffuser that moves the light through. It's colored light. It's not white light, et cetera, all of that stuff. Then I'm not sure that this really works to show a piece of the tail light missing, because I don't think you would see it. I don't think you would see it when I busted my tail light. It's really just the outer housing. It's kind of similar to this. The actual light itself, it's not affected whatsoever. The tail light still functions perfectly fine. It just has this big round, like clear cover on the outside of the piece of the tail light, and that's what's broken. But all of the underlying stuff still works completely normally. So I wouldn't expect you to be able to see it on a camera or anything like that, especially not at night, because it's just showing the tail light working the way that the tail light works. And there's nothing in the housing that would that would change that appearance. So I'm not sure that you would even see a hole in her tail light if she hit it at One Meadows and busted that one small part. We'll see what they do this time. Truth be told, if this expert and Trooper Paul are so different, how is that in itself being a reasonable doubt? I do wonder if the defense is going to have the leeway to cross-examine about Trooper Paul and his analysis, because they should. They should get the opportunity to point out this is what the theory was by the Massachusetts State Police reconstructionist. And he was the witness in the prior proceeding, and he presented this theory. And now it's quite a bit different, isn't it? The spoiler hit him in the eyelid versus he pirouetted and the crime scene spoke to me. It's fairly different. Trooper Paul had to explain it as a sort of side projection. I mean, he couldn't really explain it, so he would say sort of a lot. It was like, why did it happen that way? Well, because it just did. But he's not saying, oh, John rotated and then stumbled a few feet before falling and hitting his head. By the way, I mean, not that you can't stumble backwards and hit your head. I don't know. I'm going to have a hard time visualizing this. I really am. Maybe Arca will help us. Maybe Arca will help us. Save us, Arca. Give us something we can hang our hats on in terms of trying to picture all this. But yeah, they should. I mean, it's not Judge Bev's right to give them cross-examination or not. Okay, her saying, Mr. Alessi, you'll get your I don't even remember what she said, full cross-examination. He gets that anyway. That's not up to you. He gets that anyway. So it's not hers to dispense or withhold as she sees fit. But we know that's not how she sees it. So maybe Maybe she'll keep that off limits. I don't know. To me, that should be totally, it's well within the realm of what's allowed. He was a previous witness in the case. He presented a theory. Other investigators relied on it. This was the theory that they worked with for, months, if not years, leading up to the trial. This is the theory they presented to Scorty Bello. The change from that theory, yeah, that should be something that they can cross-examine on. But this is Bev's court, so I don't know if she's going to allow it. Pork Chop Express, 355. Even at 2, I think this is miles per hour, the bumper hits his knee, his elbow hits his side hard enough to cause bruising, but John O'Keefe had no bruises. That's a good point. We got to think about how the elbow is going to interact with the rest of his body too. If he's holding his cup, right there by his side, then yeah, there's going to be impact into his body. If he's holding his arm out stretched, then perhaps not. But then you're not getting that same, you're at a different height, right? You're at shoulder height instead of down where the tail light is. So your blue paint's not going to be in the right place if you're holding your arm straight out. So it's got to be at that bent angle. That bent angle is going to put it next to your rib cage. I don't know how you work around that. It's a good observation. His elbow would be slammed into his body. You'd expect at least a little bruise or something like that, but nothing. Audrey Sova, the scientific method is attempting to disprove something. Thank you. Yeah, I agree. This is the antithesis of science. Oh, right. It's not. It's engineering your testimony to a reasonable degree of engineering certainty. I know I'm not the only one who cringed every time they said that. Like that has any meaning at all. A reasonable degree of engineering certainty. What the hell does that even mean? It doesn't mean anything. It's just these magic words that in Judge Bev's court, we invoke these words and it means something. It means we get to say what we think. To a reasonable degree of engineering certainty. If I was just randomly kind of evaluating what would give me engineering certainty, it would be, for example, I want to know what sort of load this bridge will hold and how it will break if that load is exceeded. Where are the weak points? Where's the stress going to show up? And so what I would do is I would design the bridge and then I would test it to the different loads and then I would observe and I'd look and see. And if I wanted to be really certain, I might test a lot of different bridge designs. I might test a lot of different ways that this load could be delivered. A load that's coming in a moving car going across the bridge is going to be different from a load that's coming like from a seismic force from the earth, which is going to be different from a load if like a plane falls out of the sky on the bridge. These are all going to be different ways of delivering that load. So I might look at all of those as well. And once I've kind of examined that universe and sort of ruled out what's not going to cause the bridge to collapse, then I'm going to feel like I have a little bit more certainty about what would make the bridge collapse. But is that absolute? No, you can't test the entire universe of things. You can't rule in the entire universe of things. It's just not, it's not practical. It's not realistic. So I don't even know what engineering certainty is supposed to be. It's just, it's a ridiculous idea to begin with, but you're 100% right. Science starts with skepticism. It starts with skepticism. And so you develop your hypothesis, and then what do? You try to falsify it. Try to disprove it. If I prove my hypothesis is true, that doesn't mean that my hypothesis is always true, that my hypothesis is true under any and all circumstances. It just means it was true in this case. He didn't take into account for the 5 inches of curb, which made all this flawed and off. I don't know where the curb comes in either. I mean, he's trying to build himself in so much wiggle room with the uncertainty. We don't know where John was standing. We don't know what position he was in. Yeah, we know. And that's the problem, because it's kind of your job to know. It was your job to preserve the evidence in such a state that we'd be able to recreate it after the fact. And you didn't do that. And not having done that, I feel like it's at least your job to show me just one, just one. Just show me one way that this happened, could have happened. We don't have to say it's actually the way it happened, but just show me one that leads to this result that's consistent with all this data. And the problem is, I don't think they can. That's why they're not doing that, because they can't. How do you get to going forward 34 feet and then backing up an additional 20 feet beyond that, still accelerating, and we're not even sure if we've hit John yet? Where's John? Just give me like one scenario where this works and you have this collision and John ends up where he ends up and we end up with the broken tail light and nobody hears anything and all of this stuff fits the data. Just give me one. I don't care if it's not the one, just any. And they won't offer that. They'll just say, oh, there's lots of different possibilities and parameters, and the details are significant. Yeah, we know. We know the details are significant. Brent Mack, Andrea, serious question. How do you say in legalese? You got to be shitting me, right? In the form of a proper question. I have, true story. I have heard a lawyer. Ask a witness, sir, how dumb do you think we are? I've heard that actual question. Of course, it was objected to, but I didn't necessarily think it was improper. I don't really think that's improper. It's an open-ended question. How dumb do you think we are? If you think we're not dumb at all, you can just say that. I think you're very intelligent. You know, it's a way an expert could play that back and make you look bad for asking a question like that. Yeah, this is one where you just it's better to show. Don't say. You don't tell. Show. Walk the jury through the incomprehensibility and allow them to see it for themselves, and they will be far more persuaded by having reached that conclusion on their own than by having you try to direct them to reach it. Mike Scott, does the fact it was actually him in the paint arm demo suggest it had to be him rather than him have to direct a junior to contrive the right result? I don't know why it's him. If it's main character syndrome, it's just a coincidence. He happens to be the right height. We don't know if he's the same build. I mean, people can have very different builds even at the same height. So we have no idea how he actually corresponds to John, but for purposes of the paint test, I don't know that the finger paint's really gonna matter a whole lot with some of these details. I don't know if it had to be him to make it work, or if some other random 6 foot plus 200 some pound person would work just fine. I would be willing to bet that if you got a nice cross section of, say, a sample of like 300 6'1" men who weigh 215 pounds, in that ballpark, I bet you'd find at least a few that if they hold their elbow like that, it's not going to match up with the paint. I would definitely bet that. There's enough difference in build. How long are your legs? How long is your torso? How long are your arms? It's a lot of different variables. Sowing chaos. Welcher's BS was in mechanical engineering. His MA and PhD were in biomedical. So why does he keep referring to biomechanics in his testimony? I don't know what qualifies someone as a biomechanical engineer. I mean, I assume that like most types of engineering, there's a certification or a license or something like that that you get. You may or may not have to sit for a test to qualify for it. I just assume. I don't know for sure. I mean, I guess if that's the case and he's able to pass the test, then he gets to call himself a biomechanical engineer, and it doesn't matter what his educational history was to get him to that. But it just stood out to me that yeah, his education is in biomedical engineering. That's not at all what we're talking about here. That's, you know, making devices, making insulin pumps and yeah, stents and new ways to deliver stents and all of that type of thing. So I don't have a good answer for you on this one. I got to assume that whatever the qualifications are to be a biomechanical engineer, he meets them, whether his degree is quite online with that or not. Jack Reynolds, the slide headers or titles said evidence Karen Reed hit John O'Keefe. Is that what they went through and had to redact? I didn't see that. You know, these slides, like I said, are kind of, they're like a crazy quilt, you know, it's just this patchwork of stuff. It's so busy like trying to see all this on the slide. This is one of the tells that your slide is really bad is when you have to, you know, sit and scrutinize it to get the information out of it. Slides are supposed to simplify things. They're not supposed to throw like big walls of text here and here and here and here and make you put all of that together. So anyway, too much to pay attention to on the slides. I did not see that, but I would buy it. If that is something that needs to be redacted. Mike Scott, like the Lexus, does he get to keep this dummy? I don't want to know what he's doing with the dummy. Keep the paint away from whatever you're doing with the dummy. J-Man, why new camera? Any adjustment to height for weight for 200-pound guys and cargo versus 95-pound lady, tire type, pressure, cold stiffens, suspension, resistance, etc. Very good points. Nothing that we heard about. The new camera, we just had a little, I forget if it was Jen McCabe's testimony or Peggy O'Keefe's testimony where they talked about replacing the Ring camera and how they went and called the prosecutor's office to make sure that that was going to be okay. And they were told it was. So they replaced the camera. And I guess it's at a slightly different location. So that's the only answer I have for that. But as far as the rest of these, I mean, no, we didn't hear anything about that. I don't know if any of these would make a difference, but you know, good point about especially the cold. The cold will affect the tire pressure. The sudden change in temperature will affect the tire pressure. You know, you get the seasonal change and your sensor goes off. You got to go and put more air in your tires every time the season changes. The suspension, yeah, good point too. Doesn't sound like they took any of that into account. I don't know enough about it to know if that's enough to make a difference or not, but seems like it would be good to at least rule out that being a possible issue. Canoni Rucourt, did he show us if he got bruises from his test? No, you know what? He didn't. He didn't show us, but of course his test is at 2 miles an hour. So I don't know that we're necessarily expecting the kind of bruising that we'd expect from the collision they're attributing with John. Hooby. The lacerations are all parallel from top to lower arm. If John O'Keefe's arm was bent at the alleged single impact, the lacerations would be at an angle. No, Hooby, we got great minds. That's why I pulled that photo up. I had to screenshot that while we're watching it. I'm like, I'm not the only one who sees that these arms are at completely different angles. This one is completely straight and this one is bent. And so if you take this straight arm and you bend it and now you create the tail light pattern on it, it's going to look differently than it does on John's arm. because those scratches on the forearm are going to be perpendicular to the scratches on the upper arm because the forearm is perpendicular to the upper arm. Great minds. We both saw that and thought the same thing. There's no way that that shows that the taillight is consistent with the, orientation and geometry of John's injuries. What a ridiculous thing to say. Greg, I'm feeling really good about my he didn't write this report theory. This is incredibly confused and disorganized. It's a mess. It's a mess. Alessi tried to fix this before trial. It didn't get fixed. So here we are taking the jury out, wasting their time, trying to deal on the fly with having to redact stuff that should have been redacted over a month ago, a couple of months ago. Said it was going to be, and then wasn't. They've been on notice since before trial that this was going to be an issue, and they never fixed it. And here we are. And how's Bev? Oh, she's just amused by all of this, giggling away. It's just the funniest thing ever. How the jury is having to wait for them to sort out their shit that they should have sorted out months ago when it was first brought to their attention. I don't know that I've ever seen somebody having such a hard time just following their report, identifying what's in their report where, particularly after they've supposedly gone over it twice since Sunday. I don't know. It was real unclear, the whole timing of all that. Met with Brennan on Sunday to go over his presentation in full, then went over it in full. Yeah, you said that twice. Is there some other meeting in there you don't want to account for? Not sure what all that's about. But for having gone through this presentation twice, according to you, you really seem pretty unfamiliar with it. Whatever, clever. Recollision stats. You need to correct for difference between forward versus reversing accidents. Must consider majority victims of reversing accidents are young children. Also a very good point. Hadn't thought about that. But yes, I would expect there to be differences like with the accident, the injury pattern and so forth. What do you expect? I would think it would be different from a reverse than a forward. Some of it's going to have things in common, but one of the things that happens super often with the front impact is because you have the hood, and so the people end up on the hood and potentially going over the car. You don't have that with a backing up because you don't have the same structure. You just have, the whole back of the vehicle. So you got different implications with how people move because of that. But this is a very good point too about the kids. I really hadn't thought about that, but I think you're absolutely right. That's why they have the backup cameras and the alarms and the sensors and stuff like that. You can't see the kids in the rear view. So they're running around the back playing with their stuff while you're getting out of the driveway. That's why we invented all these safety features in the first place. Very easy to not see the kid, not see the dog, stuff like that. Sandra, Mark Betterow thinks Karen Reed's team should call ARCA first to showcase the difference between the experts' thoughts. Not a bad idea. Not a bad idea. They want to start off with a bang. And so if their bang is there was no collision, this makes a lot of sense. Start with your strongest case that there was no collision. And that's with your accident reconstruction experts. And then you can move on to the rest of the supporting data, the dog bite, the lack of hypothermia, et cetera, et cetera. All of those pieces that show that none of this unfolded the way the Commonwealth says it did, but let's just start with no collision. So it fits with the structure of their case. I definitely like the contrast. I mean, the crash daddies are just impressive. They're very impressive. Dr. Rentschler is a little bit more of a dude himself. You can picture him at home in the bathrobe with a white Russian. At least I can. But Dr. Wolf, no, Dr. Wolf is extremely professional. He's got that great voice. He's got a voice that's like made to be a baseball announcer or something. Wonderful, wonderful deep voice. Great for the courtroom. And just very articulate, clear, good communicators. I like this idea. I think it makes a lot of sense. Mike Scott, Andrea Burkhart, his blue arm stunt proved just that impact makes an impact at 2 miles an hour, but also suggests at 24 miles an hour, he'd be covered in blue and run over. If that's all that it took to get that little bit of transfer, that little bit of blue onto the arm, then yeah, it does suggest that at 12 times that speed, you might be looking at more of a splatter type of impact than just a light transfer of paint, a little lean and roll, step off to the side. Nick Starrow, Welcher put 20 to 30 grand in simulations and 3D imaging, at least, to say the Lexus Traverse bump didn't crack the taillight, and then $50 in clothes and paint to reconstruct the collision. Yeah, good point. Good point. I mean, that might have been some very fancy high-tech finger paint. You know, I can't speak to the quality of the finger paint, especially a good blue. Okay, good blue pigments can be very, very expensive. A good blue pigment can be very expensive. Can't speak to the quality of his finger paint, but just give me one scenario. That's all I ask. Just one scenario where you can run it and be like, this is one way it could have happened. Not saying this is the way, but just it works. We modeled it. It shows. Here's where everybody was. Here's the point of impact. Here's where they ended up. Here's how we got the injuries. That's it. Just one. Not seeing anything like that. They certainly seem to have the capability to do that, right? They could do it with a 3-point turn. They can recreate a 3-point turn, but not a collision. Johnny Clark. This is the Commonwealth coup de grace. It is blue paint demonstration at 2 miles an hour, guys. This is the grand finale. This is the final board in the pyrotechnics display of the Commonwealth's case. This is it. Blue paint demonstration at 2 miles an hour. This woman is on trial for murder. What are we even doing here, FKR? Making stuff up to see if it fits. It's just a puzzle. Can we make it fit? That's always one of the things that amused me, especially like the physical match testimony and stuff like that. Just puzzle in general. It's not that hard to like get the wrong piece to fit in the puzzle. Doesn't that happen a lot? You find a piece and you're like, I don't think it's the right piece, but it fits. Maybe it doesn't fit exactly like you think it would fit, but it fits. But like the pattern doesn't look right. I don't know. Puzzles often don't fit. Adriana B. Custom Furniture and Home Decor. I find it sleazy that Brennan mentioned him going to the car immediately. He only said that because Dr. Wolf didn't go to the car. He didn't have to. I didn't even think about that distinction. But you could be right. You could be right. He went to the car because it was a very important thing to do. He went to the car because he was able to bill for going to the car. You know, that was a very big bill for that September 23rd, 2024 visit and all those scans. I mean, that's what really got things rolling for Aperture in this case. ARCA didn't need to do that. Perhaps they will explain why that was not necessary and why it added nothing. Why it was a cost that the taxpayers of Norfolk County didn't necessarily need to bear to get a theory about what happened to John O'Keefe. Sandy B. How much force does it take to hit an arm and not break it, but shatter the tail light? They didn't do this test, must have not wanted to damage the exemplar. You wouldn't even have to use the exemplar, right? To just purely test forces. You just need taillights, and you need ways to be able to move taillights in measured ways, controlled, measured ways. I would think you can test, if not just calculate based on what you already know about the qualities of these materials, what kind of force it would take to break it, to shatter it. You'd have, I would think, at least a ballpark just from the nature of the material itself. And then if you still have questions, you can test it. You put it in like an arm thing, and the arm will move it and generate different forces. Just a thought. No, it doesn't seem like they did any kind of testing like that. At least not that we've heard of so far. The whole accounting for breaking the taillight is a big piece of the puzzle. How do you break the taillight and not so much as bruise your arm? That's a difficult square to circle for me. So if they just leave that out there and don't address it at all, that's a big tell, because there's no answer at all. They're not even going to try. Guess we'll have to see. Michelle, I think the Commonwealth theory is misogynistic. Only an overcompensating man would think a girlfriend with no violent history got so enraged at her perfect cop boyfriend she ran over him when dropping him off. That's what I was saying before when I said they're trying this case on the trope of don't stick your dick in crazy. That's really the trope that's driving the case. That's what they want you to think about Karen Reed. Oh, she's just a nut job. You know how these girls are sometimes. And so, yeah, she got so mad that she was going to be dumped, right? It's not even she got mad because of how he treated her. He left her in the car. No, literally, she's getting dumped. That's the trope. Okay, she's so upset that she's going to lose this man that she's just going to go off the deep end and go into a murderous rage. And I'm supposed to believe that the Commonwealth is not the one with the misogynistic theory here. I mean, of course they are. That's been kind of self-evident from the beginning. Oh, she's a nut job. It's, Proctor told us in his own words what their theory is. So yes, I agree with you. I think it is a misogynistic theory. It's relying on this don't stick your dick in crazy trope. Hap, with all Commonwealth money, why hasn't anyone put a life mannequin in different poses and backed an SUV into it at 24 miles an hour to show what could happen to a body? They had a whole crash test dummy right there. They had a whole crash test dummy right there to be able to drop him on the ground and see what happens to his head. And you're telling me you can't take this crash test dummy out and like hang him from a hanger, prop him up somehow, have a car come by and hit him, back into him and see what happens? You can't do that? It seems kind of hard to believe. You got like most of what you need right there, right? You got a car and you got a crash dummy. I would also like to know why nobody seems to have like live tested this theory of how this happened. No idea. T. Shaw, why did Welcher have the outside light painted? That part didn't break. He painted it around the corner. So the tail light, that piece of the tail light around the corner, except for like a triangular wedge at the top, is the part that did not break. So most of it did break, but some of it did not. So that's, I mean, I think he did paint over onto the part that was not broken. Don't know how material that is to his point that he can hold his arm at the right level for the paint to transfer. Congratulations. Good job. You really got your arm in the right spot there. Sarah Berger, I think they bled him intravenously through those 2 holes in his hands to use blood for scene and to put on car with whatever scenario they had. That's a wild theory. That's a wild theory. I don't know that I'm there. I don't know that I'm there, but I'm just very intrigued by it. I really am. No idea what those, because they don't really look like like needle wounds either, do they? They're too small and they're like not at the right angle. I don't know. Law and Order. He modeled the fall dummy onto a concrete floor. Yeah, he did. They can model things when it's easy, I guess. But modeling the question that's really the only one anybody wants an answer to. Nobody needs an answer to the question of, can you hurt your head real bad if you fall backwards and hit it? Nobody needs an answer to that question. We all know that. That is like the prototypical, we don't need an expert for this. The jury can use their own common sense. Not helpful. Don't need an expert to be able to communicate that. But when it comes to what we actually want to know, how would an accident like the one that you're describing produce these kinds of injuries like we saw on John and lead to the scene conditions that were observed and documented? Model that? No, not that. Kristen Pino, if John's eye was hit by the spoiler, wouldn't the bill of his hat hit first and come off? Hey, great question. Where's his hat? Where's his hat in all this? The spoiler just happens to hit his eye, but not his hat. It's just at exactly the right angle to hit his eye and not his hat. No, I'm sorry. Your head is still going to be moving too. Yeah, your hat's going to hit the car. This is a great point. I don't see your baseball hat staying on through all of this. And if it came off then your hat's going to be in the street. Not that we have a real clear image of where his hat ended up in the first place, of course, because we don't have like wide angle photos that show us in relation to other things at the scene. All we have are just close-ups of a hat and some snow and some grass. It's somewhere over there. AP, it's a hitch support rail, so the rear tub doesn't get ripped apart when someone doesn't listen to the tongue weight or max toe weight. To clarify, thank you for that. Actually, I really appreciate you sharing that. So that's what that steel bar is that we saw behind John's bumper. Again, you explain it, makes perfect sense. People disregard the weight limits and stuff all the time. Get themselves in all kinds of trouble towing things that their vehicles are not rated to be able to pull. So that makes a lot of sense. It's just a reinforcement for that rear structure. And so therefore, if you decide, hey, I'm going to go ahead and haul this 20,000 pound loaded RV or something like that, but it doesn't actually tear the whole back end off of your car. Now you'll destroy your transmission, destroy a lot of other parts of the car trying to tow that, but not the structural integrity. Makes a lot of sense. Thanks for clarifying that. Michigan Farm Boy, Welcher didn't give a variance range when asked about the time difference between 3-point turn and backup event. Just 8 minutes, 5 seconds. Why the variance when doing clock adjustment if you know that to an engineering certainty? You know, the way he described some of this, it almost sounded like he was confused about what the variance was, because on the one hand, we know that there are different clocks that have to be aligned. And so we need to find the common point to sync them to. That part makes sense. But then he was describing the variance as like within the clock itself. And I don't know where he was getting that from or what that was about. I really don't. I got the approximately 8 minutes and 5 seconds. Approximately 8 minutes and 5 seconds. So what's the variance? Again, good question. I think part of the problem is we haven't been told enough about these trigger events and how they get registered and then recorded to have a sense of what that variance would be. If it's the same clock, then it's not a problem with variance in between clocks. The problem is with variance between when is the measurement taken? Like what is actually being measured? What point in time? And then when is that being captured by the data? So is it being captured instantaneously or is it taking a minute to register? That's where I would expect there would be variance in a single clock like this. The variance probably isn't even the right word for that. It's just imprecision. Your measurement is imprecise. No, he didn't. And so I don't really know what he was talking about. If he was just confused about what the variance was about that he was adjusting for. I don't know. I don't know how the jury was supposed to make sense of all that. Two Truth for Liberty, live day 18, Bev corrupt plotting ex parte communication, 70439 and 70517, signals to HB via O, object sign, hand sign to cheek, stern look until HB objects. This is the video clip that we've seen before. I've seen it. I don't necessarily see signaling. You know, I understand that people see that. I understand even why you would interpret it that way. I don't particularly agree with it. To me, it just looks like they have a little inside joke. They have a little inside joke, and it's probably not appropriate for during the trial to be, giggling about your little inside joke you have with one of the parties, and, how you guys are on the same page about how things are going to go and what the problems are going to be, and so on and so forth. But it doesn't look to me like nefarious, like we're planning out, we have a Morse code or something like that, to send signals back and forth. I really don't think they're doing that, but I do think that, yeah, it shows that they have some kind of nonverbal communication, even if it's just, what's going to happen and I know what's going to happen. And it's funny that we both know that, she's very gleeful and giggly about that whole thing. It's not wrong, really, for that kind of thing to happen. Some of it is normal, but to demonstrate that like that in a trial setting, particularly with one party over the other, it's just not a good look. It's not a good look. Bev sitting on the scales. I fell, hopped my head off a rock just above my left eyebrow, had a massive shiner and still have the scar. The bruise took up a quarter of my face. Dang, you got your bell rung. you took a hard shot. Oh, yeah, I mean, I buy that people have different resistance to bruising. I'm one of those people. You just breathe on me too hard and I'll bruise. I always have bruises on me. I don't know where I got them. It just takes so little for me to get a bruise, and I don't register a lot of things like, accidentally kick something or whatever. I don't know. Yeah, I probably accidentally kick things more than I should acknowledge, I guess. Come around the corner too sharp and there's something there and you whack your leg on it. I mean, whatever. I do that kind of thing all the time. Probably doesn't speak well for my my proprioception, but I don't know. I think I'm a little clueless sometimes when it comes to my surroundings. But anyway, I totally buy. People have different resistance to bruising. I still have a very hard time imagining an Iron Man type of physiology where you're getting hit by a 6,000-pound vehicle going somewhere between 13 and 24 miles an hour on the eyelid, and you have not so much as a bruise. I have a very hard time buying that. And after they've gone to all this trouble to explain the eye injuries as ecchymosis, that's part of the strange thing too. No, and it's all from the skull fracture. I mean, you could at least muddy the water. Hold the door open that maybe some of it is due to impact. Because I'm not buying that he got hit on the eyelid by this car and didn't get a bruise. Very hard to believe. Raina, it just dawned on me, maybe I missed it, but in either trial, was there any testimony about John O'Keefe's shirt being ripped or torn? We had the testimony about the holes in his sleeves, in his right sleeve in both trials, but I believe that's all. Everything else on the clothing, the testimony was the damage was from the EMTs cutting the clothing off of him. So, it's got cuts on it. That they identified, but I don't believe there was any other damage No like tears or anything like that that were identified with John's clothes. Just the holes in the arm of the sweatshirt. A cool breeze. Thanks, Andrea, for clarifying that the prosecution is insulting common sense and the public's intelligence with data and facts. We've reached the culmination of the gaslighting, haven't we? That this is the facts, science, and data. He said it explicitly. He laid it out for us in that argument to the judge. These are the facts, science, and data, guys. The blue paint, the Smurf recreation. That's the facts, science, and data that supports the Commonwealth's case. So we tend to be pretty gaslight resistant here. So if you don't feel like being gaslit by the Commonwealth, you found your place. We're not real down with that either. Z, you say incompetence proven is better than framing. Is it based on what this jury is told or everything? Proctor lead Walsh case, same time and followed standard protocol. I'm really just looking at what is going to work in this particular trial. So given what information is available to this jury, what are they going to know and what are they going to think about this? It's always been a harder sell. I mean, it's going to be in any case a harder sell to prove there was an actual frame job than it's going to be to prove that there is no possibility of a frame job. Like that's always going to be harder to prove the negative. It didn't happen. And so by switching that framework to, we're not necessarily saying it did, but we are saying you didn't rule it out. That's the defense taking advantage of that structural position that they have, that advantage that they get by not having the burden of proof and not assuming one. So we don't have to assert that framing happened, but we can certainly assert it was possible. And that if you had just behaved a little bit differently, we wouldn't even have to have any question about whether it was possible or not. Because all you needed to do, just properly handle this evidence, properly document it. Maintain your chain of custody. It's really all you had to do to rule out a frame job, and you didn't do that. So that means we can't rule it out. That means it's a possibility. And if it's a possibility, that's a reasonable doubt. So that's where I think the defense is going with it. They're not going to be able to bring up Walsh or anything like that, outside stuff. So just in the context of this case and how they're presenting it. Brian McNeil, I would like to publicly apologize to Grayspace because I was wrong. I'm sorry. Well, thank you for being a big person and stepping up to say you're sorry. That is always a difficult thing to do, to say I was wrong and I apologize. So kudos to you for doing that. I don't know what you were wrong about, but I trust you and Grayspace have that worked out between yourselves. Z, Olivia Lambo, MSP delete Karen Reed's GPS location data April 2022. Okay, I'll have to go double check Olivia. I'm sure she's got a post on that. Yeah, I'll have to follow that up some later point. Yeah, see, I don't remember this. I'm definitely not saying it's wrong. I just think this might have, it might have been information that emerged far enough before the first trial that I never picked up on it, or it never registered with me. So I'll look into that. But if anybody knows, of course it's going to be Olivia Lambo. She knows everything. Texas sister too, but he still has no broken bones or bruises. Not a one. Not a one. Just that one on the back of his hand. Don't think that's going to work as a point of contact. Claude Simeon, to a reasonable degree of aesthetic and intellectual certainty, you are beautiful and incisive, even better than the beer I'm currently drinking. Well, let's not go crazy. Let's not go crazy. There are some ways of looking at the world that tend to regard the female as a certain punishment, shall we say, for male errors, whereas beer is nothing but proof that God loves us, right? Well, that is a very kind comment and I appreciate it, but don't underrate your beer. Josh H., if Karen Reed backed up 87 feet, why didn't she hit Higgins's Jeep? She backed up 54 after going forward 30. So she ended up 20 feet behind where she started. Where's Higgins's Jeep fit into all that? No idea. No idea. I don't even know at this point if we're still putting Higgins's Jeep there. Jen put it there, but she didn't seem real married to it. It didn't seem like that big of a deal. Didn't seem like a huge point. Then, of course, when Heather Maxson and Ryan Nagel came and testified, they didn't say anything about seeing the Jeep there. So I don't know if the Jeep is even still there or not. But if the Jeep is there, yeah, exactly. Especially she's still accelerating when this is happening. That's his testimony. It comes to an end. Okay. She's backed up 20 feet and it's come to an end, but she's still accelerating. So she hasn't stopped. She's not done moving back yet. I don't know how she would miss the Jeep if the Jeep is out there. J-Man, need a cop for experiment. Even if drunk hard to imagine cop getting hit by a car, they work in traffic, trained for 24/7 hyper situational awareness. Yeah, I don't know about that. Possible that a cop training would give them a different sort of, just awareness of like peripheral, what's going on, more being not that they have like better peripheral vision or anything like that than normal people, but just more paying more attention to it, that type of thing, watching your back, being a little bit more hyper alert to threats. I could see something like that. I do think the drunkenness would probably tend to mitigate that quite a bit. I mean, drunkenness is just going to slow down your reactions no matter what. So this is an intriguing idea, but I'm not sure that there's any way they could really validate that or really run that. Well, that was a painful day back from our vacation. Oh, thank God that's almost done. We get an extra hour tomorrow? Man. Every once in a while I get all pissed at Bev and then she comes out of nowhere and makes me not be mad at her. You gotta get an extra hour of sleep. What are you even doing here? I'm not gonna argue. Yeah, we're definitely not a chance of getting across today. That wasn't gonna happen. But we'll get there tomorrow. We'll get there tomorrow. So I do hope the expectations for this cross aren't too high. A lot of what Alessi does, I noticed this going back through my notes over this weekend, and just kind of looking at just the different ways that he's handled some of the different witnesses. A lot of what he does is not like big bombshell groundbreaking stuff. It's really very small stuff. But he has a way of presenting it to make it look like these are really significant issues. And an example of that is like with Burgess and the issue with his dates being wrong on his presentation. He had it listed as January 29th to January 30th when it should have been January 28th to January the 29th. The date switching over the midnight hour. And he didn't remember that. He thought that he just had misspoken when he testified. And he was like insisting, no, all these events happened on the 30th. Well, they didn't. But it's like your way of handling that possibly made this a bigger issue than it was, which is simply that there is a typo in your slide. Typo in your slide is really not, it's not a deal breaker. Like they happen. Especially for a guy who's got like, a dozen errors just in his CV. Surely there's going to be some typos in his presentation. But he spent a long time building up to it. He landed it. He had all of his, intonation with his tone and stuff like that. Building it up, getting to that point, deliver it. Seconds matter. Get him to make all these concessions. And then all these events happened on the 29th, not the 30th. And that's not the most substantive point ever, but it just works because of how he does it. And in that particular case, the way that the witness reacted to it, he doubled down on my PowerPoint is correct. Instead of, the typo is just a typo. He doesn't even know the dates, testifying cold. So yeah, I don't want to get my expectations too high for Alessi Cross because, sometimes it is just a lot of stuff that isn't really groundbreaking. It's not bombshell. It's not smoking gun. It's nothing like that. It's a lot of small things that aggregate into an impression that the witness has serious problems. The witness lacks credibility. The witness's methodology is non-existent. The witness got all of these other things wrong. It's much more of a feeling I feel like you get in many ways from the Alessi Cross than the substance really eliciting super damaging stuff. Not to say that doesn't happen from time to time. I mean, gosh, the whole academic dishonesty thing, that was pretty significant to elicit. But I just want to have realistic expectations. I also suspect he will do the same kind of strategy he's done with the other experts so far, which is to anticipate what his own experts are going to say on the stand and their criticisms of his work. And he's going to incorporate that when he's questioning him. Any problems with the information that he relied on to form his opinion, he's going to question him about that. What I'm not sure we're going to get is stuff like, testing he could have done, modeling that he could have done. I don't know. I don't know if he's going to necessarily ask all of those questions that we would like to see asked, but I guess there's no way to know. No way to know, but just show up tomorrow and find out. Desert Quill, weird as it sounds, in my opinion, a woman who is so sexually jealous they're homicidal is a male delusion fantasy. 100 billion% it is. It's the Medea fantasy. That's statistically rare compared to how many women get killed by male partners over jealousy. Men and women abuse each other at approximately equal rates. Men just in general kill more than women do. That's just a tendency to violence. But yeah, I'm totally with you on that. You're not going to have to sell me on this theory that, yeah, there's something perversely intriguing about the idea of a woman who is just so obsessed with you, caught up with you, whatever, that she can't control her emotions. Toxic. Guys, we call that toxic. Don't buy into that fantasy. This is not a good thing, but people love that idea. Women like it too. Everybody has an ego. Everybody loves this idea that, oh my gosh, this person is just so into me that they completely lose all control. They just can't even. It makes you feel powerful. It makes you feel, just valuable and beautiful and wanted and special and extraordinary. You're better than all these other people who don't affect the men like that. Big old ego trip in this delusion here. I can definitely see that. Yeah, that's some gross stuff, but that's a good insight. Well, guys, perhaps we'll get more delusional fantasies tomorrow as we wrap up whatever Mr. Welcher has to say here. I just don't know how well this is going for the Commonwealth. I really don't. If this is it, this is the final pyrotechnics display. Just not sure this is making the impression you might have hoped for. It's not nothing. I mean, if you just sit back and listen and take the comments themselves at face value, and you don't think too much about How did you get here? What was your process? Are your assumptions valid, etc.? Then it might come out as being damaging. Anytime a witness gets on the stand and is going to say, I think there was a fatal collision here, that's going to be damaging. But it's just that's got to last. It's got to be damaging all the way through cross-examination and then all the way through the defense case. That's really what the Commonwealth's case needs to be. It's where they should be by now because they're almost done. They should be so far ahead of the game when it comes to persuading the jury that their version of events is what happened, that we should be like wondering why we're even at trial. That's how good cases are supposed to go. That's how good prosecutions are supposed to look like. Definitely not my impression of what we're dealing with here. So a lot rides on this cross, doesn't it? A lot rides on this cross. If it sticks and they think the guy holds up well, he holds up well, he's got good explanations. We don't really know much about methodology, so it sounds pretty good to us. Certainly looks like he's the right height. That blue paint, it did transfer. It could be that. If that's enough to stick, that's enough to get potentially certain members of the jury maybe tilting one direction more than the other. Maybe think, yeah, it could be, it's possible. And God, we saw that tail light all reconstructed and that they got all that from the yard. It sure does all add up. Looks like Karen did it. But if he bombs on cross, and he looks like an idiot, and he looks like a hack, and he looks like a bot hack, comes out looking like a bot hack and kind of an idiot, then what do they have? What do they even have? So a lot riding on this cross tomorrow. Not that I'm trying to get my expectations up or anything. I want to keep it realistic, but yeah, this is the pinnacle of the case. They're prepared for that. Plus, they just had 5 days. Sit and read this over, think about it, game plan it, strategize it, refine it, all of it. So I'm trying to manage my expectations, but nevertheless, they are still kind of high. So, but hey, the one thing I know I get to look forward to, no matter what, we get an extra hour of sleep tomorrow, guys. That's some exciting stuff. So hey, I will see you bright and early at 6:45 tomorrow. It's almost like a normal time. The sun's going to be up. It's going to be light out. Hardly going to know what to deal with myself in the morning. I might just keep waking up at 4:30 because why not? If I'm going to have to do it again, just have myself a little lazy morning tomorrow. Afix, please consider a dual stream with Kurt, Uncivil Law, one trial day. He praised you as being likely the most knowledgeable person covering the trial. Oh, that's very nice of Kurt to say. I appreciate that kind of commentary. Good kudos. I appreciate it. Kurt's great. I've been on his channel several times. We've gone on and talked about like some of the Supreme Court cases that have gone through and things like that. I probably will not be doing like a joint stream during the trial. It's not what I do. I'm not really used to doing that. I haven't really thought about how would I do it. I probably should, I don't know, maybe have more of a planned approach to this YouTube thing. But the reality is just, I like watching trials and talking about it. And it seems that people like me to do that. So I'm going to keep doing it because it's fun. I'm not really trying to have a business or a job over here. I guarantee you when this trial is done, I'm going to probably disappear for a little bit because I like having a life. And, you sit at the screen for 10 hours and 25 minutes a day. It tends to take away your options for having a life. So anyway, that's all just a little bit of an aside, but I do appreciate Kurt, and I'm sure we will do a joint stream at some point. Again, we have certainly done it before. So but I do appreciate the compliments. And hey, we're getting close to the end. We got lights at the end of the tunnel. Got a lot hanging on this cross tomorrow. We're going to see how that goes. And then I think we got a good chance we're getting into the defense case. So maybe some crash daddies. I don't know. I can't wait to see. I can't wait to see how they put it together. So very exciting stuff. Guys, take care of yourselves. Take care of yourselves. If you've been here for 10 and a half hours with me, it's time to get up. Take a little stroll. Get the blood moving. Have a little snack. If you've been snacking, maybe don't have the snack. Maybe drink some water. You know, just make sure we're looking out for ourselves. It does take a little bit of endurance to get through a multi-week trial, day in, day out, burning the oil, the early mornings and so forth. But it's important to keep ourselves in good working order. So do take care of yourselves, guys. You know, if a little Phillies baseball is the kind of thing that will make your day better, feel free to indulge. You'll have the opportunity. Yeah. I'm a little resentful over the fact that we ended our winning streak. We were on a 9-game winning streak. We're playing the A's, for heaven's sake. Okay. Not the worst team in baseball right now. Not the worst team in baseball right now, but you know, certainly not a real impressive team. Should be real easy to beat up on. And we like bent over backwards trying to lose on Saturday and couldn't quite pull it off. Just had to win at the last minute. But then Sunday finally pulled it off, finally pulled off the loss, managed to lose to the A's in Sacramento. So I'm irritated that, you know, we lost the winning streak, and I have to comfort myself with, you know, I guess we just have the best record in baseball. Okay. Like, I guess that's what we have. Phillies fans are so negative. Like, what is that with the culture? You always got to find something to bitch about. I can't just be happy they're playing really good ball. I'm like total Negadelphian. I'm not sure what's happened to me. Anyway, if that kind of thing makes you feel better, watch some baseball this afternoon. There'll be a game on. So, guys, I appreciate all of you, especially the mods, of course. Always appreciate the mods. Everything you do to keep this channel running smoothly, the chat, the fun and informative place that it is. Really appreciate you so much. All of you that contribute, make it fun. That's why we're doing this. It's fun. It's fun to watch a trial together and bounce ideas off of each other and bring our different frames of reference into understanding what's happening. I really enjoy it a lot. So I'm grateful to all of you for making that happen. It's a very different experience from, you know, being in the courtroom and doing it. You're so alone. You're so alone in that courtroom. But doing it out here, it just gives us just a very different perspective on the process and how it's landing and so forth. So really enjoy all of you making that possible. Guys, get some extra sleep tonight. I'm sure gonna enjoy it. And I will plan to be back bright and early, 6:45 tomorrow. Not quite so bright and early, but you know, it's not nothing, but it's no getting up at 4:30, that's for sure. I will be back bright and early tomorrow. We'll see what this cross brings. And could be really good, could be really bad. We're just going to have to see. It's exciting. It's an important point. So very important stage in the trial. See how it lands. All right, guys, I'm excited. I'm looking forward to it. Be well. Look out for yourselves. And I will see you back here tomorrow. Take care.